Good morning. Everyone looks really nice today, Russ.
Yeah, it's exciting. It's our summit. It's that time of year. Welcome, everybody. Good morning.
Good morning, Daphne. Good morning. Everyone looks really nice today, Russ.
Yeah, it's exciting. It's our summit. It's that time of year. Welcome, everybody. Good morning. I think I'm getting a bit of an echo at my end, Daphne. How about you?
I was also getting an echo. I think I just resolved the issue. Getting all the tech issues out of the way first thing.
Are we doing a summit here? Or are we doing tech check? Which one is it?
Hopefully summit in this Zoom meeting.
Welcome, Aaron. Good to see you.
Hey there. Am I in the right place? I hope.
You are. You are.
Fantastic.
You've got
Okay.
about 10 or 12 minutes before we fire you up at 9:15, but yeah, your first one at
Oh,
bat.
hang on. And I just got an email from Adam. Did you see the updated tech check link?
Oh,
Adam thinks he should be somewhere else, I think.
that's okay. We will get Adam into the right spot.
Yeah.
All right. Hang on. I'm just gonna
Daphne take
buzz
care.
him.
So I think we're live now, Aaron. Just to let you know, you might want to mute.
Well, welcome everyone. It's so lovely to see everyone streaming in. Look at those numbers, huh, Russ?
Yeah, we set a new record up to last time I checked, 590 people registered.
Wow.
So close to 600. Great turnout this year.
That's amazing. And we always get those more, last minute people who, if you're like me and your schedule's insane, you
Yeah.
kind of wait till the last minute to decide if you're going to come or not.
In addition to that, we are live streaming on YouTube. So we're going to welcome everybody on YouTube who are joining us today. What do we need to know about YouTube, Daphne? You're the pro.
Yeah, not much. Welcome to our audience. We are so excited to have you on YouTube today. Um, so there will be some polls throughout the day, so feel free to participate in those. We do have a lot of content on our YouTube channel as well, so feel free to check out our previous videos of previous summit years, educational content, our after hours podcast. There's lots of informational resources on our YouTube channel. So please check it out. And if you're enjoying the summit, please feel free to give the video a thumbs up. We would really appreciate it. And subscribe if you want to see our upcoming videos as well.
And look at this lineup, Michelle. Adam and Aaron are always top billers. Get the top slot for the day. But what else do we have on today?
Oh, we've got some great ones. We've got some financial disclosure for business valuations. I know I will be really anticipatingly looking forward to that because, you get into these complex business valuations or complex financial disclosure issues. And it's so great to have people like Melanie and Jason and Paul give their expertise. They're just a wealth of knowledge.
Yeah, really excited. And power protection and prejudice. What we got up with that one?
Oh, it's a good one. Actually, I'm hosting that one, so I don't want to toot my own horn here. But Sandra and Justice Manahan are just wonderful people, and I can't wait for you to hear Sandra's story. You'll hear a little bit about my story as well. But, family law from a female perspective. It's such an interesting topic because it affects so many of us. So many of family lawyers are female.
And I was reading the bios. Am I correct? One of the presenters, a retired New York state judge.
That's right. That's Justice Manahan, and he just goes by Tom. He's very unassuming, very, very wonderful. In fact, when I first met him, I did not realize he was a retired justice because he was just so calm and kind and down to earth.
Yeah, that's going to be a really interesting one. And we have Jane Hugh, Power, Managing Tough Files, a Compassionate and Strategic Approach. That's an updated title, right, Daphne? But we got the same content, same accreditation.
Yeah, that's correct. So if you were looking for CP practice, 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 this is the same session, just with an updated title.
New
I
and
think we-
improved. People were working on the weekend on this.
I think we updated some of our speaker lineup for that one too. Is that right, Daphne?
We did, yes. So joined with Jane will be Natalie Derbyshire, Cindy Shesvin, and Matthew Krofchick.
Just a dream team. My goodness. Don't want to miss that one. That'll be a great one, especially if you want to learn more about collaborative practice. Actually, we do have training coming up. If people want to get trained, we're going to tell you about that in a moment. But let's get through our schedule. Let's go back to the schedule just for a minute. We've got business skills for lawyer. So everything you wanted to know, but law school didn't teach you. Paulette and the world-renowned Steve Benmore will be presenting on that. I'm excited about that. I'm not even hosting that one, and I want to find out what's going on. What's that all about, Michelle?
Oh, it's going to be great. I'm not going to give you too much of a sneak peek. You're going to have to wait till 3 o'clock. But lots and lots of really great down-to-earth information. Of course, Steve runs his own firm. He's got lots of experience. Paulette's background is just, really wonderful. I can't wait for you to tune in, Russ. It's going to be a good one.
Yeah, Steve's been nominated a number of times for Law Firm of the Year. I know him personally. He's runs a super efficient business through his practice of law. Lawyers don't usually think of practicing law as a business, so I think there'll be lots of gems in this one.
All
All
right.
right.
And at the end, I think this is your session, right? Succession planning. Is there a
You have
reason
to
you're
have
hosting
gray
this, Russ?
hair. You have to have gray hair to attend, or gray blonde hair to attend this session, I think, Michelle. That's the price of admission.
Is that why I wasn't invited, Russ? Come on now.
This is a really important topic. We got an aging bar, young lawyers joining us, but how do you transition out of your practice? What value is there in your practice? So much to think about. And this, I'm not presenting, I'm just going to be learning, but succession planning, from my understanding, it could be 3 to 8 years. Is that right, Michelle? To
Oh,
do it right.
absolutely. If you really wanted to do it properly, and of course, you're one to talk, Russ, but lawyers, we don't retire. We semi-retire. So having that plan, having that business model, having someone to pass the torch on to, doing the things that you like to do and the value you bring to the business, that's a choice every lawyer has to make. And it's never too early to start thinking about the future and to start thinking about what that looks like for you.
And just think post-COVID, a lot of lawyers with this flexibility with Zoom can practice anywhere in the world. We've got people joining us from all across the world. I'm joining us from Italy today. It just shows you the flexibility that you have in terms of how the landscape has changed since COVID.
I know I've joked to you, Russ, that once my kids are a little bit older, you'll be seeing me from Thailand. That's where I'll be. That I know that for sure. It's going to be
So
cool.
what I hear you saying, Michelle, is we're opening an office in Thailand.
Yes, I've said that for years now. You know that. It's on the business model. It's all good.
What city? What city?
Well, we'll have to start in Bangkok, but we'll probably go to Phuket or something in the south. I'm a sucker for my islands and my beaches.
Love it. Love it. And with Starlink, you can work from anywhere. You can be on a
Oh,
boat, on a beach. What a difference.
it's wonderful. But I do want to talk just a few minutes about our Law Society of Ontario accreditation. So,
Yeah.
it's really wonderful. As much as I appreciated and loved learning about this, I also like getting the CPD credits.
Mhm.
It's wonderful. I know my husband is one of them. He's a lawyer, but there are a lot of people who wait till the very last minute to get their CPD. And I really like getting it done early. I like getting lots of it throughout the year. So sessions like these are just amazing because, Daphne, how many credits are we getting for this today as a total?
Yeah, so in total we have 4 CPD credits plus 1 EDI hour as well.
Awesome. That's wonderful. And I'm assuming that's all going to be on the show notes as well in case you forget or in case you miss this.
Yes, absolutely.
Wonderful. Well, there you go, Russ. I'll be looking forward to putting in my credits this afternoon and seeing those go up. I'm kind of like Scrooge McDuck. I like seeing all the credits in there. How many can I do this year?
Yeah, great point. The accreditation, you can see it on the schedule, which ones have which accreditation. So very good information, Michelle. And we have some OGs here today, some return speakers, the best of the best of last year. And we've got some new faces. So if you'd like to participate in next year's summit, just apply. You can send Daphne or Nicole an email. We'll drop in the contact information at the end of the event, but we love to expand our network, make new connections, hear different perspectives on family law and what's happening in our profession. So let's just circle back to the training. We get lots of people asking about CP training. Michelle, do you need to be formally trained, or can you just say I'm a CP lawyer?
Oh no, you've got to get formally trained. It's really important that you understand what you're doing and that you learn from like-minded individuals. It is such a shift. I can tell you. I did my CP training, I don't know, I don't want to date myself, 10 or 12 years ago now. And even still, I find that things are changing and evolving like anything. So getting even a touch up if you've had it done before and you want to join. And what a star roster. I know all of these people individually, professionally and personally, and they are just wonderful. You're going to learn so much from them.
Get a touch up. Sounds like hair and makeup, right? It's really, it does expand your practice.
Mhm.
I found it also makes you a better litigator
Oh,
uh, when you get the training. So it's not just collaborative. You think about your litigation files differently. This year, we're offering it remote. The dates are on the screen. It's starting in October 20th, actually, almost about a month out. We have, I think, a handful of spots, 3 or 4 spots left open. So you can do it from the comfort of your office, your home. They're half-day sessions, so it's not going to interfere with your practice too much. And we have an early bird code of 10% off for people who want to sign up from this conference. So there's a QR code. You have any questions, you can drop it in the chat, and Daphne and Nicole, who's in the background doing the tech, will certainly answer any of those questions. Presenting with, other than myself, a dream team, right? We've got Brian Gilbraith, former president of IACP, Carrie Heinzel. Anybody who works in the Durham or Toronto region knows Carrie to be an excellent family professional. Financial professional. We have Jonathan Painter as a family professional. You've worked with all these people, right, Michelle?
Oh, absolutely. Actually, I'm on a couple boards with these people, so I know
Oh,
they're really wonderful, hardworking. And as you said, exactly that. It's the dream team. It's nice when you have a full team. And as you said, Russ, one of the things that collaborative practice training taught me is that even on my litigation files, sometimes you see the need and you can suggest to your co-counsel, hey,
right.
let's get a family professional in here, or let's get a financial professional in here. These are people who add so much value to this and really cut down the cost. So I'm really excited to hear, for this training. And I know it's going to be great. We always get the best feedback on it.
Yeah. And the language we use is a paradigm shift, right? Like you really do think through the problems differently. Most litigation files that end up on my desk, and my first question I ask, do I need a judge to help me resolve this? Can we pull it into collaborative practice, get it out of the court system? And oftentimes clients have a much more fulfilling and satisfying outcome when they do it collaboratively. So certainly something to look into. Go to the website, kick the tires, take a look at what's being offered. These trainers have been doing it for several years, and collectively, I think they've trained hundreds of lawyers. And there's other training groups out there as well. You can sign up for their programs, but we certainly encourage everybody to consider that. Thank you for we'll provide the slide. We have a session on collaborative practice. We'll throw the slide back up during that, and we'll put it back on at the end of the day. Like Daphne mentioned, there are polls. Please participate. It helps the speakers understand who our audience is, what questions you have. We'll try to incorporate our answers throughout the live event to questions that come in. Daphne, how can people submit a question?
Yeah, so on YouTube today, there is a chat function that you are all welcome to use. It is open to the public, so please keep confidentiality and respect in mind as you engage with the audience and our panel. But feel free to put any questions that you may have for our panelists in that chat, and they will see your questions.
All right, so we're coming up to 9:15. I think, Michelle, thank you for co-hosting today.
Oh, absolutely. My pleasure. I can't wait to see you guys again. I'll be watching. I'll just be in the background.
So you'll see Michelle or myself throughout the day, and we'll come back on at the end of the day, sign off, and express our gratitude to everybody who showed up. What do you think, Daphne? Should we make a start? Case law
Yeah,
update. This is always a big hit.
I know Adam and Aaron are anxiously waiting in that background. They've been here. They're ready and raring to go. All
All
right,
right.
guys. See you soon.
Thanks, Michelle.
Thank you so much to Russ and Michelle for getting us kicked off for the day. The upcoming session is with Erin Franks and Adam Prewer. So they should be online here momentarily. There they are. Welcome. Great to see you both, gentlemen. So the first session of the day is Family Law in 2025, Trends, Case Law Updates, and Legislative Changes with Erin Franks and Adam Prewer. This session has been accredited for 30 minutes of professionalism with the Law Society of Ontario. Today, the panel will discuss an overview of current trends, recent legislative changes, and case law. As always, we encourage you to participate in the polls and use the chat feature throughout the event. And all resources mentioned today will be included in the show notes, which you will receive via email later this week if you have registered. If you have not, they will be in the YouTube description of this video. And I will now introduce the panelists. Aaron is a family lawyer. He is a partner at Epstein Cole LLP. And Adam is a partner at Epstein Cole LLP. He was called to the bar in 2013 after completing his clerkship to the Senior Family Law Justice, the Associate Chief Justice, and the judges of the Ontario Superior Court of Justice. Adam co-authored Unpacking Family Law for Practitioners with Justice M. Kraft. I will now hand things over to Aaron and Adam to get started with our first session of the day.
Which I was involved would be accredited for anything having to do with professionalism. But hey, there's a first time for everything. My apologies. I woke up this morning with a bit of a head cold, so I will try to not huck too much. Adam and I are doing the case law and legislative update, and fortuitously for all of us, there have been some recent legislative updates, very recent legislative updates. So I'll talk about the most recent, and then I will pass it over to Adam, who will talk about some of the other rules updates and things. So the most significant update is that without a whole lot of advance notice or flash or fanfare, the child support guideline tables were updated. They were updated last week. They were just published in the Canada Gazette without any notice that they were coming. And the new tables are in effect as of October 1st. So there's some instant work for family lawyers as the table amounts automatically change in pursuant to the guidelines. Anything that causes a change in table amount is automatically a material change. That said, the numbers actually don't change a terrible amount. Some numbers, some income levels see support go up a bit. Some income levels see support go down a bit. By mandate, the guidelines are supposed to be reviewed and renewed and redone every 5 years. The last time this was done in 2017. So sort of typical government. We're a little bit late, but there they are. And as I say, and not even the calculation services like DivorceMate were told that these were coming out, so they're busily changing all their spreadsheets and all their programs and everything to make it work. Right now, the only way you can find them is actually in the Canada Gazette, or maybe by this point they've now been published. And just when people see them, the first thing they say is, "Well, I don't understand why there haven't been any changes. The cost of living has increased significantly." And you have to remember the guideline changes are not based on cost of living. The changes to the guideline numbers are based solely on income tax changes over the period since the last update. Because if you think about it, cost of living increases increase one's income as well as the cost of living, so both rise in tandem. It's the tax changes that haven't been since the last update that wouldn't have been calculated, and that's why some income levels see support go up, some income levels see support go down, and why some provinces actually see some rather significant changes. Alberta, for example, their numbers have changed because they've gone through some significant tax changes in the last 5 years. Ontario, not so much. So that is sort of the most significant and newest update in terms of legislation. Adam, what else we got?
So Ontario, in the past year or so, is now part of the Hague Convention on the International Recovery of Child Support. So if you are dealing with an international child support case, you've got new forms to fill out, and the family law forms were updated to reflect that. There were some changes in terms of the wording of the how to get a restraining order under the Family Law Act. And in terms of our rules, that is probably where everyone should pay the most attention, because last summer the family law rules were changed. We've got some specific things, including that you are now allowed to sort of ask for money in the event if someone has breached an order to encourage compliance. The rules now explicitly prevent out-of-court or communications with the court that you've not sort of worked out with the other side. So that is now a specific rule under the family law rules. We have seen the incorporation into the rules of binding judicial dispute resolution in the past year. And what is very important is there's been a number of changes about costs in the rules. Specifically, there is now a requirement under the rules that lawyers confer about costs prior to an appearance. It's on the confirmation forms as well. In addition, the cost rules have been changed such that there are now sort of default page limits and timings for cost submissions. So if you do not address this at the end of a motion and it is just in accordance with the rules, you want to pay very careful attention to how much time you have. The time period is sort of pretty limited, and the page limit is very short for written cost submission. So learn to be brief in your cost submissions.
Say two. That's it.
That's I do.
All right. That is all for our legislative updates and all for the French that we'll be using during our presentation today. So Adam and I are going to go back and forth on some cases of note that have sort of arisen over the past year. These are certainly not all the important cases, but they're certainly some of the more interesting cases. And you will be getting I think you've already received a copy of the written material. So if any of these cases sort of pique your interest or sound like they might be of interest to a case that you have ongoing right now, you're welcome to sort of read a little bit more depth. So the first case that I'm going to talk, and Adam and I are just going to go back and forth. The first case I'm going to talk about is a case called Metzke and Metzke from the Ontario Court of Appeal, 2025 ONCA 418. As I say, you'll get the full cites and a brief write-up for each case. And Metzke is a case about proprietary estoppel. One of the estoppels that we don't deal with all that often in family law. But there are of course many estoppels. There's promissory estoppel, issue estoppel, estoppel by conduct. Proprietary estoppel isn't one that we deal with all that often. Now, Metzke involves a family, but it isn't a family case per se, but certainly it's something that family lawyers should know about, because sometimes it can slide in where other doctrines like unjust enrichment don't quite work. So what happened in Metzke is that Martin and Roseanne operated the dairy farm. They've been operating it for quite some time, since the early 90s. They decided to eventually sell their dairy herd and their dairy quota, but to keep sort of the cash crop part of the business. Martin and Roseanne had a son from whom they were estranged, Tim. Tim had a partner, Amanda. And although they were estranged, there were some discussions about perhaps Tim and Amanda coming in and buying the farm, or at least part of the farm business, including the herd and the quota, perhaps not the cash crops. But at that meeting, they hatched a plan. Martin and Roseanne and Tim's partner, Amanda. Tim and Amanda were going to buy the dairy herd. They were then later going to acquire the quota and the land at market value. And the purchase was going to be deferred for at least 5 years because they didn't have the money to purchase it up front. They never actually discussed a firm land price. The number of sort of $2 million for the land and quota was sort of thrown around and sort of used as a placeholder, but certainly no agreement was ever actually reached. And the thoughts of financing were then postponed. In the meantime, Tim and Amanda left their jobs, moved to the farm, and began running the dairy operation while paying rent for the barn, paying rent for the quota, and paying rent for the housing. They eventually bought the herd using a $90,000 bank loan. In 2013, they tried to get financing to buy the quota, but they were unsuccessful, and the financing fell through. Over the next several years, further disputes erupted between the parties. The first was a fight about whether or not Tim or his parents would have to pay for the barn repairs. The second involved criticism by Martin and Roseanne about how Tim was running the herd and herd management. Eventually, things went sideways, as sometimes they do in families. And Tim and Amanda actually even considered going to lease another farm, although nothing ultimately came of it. And that was the end of the discussions. The prices for the quote and the land still remained undetermined. There were no further negotiations. And the court, at first instance, found that Tim and Amanda could not have raised the money they needed in order to buy out the rest of the farm and the quota in any event. Finally, in 2018, after another heated dispute, Roseanne gave Tim and Amanda their marching orders, said, "Get the hell off my property." They complied. They sold the herds that they previously purchased at a loss because they no longer had the quota to support it. Later that year, Tim and Amanda sued Martin and Roseanne for $1.3 million for unjust enrichment. Martin and Roseanne, of course, denied liability and countered for their own lawsuit for some unpaid amounts that were supposed to be paid under their sort of lease agreement. The trial judge dismissed the unjust enrichment claim. He basically found that there had been no enrichment, had been no deprivation. Without enrichment and deprivation, you can't find unjust enrichment. However, the trial judge, upon hearing this, thought, maybe there's something else here, and started to consider ex proprio motu, as we say in Latin, of his own motion. This idea of proprietary estoppel, always a dangerous situation, although here for a judge to sort of raise their own claim, but here it was done right. He raised it. He gave counsel an opportunity to research and make submissions on the matter, and that's exactly what happened. Ultimately, it was determined that there may or may not be a proper claim for proprietary estoppel. Ultimately, the Supreme Court of Canada has the leading case in proprietary estoppel, a case called Copper, Smith and Morgan, which was decided in 2017, that's cited in the paper. The test for proprietary estoppel was set out very clearly by the Court of Appeal in this case: a clear representation or assurance leading to a reasonable expectation of a right or benefit over the property, reasonable reliance on that expectation by action or inaction, and resulting detriment that makes it unfair to the promisor to renege. So your typical sort of equitable estoppel doctrine, where you lead somebody down the garden path, you give them representations, you cause them to rely on it, you cause them to change their positions, and then you change your mind. The assurance can be expressed, it can be applied, it can be clear, it has to be clear, it has to be unambiguous, and it has to be taken seriously. Here, ultimately, the Court of Appeal found there were three flaws in the trial judge's reasoning, who did ultimately find that there was a basis for proprietary estoppel. First of all, there had been no clear representation. At the very most, there had been a willingness to negotiate. The actual payment terms had never been actually set in stone. There was never anything set in writing. Ultimately, an agreement to agree was the most the Court of Appeal found was there. An agreement to agree is not an agreement at all. There was no actual representation, no actual assurance, and simply the quote-unquote negotiations were far too up in the air and far too loose to actually form the basis of any actual estoppel. Secondly, there was no reasonable reliance. Early on in the piece, Tim and Amanda knew they couldn't finance the quota. They knew it. They didn't disclose it. But that's the reason no further talks ensued, because they knew that they actually didn't have the financial backing in order to do it. And finally, there was no actionable detriment. Without any sort of promise to rely on, or any sort of alleged losses, any claims for losses were speculative and nothing else. Ultimately, the Court of Appeal made it very clear that in some cases, Metzke mirrors family law disputes, where handshake deals or wishful thinking are sometimes tried to be bootstrapped into an actual deal. And it's very clear now that if anybody's going to be claiming proprietary estoppel in a family case or not in a family case, you need a clear, concrete promise, you need to show reasonable reliance, and you need an actual proven detriment. So an important case to read, and it's one of those doctrines that is very applicable, as I say, to family cases sometimes. And sometimes when unjust enrichment fails you or resulting trust fails you, it may be the case that either promissory estoppel or proprietary estoppel can come in and fill the gap. Hopefully, however, you think of it on your own before the trial judge surprises you with it.
So I'm going to talk about a case called Wang and He, 2025 ONSC 3072. This is a case that's really useful for two things. First, it is a very effective summation of where we are in terms of what constitutes an urgent motion. And it's also an example of a case that you can cite when the other side is behaving badly. So in this case, Ms. Wang brought an urgent motion, and she was seeking parenting time on an interim basis. She was seeking exclusive possession of the matrimonial home. She was seeking an order that the child live primarily with her. And she expressed a concern that the father, Mr. He, would flee the jurisdiction with the child. This decision, however, was just about whether or not this would be allowed to proceed on an urgent motion. Ms. Wang had what, in terms of her narrative, she claims that she had fled the home because of verbal and mental abuse, but the very young child had been left behind. She argued she was the child's primary caregiver and she'd been breastfeeding the child, and that the father would abscond with him. The father, unsurprisingly, felt very differently. He claimed that there was no reason that she had to leave the home, that he was an adequate caregiver, and that the mother had left the child in his care for days at a time in the past. He argued that the mother was essentially over-exaggerating how much breastfeeding was happening, and he pointed out that the parties had hired a nanny and relied on that nanny so that the mother was not the primary caregiver. It's a very good case in terms of going through the considerations for an urgent motion. Of course, we have the Rosen factors, which were set out in 2005 and have been considered many times in Yale and Scarborough, for example, and then in Thompson and Wobler. Ultimately, what constitutes urgency to supplant the need to have a case conference is a very narrow set of circumstances. In the Tippe case in 2022, the court has described as generally relating to situations involving abduction, threats of harm, or dire financial circumstances. This is also a case that sort of focuses in on the specific requirements, like, you do need to actually have evidence as to when the case conference will be when you are arguing a motion is urgent. Associate Justice Kamal in this case set out, which is a very pithy quote, but high conflict does not equate to urgency. And in this case specifically, there was actually no evidence that the father had any sort of intention to abduct the child. And you want to be very careful when you're in these sorts of cases that you don't over-exaggerate your case, that you stay focused on what you can prove. Because if you make a sort of somewhat wild claim that you cannot back up, you're going to degrade from your entire argument. This is also a great case for dealing with situations where the other side is not following the rules. Counsel for the mother in this case had the judge noted, completely disregarded the consolidated notice to the profession for family and child protection matters in the Ottawa Family Court. So all of the materials exceeded the page limits. And this is a case that you can cite in a factum if you are arguing that the other side has exceeded the page limits. The other side had also, in a real wild choice on their part, they had brought a notice of motion on notice seeking an urgent motion, which they then withdrew because they couldn't have it heard soon enough. So they then brought it on ex parte, the exact same motion on an ex parte basis in order to get it heard sooner. Unsurprisingly, the judge said that that was not okay. There is some very clear direction to counsel in this case about controlling clients, that our opinions and our views of this are supposed to carry weight and credibility with our clients. And the privilege of being counsel comes with responsibility, and that is the responsibility to reduce conflict and maintain the integrity of the system. In a sort of a line that actually makes me extremely anxious, just reading it, something that I'd never want anyone to ever say about me, but the judge said in the final sentence of his ruling, as officers of the court, counsel need to act with integrity. Counsel for the applicant did not do so. You do not want to be in a situation where a judge says that about you. But if you are in a situation where the other side is acting badly around an urgent motion, Wang and He is a case to look at.
Thank you. So as long as we're talking about professional responsibility and professional integrity, that's simply too good a segue. I was actually going to skip the case of Como and Fox, but I'm going to talk about it a bit because it impacts the way we lawyers practice. we as family lawyers understand that sometimes we are not dealing with people at their best. Separation is a very difficult time. It's regularly compared to, or it's regularly suggested, sort of the second most difficult thing to having a death in the family. And we as lawyers deal with these people on a regular basis and try to help them. I will often tell my clients and my back office, the people at the back office at the firm, while I may be an okay lawyer, I'm a really shitty accountant, and I very often don't necessarily keep track of what retainers we have and what ARs are and that kind of stuff. It's just I just don't pay attention to it. Como and Fox shows that by not doing that, you can really get yourself kicked in the ass. So it's not at all unusual that when we have a difficult client, we will occasionally, not all the time, but very occasionally have a client sign a notice of intent to act in person, knowing full well that when things get difficult, the client may not cooperate. You may have to bring a motion. You may or may not be allowed off the record, depending on when in the proceeding you bring your motion. And counsel used to think, I emphasize, that you could simply have a client sign a notice of intent to act in person, and then whenever the client started to misbehave, you could simply bring it out, file it, and say, adios. So that was the situation that was presented to Justice Pazaratz. Justice Pazaratz starts his decision like this, and there's nothing better. I could just actually spend all my time reading the first couple paragraphs to Justice Pazaratz's decisions because they're often very, very pithy. So he says, if you sign this piece of paper, it means that any time I choose, I can dump you as a client. Even on the eve of trial, suddenly you'll be on your own in the courtroom. Lawyers are not allowed to say that or do that. A notice of change of representation is not the same as a get out of jail free card in the board game of Monopoly. It's not an escape hatch to be kept in a back pocket until the lawyer tires of the client or the money runs out. And Justice Pazaratz then, over the course of numerous pages, goes on to suggest what the problems are with lawyers undertaking this practice and having a notice of intent to act in person signed. It's a rather sharply worded endorsement. He suggests that doing so is a tactical misuse of the notice of change in representation, and that lawyers simply can't do it anymore. This situation was a woman had been represented for quite some time by the lawyer. A 6-day trial was scheduled for the July 25 sittings. At the trial scheduling conference, the lawyer remained on the record for the mother, gave no indication at all that she wouldn't be representing the mother at trial. Father was self-represented. In April of 2025, lawyer served father and mother with notice of change, one that had been signed by the mother more than a year earlier. So the lawyer here had done exactly that Justice Pazaratz said can't be done, indicating that the mother would then be representing herself. In July, the mother scheduled an attendance in purge court to request an adjournment of the then imminent trial, finding herself without a lawyer. She cited the fact that she didn't have a lawyer, cited the fact that she couldn't understand the case herself, cited the fact that she was having trouble finding a new lawyer on the eve of trial, and suggested that she was wholly incapable of running the trial on her own. The father opposed the request. At the purge court shows up Justice Pazaratz, who invited the lawyer to show up via Zoom to clarify the timing of the notice of the delivery of the notice of intent to act in person. And when I say Justice Pazaratz invited, well, we all know what a judicial invitation means. So the lawyer showed up, quickly understood that this was not going to go well, got back on the record and did the trial, even though can't tell entirely, but I'm guessing likely wasn't paid for her services for trial at the end. But Justice Pazaratz does take the opportunity to talk about the situation and the fact of unbundled legal services and limited scope retainers and such, and the sort of this thing where lawyers will appear as agent only but not on the record. And Justice Pazaratz takes a very sort of judicial view of this, or from the point of view of the judiciary, which one might think, and says, "Listen, this is no way to run a railroad. How does it work if every time this case shows up in court, there's a different agent or a different person offering limited scope retainer services? On Monday, lawyer shows up and undertakes to do something, and 3 weeks Monday, a different lawyer shows up and says, I had no idea that this promise was made." He says it's simply no way to run a railroad. But Justice Pazaratz, I may forget, I say with the greatest of respect to a very well thought of jurist, is what it means to be a lawyer. And would it not be better that somebody shows up with some assistance, be it by agent or unbundled legal services or limited scope retainer, than showing up alone and simply drowning in the procedural morass of, our current rules and current notices to profession, etc. That is a part of the point of view that Justice Pazarats doesn't talk about. But as a result of this, the most important thing that Justice Pazarat said is that there is a temporal element to a notice of change, and you can't simply have somebody file one time and then serve it a year later. It's something that has to be done quite immediately. And in fact, if you try to do this, the court may actually step in and say, no, you can't. So this is the reason I say that lawyers now have to start to pay more attention to their accounts and more attention to their receivables, because if you think that you can simply, as trial approaches, get off the record, either by motion, which Justice Pazarats also talks about, or simply by whipping out a notice of intent to act in person that you had signed sometime before, it's entirely possible that's not going to be successful. And if that's not successful, you are facing the prospect of doing a trial of 1 day, 5 days, 2 weeks, a month without getting paid, which is a prospect that nobody particularly wants to think about. So as trial approaches, months and months and months before trial actually approaches, you should really be giving this some thought and thinking, is this a client I'm prepared to take to trial? Do I want to get my trial retainer now? Do I want to make sure I get it months in advance to avoid exactly this sort of situation? And the thoughts of getting a notice of intent signed now, at least, and using it sort of at your will when you need it, seem to have gone by the wayside, even though I say again respectfully, I would think that many judges would rather have a lawyer on the record for as long as they can be on the record with the protection of a notice of change if they need it. Because let's face it, the only time we get these notices signed are when we have a client who's proven to be disobedient in the past. So it's an important read, a concerning case, but it is the law.
So the case I'm going to talk was actually from Nova Scotia. It's DP and FM. This is a case that is about interim motions for parenting, though this is a very unique interim motion for parenting. This interim motion had a 2-day hearing featuring viva voce evidence from both parents, multiple collateral witnesses, and both parties were subject to cross-examination with written submissions filed after the close of evidence. So a very thorough hearing, which may help us understand, because in this case, a 16-month-old who had previously been living primarily with the mother is involved, and the judge orders a 50-50 shared parenting arrangement. This is a case that deals with a number of those important issues when you deal with a child of this age, specifically things about the status quo. Justice Mason deals with a status quo here that the court finds was imposed by the mother. However, the judge also deals with the fact that the father would frequently breach the sort of imposed agreement on him. This is a case that has a lot of great analysis, even for courts and lawyers here in Ontario, as Justice Mason does a helpful review of the key principles, including talking about Justice Pazarat's often cited decision of Churchill, Elliott, and Ward, which we talked about last year. And I would encourage everyone to read. It has 40 core principles for interim parenting disputes, and in many ways it's the only case that you need. But this case is also very helpful, particularly in dealing with the concept of a status quo and whether that status quo is placed on you or not. The court put a lot of emphasis on the fact that the mother had essentially resorted to self-help, that she had imposed this plan, and that the court will not sanction parties who act in such a manner. The mother had unilaterally restricted the father's time. Though that being said, after cross-examination and all of the evidence came out, it appeared that the parties actually had fairly good things to say about each other in terms of their actual parenting skills. Indeed, on cross-examination, both expressed confidence in the other parent's capacity and their ability to cooperate moving forward. So as a result, the court felt comfortable that the father could sort of build up in a very short period of time to a full 2-2-3 rotation. Aaron and Michael, in their write-up of this, posited that we will likely never know how this turns out, because we just touch these cases and we never find out the background. But it would be very interesting, given that it was a significant shift. The child had lived primarily with their mother for their entire life, and this would be a seismic shift in their sort of experience. However, given the process, it's clear that the judge had thought about this a lot, had considered the factors in Nova Scotia's Parenting and Support Act, which is very similar to our Family Law Act, and determined that both parents were capable of meeting the child's needs and that this would be in the child's best interest. It's also an interesting case to sort of look at historically, as in the not too distant past, we would have been thinking about this under the tender years doctrine, in which case a decision like this would never have occurred. So a very interesting case, an important one for interim motions on parenting. And even if it's Nova Scotia, still one that touches on a lot of good Ontario case law.
What do you mean, even if it's Nova Scotia? You just insulted an entire province of our Dominion.
Yep, that's usually what I do at least once in these things.
I'm going to talk about a case called Chapman and Ing, which deals with the marriage of family law and corporate law. And there's a lesson buried in here somewhere, and I'm not entirely sure if the lesson is don't do business with those you're sleeping with or don't sleep with your business partners, but there's some lesson in here. You can decide what it is for yourself. The parties were engaged sort of in the typical on-again, off-again relationship for several years. To complicate matters, they were also business partners in a trucking business and in a property holding business. They used various structures to buy and sell these properties. Over time, their personal relationship really soured and went sideways, as often does. When the personal relationship soured, so did the business relationship. And then the parties then disagreed as to their entitlements in both the corporate world and the family law world. The appellant, who was the male in this case, wanted an order for the windup of the parties' mutual real estate companies and the appointment of a receiver, arguing that he was entitled to half of everything, half the proceeds, half the company, as he was a 50% shareholder. He argued that the parties were in a joint family venture. This is where the family law lawyers get interested, and that he owned the properties on a 50-50 basis, regardless of title. The trial judge disagreed and found the parties were less intimate partners in a joint family venture and more business partners who from time to time engaged in unbusinesslike activities. He found that they were in a conjugal relationship, although really just barely. They found that the split proceeds equally would be to unjust enrich the appellant because the value of one of the properties had significantly increased after separation due solely to the respondent's investment of time and money. And then, having not contributed, he wasn't entitled to share. The trial judge therefore awarded the respondent 100% interest in the property, in this one specific property at issue called the Wyandotte property, in exchange for a rather nominal payment of $39,000, which was essentially 50% of the purchase price of the property, less the amount of the first mortgage. The appellant, as many appellants are, was unhappy. Otherwise, they would not be appellants. He trotted off to the Court of Appeal and came up with a new argument, a clever argument, and said, hey, everybody have a look at Section 22(3)(b) of the Ontario Business Corporations Act that basically says that an equal shareholder in a corporation is entitled to equally share in the property upon wind-up or otherwise. He suggested the trial judge erred in granting a proprietary award when a monetary would have sufficed. And lastly, he argued the trial judge erred in valuing the remedy on a value survived basis, given the fact that the parties were not in a joint family venture. So this is a fairly meaty case to unpack. Parties first were in business in 2007. As I think I may have mentioned, they had a trucking company, they had a property company. When things soured, the husband essentially stripped the trucking company, sold a whole bunch of the trucking company assets to friends at below market value, started another company and started transferring clients to the new company, basically behaved in all the sorts of ways that you do not want your clients to behave when you have a suspicion that you may land up before a judge. So that left the Wyandotte property that had actually done really quite well, solely on account of the, I will call the wife's efforts post-separation. Again, the trial judge found that the parties were in a conjugal relationship that eventually became predominantly focused on their business. And while the marriage was certainly not at all happy, it was still a conjugal relationship. The trial judge also found that the appropriate remedy would be to require the respondent to buy out the appellant shares in the company as those shares existed at the date of separation. And that's where the order of the $36,000 or $39,000 payment came from. Notably, this case relies heavily on Mulchan and Pennington in order to figure out whether or not the parties are in a conjugal relationship. The court doesn't consider Kasabian, a case that came out just after this case, which we're actually going to talk about a bit later today. That is sort of the new leading case on when they're on whether parties are in a conjugal relationship and when the conjugal relationship ends and when the parties have separated. In analyzing unjust enrichment, the trial judge found that the appellant had been enriched from the respondent's investments, and therefore she was to enjoy most of the benefits of the property that she worked on to avoid an unjust enrichment. As I say, husband comes up with this novel argument about a juristic reason for the enrichment, because remember, enrichment requires an enrichment, a deprivation, and lack of juristic reason. So husband said, well, maybe there was enrichment and maybe there was a deprivation, but there is a juristic reason, and that juristic reason is the OBCA, specifically, can't remember the section number, but the section I referred to before, section 22(3)(b), which says rights of shareholders, where a corporation has only one class of shares, as did this one, the rights of the holders thereof are equal in all respects and include the rights to receive remaining property of the corporation upon dissolution. He said based on that, there was actually a statutory juristic reason for the unjust enrichment, and therefore there could not be a finding of unjust enrichment, and the proceeds were to be divided equally. The Court of Appeal, first of all, deals with the fact that this was a new argument raised on appeal. And while the Court of Appeal is very loath to entertain new arguments on appeal, here they said, well, really, this is simply a new legal argument. There's no new facts that have to be brought to bear. All the facts were already out. Therefore, they did allow the argument on appeal to be made on appeal, even though it hadn't been raised below. However, Justice Pomerantz said, while a good shot, 22(3)(b) of the OBCA does not provide a juristic reason for the enrichment, and the reason is predominantly because if a statute is meant to is going to be used as a juristic reason to avoid unjust enrichment, it has to very clearly say so. According to Justice Pomerantz, by its terms, Section 22(3)(b) addresses the relative rights of shareholders of the same class vis-a-vis the corporation. It does not purport to allocate the family law or equitable claims that one shareholder may have against the shares registered to another shareholder. There's nothing in the section that can account for the enrichment of one shareholder to the detriment of another, even if linked to their corporate dealings. The provision is immaterial. So Justice Pomerantz says, yes, by all means, at corporate law, yes, equal shareholders are entitled to equal rights. However, there is this sort of overriding family law jurisprudence in the background that we have to pay attention to. She then goes on to remind us all about the case of Wildman and Wildman, where the court says this is particularly so where the context involves family law litigation. In Wildman, the court was willing to pierce the corporate veil in a family law dispute, commenting that this is matrimonial litigation, not commercial litigation. So that is music to a matrimonial lawyer's ears, and it's a very useful phrase to bring out whenever you happen to be in a case that does involve corporate litigation, because family law sometimes is just different. And there have been a number of appellate authorities that actually say just that. Ultimately, on the just by way of subnote, it's not certainly the most important part of the decision, but Justice Pomerantz does suggest that the trial judge may have erred in ordering a proprietary remedy, being a trust interest, on a value survive basis, even though a joint family venture had not been found. And in suggesting that the trial judge may have erred, I respectfully suggest that Justice Pomerantz actually erred, because you have to remember how things were before Kerr and Barano. Before Kerr and Barano, for unjust enrichment, the first award, or the award of first resort, was a monetary remedy. if a monetary remedy was found to be inappropriate for some reason, or insufficiently linked, you could then go on to a proprietary remedy. Before Curran Barano, the whole idea was that a monetary remedy had to be valued based on value received, and a proprietary remedy had to be valued based on value survived. Curran Barano sort of undid those strict sort of silos and said, no, if there's a joint family venture, you can also award monetary relief, which is again the first grounds of relief, and you can value it based on value survived, which tends to be a much higher value than value received. So that was the purpose of Curran Barano, but it does not mean that you can only value something based on value survived if there is a joint family venture. Curran Barano didn't undo the fact that generally speaking, a proprietary remedy is valued based on value survived. So that's just a little bit of a hiccup in the analysis. And if you are not reading it, knowing about that, if there's a possibility of getting confused. But a very important case to read, up there with Wildman and Lynch and Siegel, where we're talking about sort of the differences between family law and corporate law.
So I'm going to talk about a case called Scott and Scott, which is a cost decision. This is a case that is very useful when you are dealing with costs related to unproven spurious allegations. So here, the parties had a trial, and the wife had been successful in all issues and was seeking full recovery costs of just over $57,000. She argued that the husband had been acting in bad faith. The family law rules allow for full recovery costs in the event that a person acts in bad faith. From the case of Scalia and Scalia, we know that essentially the components for bad faith are that you have an intention to inflict harm or to deceive. That's the core of bad faith under the family law rules. So what was the bad faith in this case? The husband argued that the wife had been collecting millions of dollars over the past 10 to 15 years because she was in secret an internet porn star named Princess Consuela. To prove this, he provided 39 images that he claimed depicted his wife that he had captured from the internet. The issue is that none of the pictures showed her face. Query as to how he identified this individual. The judge was not impressed by this argument, described it as being patently ridiculous, also pointed out that the independent witness called by the husband had no credibility whatsoever, and that everything was a deception, piling, quote, improbability upon improbability. So very clearly to the court, they saw this as a concocted argument. It was designed to humiliate and embarrass the wife. She was forced to deal with these, quote, absurd and unfounded accusations for years through the litigation process. And this was done as a form of revenge. So this is one of those situations where it can be very useful when you are making these costs arguments in terms of claims that people are making that have no basis, that are there to drive up cost, to embarrass and humiliate. So an important case for that point, and I will turn it back over to Aaron.
Some cases you read and you think to yourself, wow, I wish I was there for part of this one. This is one of those cases. I would have liked to have been there for the cross-examination regarding Princess Consuela, but alas, I was not. I'm going to talk about a case called Q and Zhang that deals with the presumptions of resulting trusts that are baked in to the Family Law Act in Section 14. And it was meant to answer the question, although as we'll see, it doesn't actually answer the question, is there a difference in funds that are received before marriage and after marriage? Because before marriage, parties aren't spouses. So Section 14 doesn't apply because Section 14 is in Part 1. And Part 1 adopts the definition of spouse of parties that are married or party to a marriage that's void or voidable in good faith. So prior to marriage, we're left with the doctrine of resulting trust, which is, as we all know, did parties buy something or transfer funds, and the law presumes bargains and not gifts. However, after marriage, we have Section 14 and the subsections that say money that is held, property that is held jointly is presumed to be held as joint tenants and meant to be held as joint tenants, and money in a bank account that is in a joint account is presumably meant to be held jointly, subject to proof to the contrary. So the burden of the presumption switches as you walk down the aisle, which is something nobody thinks about as they're marching down the aisle. And the question then becomes, if money is advanced before marriage and the parties then separate after marriage, does the nature of the obligation change? Does the nature of the presumption change? Are we stuck with the originals, with the original presumption of resulting trust, with the person receiving the gift having to produce evidence to rebut it, or are we now in the switched regime under Rule 14, where the assumption is that there is actually meant to be equal holdings, and the person that's contesting it then has to hold it? The facts of the case are somewhat unremarkable, and the factual background or factual matrix is exactly as I've described. One of the parties kicks in a fair amount of money to the purchase of a property that is ultimately registered in joint names. This is done before marriage. After the parties are then married for a very short time, then there's a separation, and the question becomes, well, who bears the onus of the presumption? Does the person that gave the money, are they able to say, well, this money was given before marriage, therefore a recipient has to show that a gift was intended? Or because we're now married, do I lose the benefit of the presumption and I have to do it, and now I now have to deduce evidence to show that I never intended a gift at the time? Ultimately, although it would have been really great to have this question answered, because it remains sort of one outstanding question, and because the Court of Appeal does suggest, maybe in a case called Holtby and Draper from 2017, in one paragraph does suggest maybe that the presumption doesn't switch. Ultimately, Justice Trotter adeptly dodges the question and says, listen, on the facts of this case, it doesn't matter if we apply Section 14 or if we don't apply Section 14, because even if the wife bore the burden of the presumption, having given the money under Section 14, she discharged her burden. Therefore, it wasn't necessary to consider whether or not this one particular passage from Holtby and Draper sort of stood for this proposition that once married, Section 14 applies to even pre-marriage gifts and the like. So it would have been nice to have the answer. We don't entirely have it. As Justice Trotter notes, in a perfect world, litigants would carefully document their financial affairs. But we as family law lawyers said, the reason we do some of what we do is specifically because we don't live in a perfect world, and people don't always live in perfect marriages. So the court below ultimately bought what the wife was selling, even if it was mostly her that was selling it, because she was the only one that gave evidence, which also raises the point that the clear and convincing evidence that you have to raise in order to rebut a presumption can actually come from the party themselves. You don't necessarily need third-party evidence. The Court of Appeal also talks a bit about occupation rent and really sort of hammered the husband here by way of occupation rent, which tends to be how occupation rent is used these days by the Court of Appeal, especially since Non-Shum and Green, where they really loosened the reins on occupation rent and said, yeah, it doesn't have to be unique. It just has to be a reasonable situation. And here the Court of Appeal agreed that the husband's conduct had been so egregious, they essentially used it to offset a fair amount of what he otherwise would have been entitled to receive. So an interesting case, doesn't answer quite the question we'd hoped it answered, but it does take a little chunk of it anyways.
So I'm going to talk about two cases sort of mushed together, just as we're running a little low on time. It is DuPont, Good, and Ashmead, and Kaniga and Thwaites. So in DuPont, Good, and Ashmead, this is a case that sort of stands for two broad things. And the first, it's by Justice Sharma. There's a big chunk of it about how you should prepare materials for a motion. And if you have issues with the other side in the preparation of their materials, this is a good case to cite. Justice Sharma goes through all of the potential issues, from the fact that an affidavit should be in first person to that you should proofread your affidavits. Also, you are not allowed to attach another person's affidavit as an exhibit to the first person's affidavit in order to get around page limits and things like that. So a very useful case in that respect. Then His Honor does something that's very interesting, which is this was a parenting case, and His Honor talks about the fact that there was no independent and objective evidence from the Ontario's children's lawyer or other parenting assessor of what's best for the children in this motion. And there was no expert evidence as to what was best for children of this age. And what he states is, in the absence of such evidence, I refer to the AFCC Ontario Parenting Planning Guide as independent and objective evidence of what is best for children. So while we have talked about in the past judges using this parenting guide as a guideline, and it is seeing increasingly large or an increasingly wider adoption in courts, this would appear to be a court taking judicial notice of the parenting plan guide itself, which is something that is likely outside the bounds of what can be taken judicial notice of. Essentially, the facts have to be so notorious or accepted that everyone in the community accepts it as being true. It's not the subject of dispute, and I don't think this reaches that level that the guideline can be used in such a way, but it is a further example of seeing how far the parenting plan guide has spread, and it's important. It would also indicate that this is a case where a judge was really struggling with the lack of evidence and averts to something when they are trying to make a decision for the best interest of the children. It's also potentially a little troubling because judges are supposed to make a decision on the best interest of the kids in front of them, not children generally. And if the AFCCO parenting plan guide sort of has this automatic default position, then that would indicate it sort of is a general proposition about kids rather than a specific one. So compare that with the Kaniga decision with Justice Tweedy, where Justice Tweedy deals with the same guideline and specifically states that it is only a guideline and cautions against parties considering it a default position. In that case, the mother had behaved very badly. She imposed a parenting schedule on the father. She also broke into the father's house and then subsequently broke into his computer to find out if he was telling the truth as to why they couldn't spend family day together. This was post-separation, and she was actually convicted for an offense under Section 342 of the Criminal Code, which is unauthorized use of a computer. And as family law lawyers, we know a lot of people who are using the other side's computer in an unauthorized fashion. The AFCCO parenting plan guide is cited directly in this case. This case sets out very clearly that it's just meant to be a guide, though it is an extremely helpful guide. So Justice Tweedy departs from it. The mother argued that while she had imposed the schedule was appropriate for the age of the child based on the guide. This case is also important, and it's very interesting because a lot of parents, particularly with a child of this age, because it was another case with a young child, the mother here argued that she'd been the sole decision maker for the child since birth, and that status quo should continue, that she should have sole decision making. Justice Tweedy didn't accept this and noted that it was a status quo imposed on the father. The mother had made all the decisions because she didn't let the father participate. And a self-engineered status quo is no status quo at all. The mother was not fully supportive of the father's relationship. The father was supportive of the child's relationship with the mother, and he was the more successful party. Joint decision-making was ordered, and the father got a schedule very similar to the one that he proposed, which did depart from the guide. So an important case two important cases on the AFCCO guidelines and how we consider status quos.
Okay, we are indeed running short of time, so I will speak quickly about a couple cases and just sort of hit the high notes. Marillion and Dunmore, the case that keeps on giving. It's now been reported 5 or 6 times for different issues, most recently from the Supreme Court of Canada. Supreme Court of Canada deals with this situation. You are a lawyer, you have a client, your client shows up in Ontario with a child, the other side suggests the child is in Ontario improperly. Hague Convention, you're thinking, but no, because the jurisdiction from which the child has most recently come is not a signatory to the Hague jurisdiction. Therefore, the Hague doesn't apply. Therefore, we're dealing strictly with the Children's Law Reform Act. Therefore, what is the test of habitual residence under the Children's Law Reform Act as opposed to the test of habitual residence under the Hague Convention, which comes from bailiff? Bailiff, a case that I don't like. Bailiff dealing with habitual residence in the test that I don't like because it deals with the whole hybrid approach rather than deviating from, rather than the old sort of parental intention approach. In Merlin and Dunmore, the Supreme Court of Canada says that while the definition in bailiff of habitual residence does not apply directly to cases under the CLRA, similar conditions may still inform the analysis. Habitual residence under Section 22 of the CLRA does not require a shared parent. It does not require shared parent attention. They then give a couple high notes about what you do look at in order to determine shared parenting. You can read bullet points as well as I can, so I will simply leave them to you. It was a bit of a surprise that the Supreme Court of Canada heard this case, having just heard FNN just a couple of years earlier, but FNN really dealt with the issue of potential harm under the CRA if the child is returned, and Merlin and Dunmore, at least this issue or this incarnation of the Supreme Court of Canada, specifically deals with that issue of habitual residence. Justice Cote, as she always does, dissents, like the dissent. Here, Justice Cote says the parental intention approach really has to play a central role in determining the habitual residence of a child, and she was concerned that the majority's rejection of that approach would incentivize parents to submit any and all evidence relating to the child's connection to a particular jurisdiction, and all that was going to do was extend the time it took for these cases to be litigated, and she's exactly right. Next case, again, just by way of high notes, is Rosset and Bauman. Rosset and Bauman is Justice Finlayson's attempt to try to undo the problem that we have where if a spouse is subject to a foreign divorce that is recognized, that spouse can then no longer claim support in Ontario, because you can't claim support in Ontario as corollary relief if you're subject to a foreign divorce, and you can't claim support under the family law in Ontario if you're a former spouse. Justice Finlayson suggests that it's time to sort of re-examine that whole former spouse issue under the Family Law Act, and he finds that, in fact, yes, it's time to redo it, and finds that, yes, he would have awarded support. Unfortunately, the problem or the warts with Rosset and Bauman are that only one side had a lawyer. This whole issue was really sort of raised by the court, a very well-meaning court by Justice Finlayson, who was really trying to address this problem, as directed by the Court of Appeal a number of times. The problem is it's really hard to undo 20 years, if not more, of jurisprudence that are very clear that say a former spouse can't claim support. So while it's a valiant effort and absolutely worth the read, I'm not sure it goes far enough. And finally, on the same topic, yet another incarnation of Merlin and Dunmore. This time, a constitutional challenge had been brought to the definition of spouse under the Family Law Act, on the basis that a former spouse can't claim spouse support. The end of the story is that here in this particular incarnation of Merlin and Dunmore, determined by Justice Mathern, who is actually a constitutional scholar, good case, good judge to hear it. She said, "Listen, unfortunately, there's just not the evidence I would need here to find that the definition runs afoul of Section 15, and I don't fault counsel for that. The problem is that this sort of morphed into a constitutional charter case halfway through the case, and it's really hard to take a case that isn't a charter case and just turn it into a charter case." The final case I can talk about very quickly is Kasabian and Markarian. The new leading case on what it means, on what date of separation means, and what reasonable attempts to reconcile means. And notably, it does not even once mention the term matrimonial consortium, because who the hell knows what a matrimonial consortium is? And that's from Oswell and Oswell, where one party breaks the matrimonial consortium. Kasabian actually takes a good hard look at past case law, and it is the case you have to read if you're dealing with whether or not parties have separated and whether or not there have been reasonable attempts at reconciliation. Sorry for the fast talk at the end.
I mean, I think that's our time, Russell. We're at 10:15.
Wow. What can I say? That we heard of a matrimonial consortium's child support updates. We've got 10 days or so to get that sorted. The marriage of family and corporate law. That would be an interesting ceremony. Couples taking care of business. well taken care of business. That's always fun to read those ones. We've heard about princesses today. I might have to go try to find that princess online somewhere. It would have been an interesting case to sit
Just
on.
Consuela.
Self-engineered status quos. Aaron's told us about unhappy appellants. Is there ever a happy appellant? I guess if you win,
I
right?
guess only at the end of the day.
Right. Um, what I really like was this discussion, Aaron, about to control clients, right? And then now Form 4 is kind of dirty business, if you're going to use that to try to control your client. But there's practical realities for our clients. They may not have a trial retainer ready when you're setting the trial. And counsel can't simply just adjourn the trial until the retainer's in place. So I guess my question is, what are some tips in terms of, trying to get a proper retainer, controlling your client and your duty to the court? What practical tips do you have for lawyers out there?
Well, I guess tip number one is what I was told a very long time ago, and I think it was actually by Ian Hull, who's a senior estates lawyer. And he said, it's wonderful to do pro bono work. And our firm does a lot of pro bono work, but it should be the lawyer that decides if the case is pro bono and not the client, which is actually very good advice. Let's face it, legal fees are expensive. Sometimes clients and lawyers are mismatched, and you don't necessarily always need, the Cadillac or the highest. Sometimes, a solid Volvo was really all you need. And the other thing that I mentioned is that, you really sort of, as the case winds forward, you really have to sort of take some responsibility for financial management. You have to know if your AR is creeping up. You have to put your client on a payment plan. If, once you're heading to trial scheduling court, like, that's what happened in Justice Pazratz's case. Like, this lawyer went to trial scheduling court and made no mention of the fact they were going to get off the record, and then tried to get off the record immediately after. So I think you have to have these discussions with your client long before a trial scheduling court. You have to say what the retainer is going to be, and you got to get your trial retainer in early. If they can't afford your trial retainer, then you can discuss if you're going to do some sort of unbundled services. But while on the one hand it is incredibly unfair to lawyers to force them to stay on the record and do a trial that could last, in a parenting case, a high conflict parenting case, it could last a month. Like, to do a trial like that and not get paid for it unless you're doing it voluntarily. On the other hand, yeah, I get what Justice Pazratz is saying, and you got to make these plans early. So you got to have some sort of tickler, or you have to have your assistant remind you, hey, the Smith trial is, the trial scheduling conference is coming up next week, and, you're owed $25,000. Do you want to have a discussion? Do you want to think about it? Because at some point it's going to be too late, and no one's entirely sure when the too late point is. So you gotta keep an eye on things. That's my best advice.
A lot of lawyers couldn't afford to do a 30-day trial and not have the income.
Right. It would be financially ruinous. It would be the end of the practice, right?
Yeah. So in terms of, Adam, do you want to add to those tips? That was great, Aaron.
I mean, I don't have much to add other than just, I guess you have to know yourself. If you're the kind of lawyer who isn't good about tracking those things, then you need a good system in place or a really good assistant to sort of deal with that. Aaron made the joke about, he's not so good at that back end, but he's very good about making sure that he has an assistant and systems that make sure that that makes up for that part of it, which lets him free to be the excellent lawyer that he is. So you don't have to do all of that. It doesn't have to be your personal thing, but you need to be aware of it. And if that's something that you struggle with in your practice, put in the things in place to help you. Don't feel like you have to do it all yourself.
Yeah, great tips. Can you discuss briefly, you mentioned a temporal element to the notice of change. Are we talking hours, days, weeks, months? And what if you're at an exit pretrial and your client didn't fulfill his or her agreement to provide you with the trial retainer? Is that too late? Are you stuck at that point? What would your take on that be?
So there's sort of two questions there. One is, what's the temporal basis for filing a notice of attack in person? And number two is how much time is not enough time in order to get a judge to allow you off the record. So the first question is, like, if you have a client sign a notice of intent can you wait an hour, a day, a week, a month, a year? Justice Pazarats doesn't give a hard and fast rule, but he certainly makes it clear that time matters. So I certainly wouldn't, I would have no difficulty saying, listen, Mr. Smith, you've shown you're not really that interested in following my advice. You owe me $20,000. I'm going to have you sign this notice of intent now, and here are the rules. Within 30 days, you must cut your receivable in half, and you must do 1, 2, 3, 4, 5, which are things you're ordered to do. And if you're not, I'm filing this. I think you're okay doing this because doing that. There's nothing that says you can't use it as a hammer to try to, wrench compliance from a client, especially if you're trying to get them to comply with a court order. In terms of when you can bring a motion, if you have to, if you've got a hearing coming up, if you have a motion coming up, if you have a long motion coming up, or heaven forbid, if you have a trial coming up in the relatively immediate future, courts are giving lawyers hard times getting off the record, which is why I say that this has to be planned months in advance, not weeks in advance. If your trial starts in 2 months, you're going to have a hard time, especially if it's a peremptory trial, because the court's going to say, well, who are we going to find to represent this person? This person can't represent themselves, and we're not going to adjourn the trial again. So it's something added that lawyers have to think about. And then that, invokes the specter of law pro if things don't go right. And they are candid conversations. People don't like talking about money, but you have to, or you have to have somebody in your office do it, but it has to be discussed or you will get screwed.
Is the court sorry, go ahead, Adam, you want to jump in there?
It also probably makes a difference if you're the one bringing the motion to get off the record. Like, one of the things that sort of does seem to come out is if the court just finds out about this, right? Like, the judge finds out about this at the purge court because the mother scheduled attendance. Like, you don't have an opportunity to get in there and explain what's going on. I think a court's going to have more sympathy for people who are able to bring that motion. Though, again, to Aaron's point, that means pre-planning and acting in advance. You just don't want to be bringing this up at the exit pretrial to say, oh, by the way, I haven't been paid. I'd like out, please.
And after the fact, an invitation from a judge, it's not an invitation, because if you don't show up, it's going to be followed by a court order.
Exactly. And it is, what other profession can you be forced to work for free? Like, when I go to the dentist, the door is locked and barred until I pay for the dentist, right? But if you need surgery, perhaps not in Canada, but anywhere else, or anything elected, you pay, it's pay as you go. Only lawyers are sort of hung out to dry for, having the audacity to allow a client to carry a receivable for a while. So there's some unfairness in it, but, it's also a privilege to practice in the profession. So, it's a balancing act.
One last quick question, not just about money, but what if there's a change in, your client's temperament, or you're not following your advice, or they're instructing you to go on trial on issues that are not going to be successful? Would a judge let you jump ship then, or?
So that's an area that Justice Pazarats does talk about, and he does make a point that if you show up in court and say, I have to get off the record, not for financial reasons, but for ethical reasons, either there's a conflict, a real conflict, like a conflict has arisen, or a client is no longer following your instructions or something like that, he then suggests that the court really can't make inquiries because it's a matter of privilege, and you're then entitled to get off the record and the court won't get in the way. But woe unto the lawyer who makes claims of breakdown of relationship or suggests that there are ethical issues if it turns out it is only a financial matter, because then you're even more screwed. This isn't the time to put your personal reputation on the line. So if there's a whole bunch of letters saying pay my account, pay my account, pay my account, pay my account, oh, I need to get off because we have ethical issues, and that comes out, that's not going to paint you in the best light.
No, good tip. Adam, anything further before we sign off?
No, just, if you do that, get ready for a more sternly worded judicial invite.
Or an invite from the Law Society, maybe.
Exactly.
This has been super insightful. Thank you guys. You guys really knock it out of the park every time. I want to thank our audience. There's been lots of questions about the show notes. Go to our YouTube description. You'll find the information there. You'll receive follow-up surveys from after this event with the notes included as well. So thank you for everybody's input. We'll take, what do you think, Daphne, a 5-minute health break and get started on our next session?
Yeah, that sounds excellent.
Okay, have a great morning, guys.
Good
Thanks,
conference,
everyone.
folks. Take care. Bye-bye.
So we invite everybody, you can just stay online, and we're going to be back online at 10:30 with our next session.
Hello, everyone. Welcome back. Hi, Jason. Great to see you.
Morning, how are you?
I'm good, thanks. How are you today?
Good.
Good. Thank you so much for joining us for our 4th annual Family Law Now virtual summit. Glad to
Absolutely.
have you here.
I guess I should just mute my
Sure, no problem.
sound and
Yeah,
video.
your session will be beginning really shortly.
Coming up soon. Okay.
Just a quick note for everyone in our audience. We did get a lot of questions about the show notes for the last session. They are available in the YouTube description, so you can access the case law citations there. Once again, thank you to Adam Prewer and Aaron Franks for donating their time. Such an incredible session. We look forward to each year. And just a reminder that the previous session was also accredited for 30 minutes of professionalism with the Law Society of Ontario. And the next session we are looking forward to is financial disclosure for business valuations and income assessments. And that will begin here shortly. Okay, welcome back, everyone. Let's get into the next session. So today we are looking at financial disclosure for business valuations and income assessments with Paul Mandel, Melanie Russell, and Jason Kwiatkowski. Hi, Melanie. Great to see you.
Nice to see you.
You as well. Hi, Paul.
All right, Captain. Thanks for having us today.
Thank you for joining us today. We really appreciate you donating your time and sharing your knowledge in the session. So today our panel will be discussing financial disclosure for business valuations and income assessments. So this entails types of disclosure, requesting disclosure, CICBV professional standards, federal child support guidelines, shareholders, and business owners. As always, we encourage you all to participate in any polls and use the chat feature on YouTube throughout this event. And all resources mentioned will be included in the YouTube description. And if you registered, you will receive it via email later this week as well. So it is now my pleasure to introduce today's panel. We have Paul Mandel. Paul is a valuations and litigation support partner working out of the Toronto office. He is a senior business advisor and leader with more than 29 years of experience. Paul assists clients with corporate valuations, including valuations for income tax, disputes, planning, and regulatory purposes. Thanks for joining us today, Paul. We also have Melanie Russell. Melanie is the founder of Calyx Valuations, Inc., which she founded in 1996. Look at her showing off the Summit mug. I love it, Melanie. Throughout her professional career, she has been involved in many valuation and forensic assignments for a variety of public and private companies of various sizes and across many industries, obtaining her training at two of the largest international accounting firms. In family law matters, Melanie gets involved in valuations of business assets and income for support purposes, tracing, and forensic reviews. Melanie placed second in Canada on the CICBV membership examination. Ms. Russell has been active in teaching business valuations and related topics since 1987 at various universities and professional organizations, and runs the premier preparatory course for CBV students in Canada taking their national membership qualification examination. She was elected/designated as CPA Ontario Fellow in 2023. Thank you for joining us today, Melanie.
Thanks.
And
Thank you for the mug. Thanks for the mic.
My pleasure. And last but not least, we have Jason Kwiatkowski. Jason is a founding partner and the president at Valuation Support Partners, Ltd., a professional services firm specializing in providing the business and legal communities with business valuation, litigation support, and exit planning advisory services. Jason is an independent financial neutral and has completed numerous business valuation and expert reports, including income assessments for various purposes. Jason has testified before the Ontario Superior Court of Justice as an expert witness in business valuation and damages quantification. Jason has authored many articles and has spoken before various professional and business groups, as he's doing today. And I will now hand things over to the panel to get started with their presentation.
Russell, so first thing is thank you. Thanks, Daphne, for that introduction. I just want to clarify, I'm with MNP LLP. We got a sort of series of questions. I don't know if we're going to read them out, Melanie, or
Yeah.
right, we want to respond.
So one by one. I think we're going to do a
Yeah.
poll first, right? With first poll.
I don't know. Russ isn't here.
I know
Oh,
he's-
poll is launching. Okay, Daphne says the
there
poll
we
is
go.
launching. So here we go.
Yeah, I'm just gonna hop on for a quick note. So we're doing polls a little bit differently this year. So everyone should be watching live on YouTube. Our poll just launched in the YouTube chat. So I can see it here. So what percentage of files? I'll let the panelists go through that, but just so everyone's aware, for participating, please watch on YouTube and participate in the poll. And for the panel, you can check the chat here and we'll be sure to update once the results come through, okay?
So I guess, Paul, you want to start with, while we're waiting for the poll, just to start with your first question?
Well, let's give him a second. I think we'd love to
Yeah,
run the
okay.
poll and then we'll talk about it. But I can't see the poll. I don't know if
Yeah, I can't either.
Daphne, you're gonna have to help us with that because we don't have the YouTube channel open. We have the Zoom link open.
I just opened the webinar chat and it shows.
Oh, it's the question I thought was in there, but not the sort of the polling results.
Well, they haven't given it yet, I think.
Okay. Are we getting it now?
Maybe Daphne, do you want to give us the results as soon as you hear, and then I can maybe get started with
Yeah,
Paul's
yeah.
first question?
Yeah, absolutely.
Awesome.
So
Thank you.
what percentage of files do you feel as though you have sufficient disclosure? Almost always we have 13%. I usually want more, 68%, rarely 15%, and not applicable 3%.
It doesn't actually surprise me. There was always sort of a desire to get more information and to have like kind of more line of sight into the client and what's going on there. Now, are we going to read off the questions? Like, is someone going to read for me the first question and I'll address it? Yeah.
Yeah. So first, why don't I admit for you?
Yeah. Well,
What's the minimum versus desirable disclosure required to do valuations, both of business and income?
So that is a terrific question. And the way we sort of, it is a terrific question. The way we kind of answer these, right? You ready, guys, for the drum roll? It depends, right? Like, it honestly depends on the file, the issues. There are certain documents that we must have and certain information that we must have. So before we kind of delve into that, I want to kind of cover off a couple of sort of ground kind of issues. So first thing is there's different types of valuation reports. There's a calculation, an estimate, and a comprehensive. And the difference in our professional standards, it actually says for an estimate, you do more due diligence than a calculation. And for a comprehensive report, you do even more due diligence. What's due diligence? Review of documentation. So it actually doesn't say in our standards what exactly it is. It just says that you should do more. So the more you have a live issue or the higher level of reporting, the more information we're going to want to see. Next concept I sort of want to introduce is there's 3 types of financial statements that we look at. The sort of bottom level is a compilation or notice to reader. The middle level is a review, and the high level is an audit. What's great is as you go up, those financial statements have more notes and more information in it. So sometimes an audit will give you a lot more information, or it always gives you more information than a notice to reader, but it still doesn't preclude us from needing additional information. The next concept I kind of want to introduce is managing disclosure. A big part of mine, Jason, and Melanie's job is actually managing all this disclosure and getting it. It takes a lot of time and a lot of fees for us to kind of get the information we need. So when asking for things, sometimes we want to think about cost benefit. But a file that sort of stretches on where you're asking for information, waiting for it, getting a portion of what you asked for not all of it, will tend to have much higher fees than a file where everything sort of gets put on our plate on day one and delivered to us on day one. So we want to kind of always manage that during the process. I also look at sort of another couple of concepts. When we're writing to the other side or opposing parties asking for information, they'll send us some of this stuff and then they're silent. I said, if you don't have it, let us know. Just say it doesn't exist. We don't think it's applicable, but give us the reason versus being silent. That helps move the process along. So turning back, I kind of said the minimum versus desirable is sort of a variable amount. It depends on the issues. It depends on the valuation approach. It depends on the industry that we're looking at. But kind of like the one core document that we need in everything, whether it's a business valuation or guidelines income. For business valuation, it's the financial statements. And for guidelines income, it's the personal tax returns and the financial statements for companies which they have access and control. Melanie, just anything to add?
No, not on my end. I just one little technical thing. You'll probably see things being, Paul just talked about levels of review of financial statements. So now you used to see notice to reader, but now they're all called compilations, just a technical thing with the CPA associations. Good. So on to number 2 or anything, Jason, any comments to add?
No, I think that was a good summary.
Okay, good. So, so Paul introduced a concept of how much disclosure enough, and it's ultimately sort of a professional judgment. It depends, but it's nice to look at see what kind of boxes we have. So one of the boxes Jason's going to talk about on the child support guidelines, and I'm going to talk about another box. So of course, we always as CBVs, we will look to our standards to say, is there any guidance that helps us determine how much disclosure we should be asking for? So a couple of introductory comments. I'll go through a couple of the standard sections, but in general, the CBV Institute says it's up to your professional judgment. So whether you're doing a calculation, an estimate, a comprehensive, or an income analysis, it depends, and it's up to the valuator or the expert to make that decision. The second sort, and I'll go through a couple of sections on that. The other sort of general rule is we're now, or not general rule, but are the standards that govern valuations are changing because there's an exposure draft out there, and there's even more emphasis on adequate disclosure, but not just making sure you have adequate disclosure, but disclosing if you don't. So I'll talk about those, and that's you'll probably see some changes in reports coming forward. But so in one of the standards, the current standards before the exposure draft, it says it's expected that the scope of review will be more comprehensive for a comprehensive valuation report and progressively less comprehensive for an estimate report, and then down to a calculation, as Paul said. But that's about the guidance there, right? The valuation report shall provide sufficient information for the reader to allow the reader to understand how the valuator arrived at the conclusion expressed. So before valuators can do that, we need to make sure we have enough supporting documentation to be able to do our calculations. So And sufficient information shall be gathered by such means as inspection, inquiry, computation, and analysis. And to make sure that the valuation report is properly supported. And valuators, when they're determining how much evidence needs to be collected, we have to exercise professional judgment, considering the nature of the valuation, the type of valuation report being provided, and the uses of the report. So as I said, those are sort of being tightened up a little bit in the new standards. However, the new standards will say something to the effect of it must be based on sufficient appropriate information given the intended purpose and intended uses. Valuators and experts have to consider the extent to which the scope of review has been limited. If any scope limitations are significant to a degree that they are likely to jeopardize the credibility of the conclusion, we cannot render a valuation conclusion. So that's, that was, some people will argue that that's in the existing standards inherently, but it's really clear now. And the exposure draft expands a bit on what is scope limitations, what's significant, what's not, but it's ultimately judgmental. But it gives a couple examples. One is, as Paul said, unavailable financial statements probably means a scope limitation. Unavailable data or key documents, inability to speak to management about relevant aspects of the business, which is interesting because in a contentious situation, we might be stopped by counsel from trying to speak to the other party, or the other party's lawyer may stop us from speaking to them. And another, currently when the standards say when access to essential information is denied by the client or some other party or is otherwise unavailable, any conclusion should be qualified and the limitation of scope should be considered. And as I said, that's existing standards, but the current standard or the new standards coming in are even going to be stronger with that. The exposure draft also expands some of the things to consider. So one of the general areas we have to consider, what are we valuing? So what's the subject? And the exposure draft talks about potentially key documents and information might be interviews with key management, articles of incorporation, share features. We also have to look to the underlying business operations and get enough understanding of that. So that might be looking at ownership, history, key management, looking at historical results, future expected results, the industry, competition, market conditions, market transactions, general economic conditions. And in general, the practice standards require, both on the expert side and the valuation side, require that we specifically outline what we have used. And as I said, the scope limitations as well. So over to anything you guys want to add, Paul or Jason?
Yeah, I want to emphasize in one thing, Melanie, you said speaking to management. And I think that's a very important issue that we often, when we're on the opposing party of management, we think it's very important to try to speak to management. And I find it frustrating when they won't talk to us. I think there's a lot to be said. So I thought that was a very fair comment to make. And the other one is that there is no, and within the standards, they don't actually have a specific list saying, well, if you move to an estimate or a comprehensive, you must look at document A and B. It all comes back to judgment, and it depends. But you emphasize that there's a trend. You should look at more as you move up in levels of reporting. You should look at more documents.
And I know it can be frustrating. I had a situation where the court order was for an estimate level, but the other valuator did a calculation. So then the question was, what's going to change? And I assumed that the valuator, when they upgraded to an estimate, would look to something to support the real estate, which was actually the real estate value, which was actually the most significant component of one of the company's values. But the valuator didn't change it, still relied on what management told them was the value of the real estate. So my judgment would have been, I would have gone out and got an appraisal, whereas the other valuator thought that wasn't necessary. So it's still professional judgment, as you said, Paul.
Yeah, I think that also one about the real estate is a live issue. Like something where it in most files, it's very, very much a very significant asset, which is why we go to that outside appraiser.
Right. Jason, any comments?
No, I think we've spent enough time on this question. You covered it pretty thoroughly.
So can
Yeah.
I
You're
read
gonna
Jason
cover-
for
yeah,
you?
you're gonna cover
I'll read
another
the next
box.
question for Jason. So Jason, can you give me any disclosure guidance provided by the federal child support guidelines?
Yeah, I wish I could. I mean, as evaluators, you know, we're open to the standards and the guidelines for some guidance on disclosure. And unfortunately, the federal child support guidelines do not provide a lot of detailed guidance in this area. I did find one section in the guidelines, section 21.1, which talks about income information. And it says that the spouse who's applying for applying for a child support order and whose income information is necessary to determine the amount of the order must include the following with the application. And it talks about personal tax returns for 3 years, notices of assessment for 3 years. And then it just provides a little bit of guidance where different situations, if the person's an employee, you know, they need to provide their statement of earnings. If the person is self-employed, they need to provide financial statements of the business for 3 years. If it's a partnership, they need to provide confirmation of income and draws from and capital in the partnership for 3 years. If the person controls a corporation, they need to provide financial statements of the corporation and all the subsidiaries for 3 years. And if this person is a beneficiary under a trust, need to provide the trust settlement agreement for 3 years financial statements. So some guidance, I think we would all agree, some basic necessary information there, but not a lot of details and elaboration. Any other thoughts?
Agreed.
Yeah.
It comes back to our concept, it depends.
Yeah.
Right. And what are the sort of issues?
Right. Good.
So I
Excellent.
think, Paul, you've got the next point, which is,
for me?
Are there any situations that may or will require additional disclosure? And I guess that's over the basic.
Yeah, and I'm going to give you yes. Okay, is the big
good.
global answer. Well, let me deal with valuations for a few minutes, and then I'll sort of roll into Garth. I think it really matters on what are the live issues in the valuation and what do you like, and what's your valuation methodology. So Melanie gave the comment, if you're valuing your real estate, and if you're valuing a company with real estate in there, getting a real estate appraisal is the live issue. Most valuations, what we're doing is we're doing some sort of capitalization of earnings, and we're normalizing those earnings. So in those normalizations, that creates what I say is a very, very significant issue for more disclosure. Are we trying to normalize for personal expenses? Are we trying to normalize for non-arm's length salaries? Well, we need a lot of information to do that, and where are we going to get it from, and how material is it? Which will depend on which will then lead us to how much disclosure we need. So I wrote down, for example, like if the live issue is unreported is personal expenses, we're going to want to go and look at, we either want to ask the client for them, but we may not get an answer, or we're going to want to look at the GL and see what was expensed. And that sort of pivots me to one other concept, is financial statements are the top level sort of reporting for a corporation. In order to create financial, there's underlying documentation. The next level down is a trial balance and a general ledger. And a general ledger is where they record all the transactions. Then below that is the actual source documentation, purchase invoice, sales invoices, computer information. So if you trust the financial statements, you may or may not to delve down. But a financial statement, even if they're audited, all they're going to say is, yes, we sent expenses on automotive, for example, but it's not going to tell us what the detail is, and we'll have to drill down to sort of figure that information out. Right. So yes, from most situations require us to delve in and need additional information. And there could be, even on evaluation, sort of industry specific information that we want to know about, and it's really relevant for that file. And then it's quite actually the same thing for our guidelines income. will have guidelines income may or may not have a live issue. The typical live issues I find are unreported income and personal expenses. If those are live, we're going to want to look at a lot of additional documentation to deal with those. If they're not, then sometimes we're not going to need all the documentation in that area.
Yeah, I would agree with Paul on the answer is almost always yes, because, you know, from our perspective, you know, we are going to request a certain amount of information or documents initially, but inevitably, once we receive and review those documents or information, we will oftentimes have follow-up questions because we need to understand. So you can almost always expect additional disclosure after the first round or batch is provided.
Yeah, totally agreed.
So you want me to read it? I'll read out the next question if we're ready.
Which just kind of fits into that. Goes right into this.
Okay. So what if excessive or unreasonable disclosure is being requested?
So that's an excellent question. And I'm sure that both Jason and Paul have faced this, where a lawyer calls you up and said, the other expert sent me a 50-page disclosure list. I want you to go through it and tell me what's unreasonable. So I guess first of all, the definition of excessive and unreasonable is subjective, right? And it can only be judged on the circumstances. So I always, that's a troubling thing when someone asks me to do that, because I may not have all the information, or I'm not in the other expert's head to know what is driving these requests. And in general, my underlying assumption is anyone like Jason or Paul who have some experience or fair amount of experience and they know what they're doing, if they're making a request, there's usually a good reason for it. So it's very hard, and those letters I usually say no, I can't write those. Unless for some reason sometimes the expert has already been, or the other side has already received information. It may have not have gone to the expert, so the expert may not be aware that there actually has been disclosure. But anyways, the first thing is, what is excessive and unreasonable? And you know, who has access to what amount of information? So another thing that sometimes I get asked to do is, if I'm making the requests and the lawyers are anticipating, the counsel I'm working with is anticipating that they're not going to get all the disclosure because the other side is difficult, or there's time deadlines looming, or whatever. And they'll ask me to say, well, you tell me which ones are imperative and which ones are nice to have. And that is also a very discomforting question, because I usually say, well, hold on, I'm not going to make a request unless I think it's warranted, right? I'm not just going to throw in things just to make someone's life difficult. I usually, on that list, there's a reason that I'm asking for it. So it is a very troubling thing, and it's not. So I find often it's not the expert's role to say the other expert is being unreasonable. That's my general thought. I don't know, Jason, Paul, do you agree?
Yes, it comes back to, it depends on what people are thinking and what the live issues are, right? Yep. And sometimes their client has created a live issue, right? They said, I'm very concerned about X. So that drives a lot of questions.
Yep.
Well, and I guess another one little comment to add in here. I think it also might depend on the type of format you're in. If you're in a court proceeding, or you're in a mediation, or you're in a collaborative situation, or whatever, there may be a slightly different need for amount of disclosure, or what's reasonable or unreasonable. That may be another source of reference.
So I have a question for the two of you, and I want to get your thoughts on this. I tend to look at documents differently. Is it an existing document, or is it something that needs to be created for the family law process? And how do you guys feel about that? Like, is stuff that needs to be created, is that a different fair, like, is there a different level of one being more fair game than the other?
Agreed. Look, if something is already being prepared or is in a report that you can just simply provide it. There's no trouble to do that. If it has to be created, like, then it becomes a question of, well, what's the cost benefit, right? Like, how much time and effort is it going to take to create that document that you're looking for versus the materiality of the issue that we're talking about.
Yeah. Yeah, I totally agree. And I guess the other, sometimes I see request lists from the other experts when they're asking sort of opinion questions from the other side, like where is the business headed? What do you think? What do you think the revenue is going to be like, and such like? And that's always troublesome because that's not a document. And in theory, that should be covered by an interview, right? And maybe both
Yeah.
parties are involved, but that's always a troublesome one as well, because who knows? Those are opinion, right?
And then I had another one I little jotted down is sometimes information, like when they're asking for information that really is being asked for to provide corroboration that the financial statements are correct.
Yeah, that's an
Okay,
interesting, and sometimes that's fair, right? And
Yeah.
that goes back to your point, Paul, about do you trust the statements? And I don't know about you guys, but what percent do you think your files involve not relying on the statements?
It's a good question.
A lot, a fair amount,
Well,
probably.
that's sort of putting it in context too. Are we dealing with a small business, a big business? Do they have partners, not partners?
Is it audited, reviewed,
Yeah.
filed, Giphy, whatever?
Like if you have audited statements and there's a lot of partners and there's institutional investors, it really reduces the sort of the probability of there being personal expenses in there.
Right.
Versus when they solely own the business and they have huge amounts of, let's say, just looking at it, of promotion expenses or automotive or vehicle expenses.
Great.
Okay. Jason, I think you're up, right?
I think there was another poll, wasn't there?
Oh, okay.
Poll number 2.
Oh, yeah.
What is a reasonable amount of time to wait for disclosure in the audience's experience? I don't know if Daphne, if you can help us out with that.
Yes, that's right.
Daphne, who looks exactly like Russell. I'm shocked. Okay. Not sure if
The poll is running. I'm just giving the
Okay.
audience a chance to answer. Do you guys have it open, or would you like me to read the results?
Yeah, please read. I'm
Yeah.
not sure how to access it.
Yeah, absolutely. Okay, so what? Oh, no, that's a different poll. Sorry about that.
While we're waiting, I'll just maybe put a couple other comments to you guys or questions to you guys. So, in disclosure, I guess we'll get into talking about scenarios and adverse inferences in some of our discussions, but how to deal with the lack of disclosure, I guess we will get there.
Yep.
Okay, so what is a reasonable amount of time to wait for disclosure? 1 to 2 weeks, 18%. 2 months, 82%. 6 months, 0%. Anytime before next solar eclipse, 0%.
Is that a little encouraging, guys?
And I'm going to tie that answer into like the longer it is, like the harder our job is. Like you write a letter and then it sits on the shelf for 2 months or 3 months. And then you got to go back, you got to find out what's going on, and just runs a lot of fees and a lot of time.
Yep. So the next question we're dealing with is how long is it reasonable to wait for disclosure? So we've been talking about sort of what disclosure constitutes, but now it's how long is reasonable to wait for disclosure. And not surprisingly, I think we would all answer the same way. And it depends. It depends on a couple of things, right? It depends on, the scope of the engagement that we've been retained to do and the extent to which there are contentious issues that we have to investigate. Like, are we doing a quick high-level review of documents and then giving sort of some preliminary thoughts? Are we doing a standard report in accordance with the guidelines, or are we doing a forensic review, right? Those are each different creatures. Also, I think it depends on the complexity of the situation. Like, are there multiple companies involved? Is there a trust? Has there been a lot of tax planning things that have gone on? Capital gain strips, like complicated stuff that, may take some time. But I think if we're talking about sort of an average assignment, so not high level, not forensic, like, I don't think it's unreasonable to expect 2 to 4 weeks a response, maybe a month. I think the most popular response was 2 months. So maybe 1 to 2 months. I guess we have a subset question here. How many follow-up requests are reasonable before the expert should involve counsel? I think this is pretty common. It's common for us anyways, in that we provide an information request and we get no response. And so how often do we follow up? How frequently do we follow up to make sure that we're continuing to manage the process and move it forward, but still allowing a reasonable amount of time for them to gather the information? I'll typically follow up a couple of times, and if I'm not getting any response, I'll throw it back to counsel.
So Jason, I want to add a comment on that, is that even when I'm doing these kind of files, valuations, and it's my own client and it's non-litigation, they take time often. And sort of my sort of experience is, if they don't deal with it in about 10 days, like short of them being off work or their staff member, their key finance person being off, then they're not dealing with it. And then as soon as I send that reminder, we get an answer within about 48 hours. And the other one is, I find current year information. Sometimes it's not ready yet. So they hold up the whole process because we're waiting for the current year information.
Yeah. And
Often, go ahead, Melanie.
I was just going to say, further to that and further to Jason's comment about it depends. You often have to consider the factors. If it's a sole business owner who's trying to running around all over the place and maybe doesn't have a good accountant or a strong support network, you're going to have to wait, or you're going to have to help them out, or they're going to have to get someone to help them out. So that's often part of the reason, and it may be just they're balancing too many balls in the air, and it's not that they're trying to avoid disclosure, they're just having trouble getting to it.
Yeah, I agree with that. And I find oftentimes that when I'm working for the business owner and there is no pressure from the other side or deadline to work towards, I will not get a response from my own client. And I could follow up every couple of weeks, and it's just not a priority because it's not a pressing issue. So those are tough situations to manage.
But that's when you call the big guns like Russell and say, "We need your help. Write our client a letter."
Yeah.
Push 'em.
All right.
So we're on to
good. We're good with that.
We're on to the next
Want
next
to
one.
read
Is this
off?
Paul?
Yeah.
Number
Yeah.
7.
Yeah.
Sorry, Daphne, were you going to?
Yeah, if you'd like to do poll 3, we can do
Sure.
that now. So in your experience, how many requests are made before a full financial disclosure is completed? And I see some results coming in. So percentage wise, we have 1, 3%, 2, 42%, 3 to 5, 50%. It's climbing. People are still voting. It's climbing the numbers. And to the point, I think it is spam, 7%.
So I think the takeaway from that is that there's usually multiple sort of rounds of this.
And one thing I find with clients, whether it's just litigation, family law, or not, is that you have to get an understanding of your client. If you're the one making the request, get an understanding of what pushes them, and if there's a person, if there's a third party or like a support person that can help them out, or whether they're just the type that Jason said, you keep sending emails to trigger them, or whether a phone call. Sometimes just pick up the phone and call them, rather than sometimes people turn off their minds to email as if they're getting too many. And if you pick up the phone, that might actually work. So I think it's also understanding the client and what the best way is to get the information from them.
So are we up to number 7, which
Yeah.
is
Oh, yes.
what are the next steps if disclosure is not provided or not expected to be provided?
So I think of this as sort of we can either go in two directions. One is we push sort of the court to help us, right? Ask for disclosure. And I always go from a valuer's perspective. We just say, oh, can you make this happen? And then we sit on hold and somehow it shows up or it doesn't. And then, so that's the first one. So it's, there's some sort of motion. And my understanding is, and my experience is, generally the courts are pretty favorable. Like if we ask for something, the courts will compel them.
Mm-hmm.
And then if you don't get it, sometimes we'll get instructions that you're not getting it. Assume this is just finish your report with what you got. And, we'll have to caveat or qualify the report. It only bothers me when it's situations that it's sort of garbage in, garbage out. We know it's limited and there's a problem there. And we have to work around those situations. Like Melanie and Jason, thoughts?
Yeah, I totally agree. And that may be where you have to make assumptions. And I think we have to be careful of when we make assumptions and who drives those assumptions. And, the standards have tightened up, I'd say, and probably the court cases have too, say that maybe, if there's more than one reasonable assumption, then you get into scenarios and take off, we're not siding on one assumption per se, but if there's more than one, let's do it and let someone smarter than the experts decide on what the appropriate scenario is. So I think that has become a big, I don't know about you guys, but I've seen that as a big issue in the last couple of years, doing scenarios that are reasonable scenarios, not 300 scenarios, but reasonable.
Yeah, I agree with both of you. I think if disclosure is not being provided and we're asking for something, obviously we feel we need, if it's not being provided, I've been asked to make assumptions and draw adverse inferences. It could be with respect to, verifying or confirming share ownership. It could be with respect to assumptions around personal expenses or unreported cash income. But I have had to make assumptions and sometimes scenarios like you suggested.
Right. Now, I don't know about you guys, but when counsel asked me to make adverse inferences, again, that's a little discomforting because what does that mean, adverse inference? What exactly do you, and sometimes with adverse inferences, even if we can get direction on what that should be, don't you sometimes need some documents or something to go on, like as opposed to just picking something out of the air. So sometimes that's adverse inferences are a little problematic, but I don't know about your thoughts, guys.
I was gonna say is there's certain stuff we can't render an opinion. Like if you don't have financial statements, you can't render opinion. But sometimes you might be missing personal expenses is a great one, Jason, that you mentioned. But sometimes it's just not that, it may not be that material. Business makes a lot of money, and whether it moves 50 grand one way or the other, there are cases where there's hundreds of thousands of dollars of personal expenses, but typically it's not in that range. So if we're off, right, by 25,000 a year of income, it might not necessarily move the needle that much.
Yeah, good point.
So let's move on now. So what are we in, number 8? Okay.
So
yeah. So what if the requested or required disclosure simply doesn't exist or is not reasonably located?
So we're now at the point where we've done our gazillion request letters, and it's we either get the response, it doesn't exist, or someone says, let's stop it. We got to get a report out by whenever. You just have to move on. So there's lots of reasons why disclosure may not exist or not reasonably be located. It could be just due to the passage of time, like marriage date was 30 years ago and nobody keeps documents back then. Document destruction based on, you only have to keep them 6-7 years, and so that's appropriate. It could be I've had situations where the lawyer has died or the accountant has died, and the documents may exist, but no one can find them. And I've also had the situations where, my spouse took all the records, and it's his or her fault for that. It's like, okay. Or I just don't understand the numbers, or my partners won't agree to disclosure. So lots of reasons that it may or may not, but you have to get to that point where, like experts, we keep optimistically making requests to hope we'll get it eventually, but at some point you may realize not. So the first question is, as Jason alluded to, is how significant are those missing documents, or how significant could they be? Sometimes you don't know. Sometimes you can judge, sometimes you just don't know. And because it may be, once you have them, you can judge the significance. Sometimes you can't. But as Paul said, if it's a big enough company, there's lots of partners or audited statements. If you can't get GLs and supporting documents, it may not really matter because there's probably not a big risk there that the personal expenses are significant. So the next step, I think, when you realize is, can there be are there any other documents or anything else out there that can replace the missing documents? For sometimes I've been lucky enough where there weren't old financial statements, but there was a valuation done years ago for estate planning, and someone had summarized the statements around that date, so would use those. I mean, you sometimes luck into that. Or you don't have a breakdown of the historical management remuneration from the salaries and benefits expense, but maybe if someone happens to have kept their tax returns, and I've had shareholders say, well, there's 3 of us and we always took the exact amount, same amount out. If you can find one, then you might be able to multiply by 3 and you're good. But at some point, you have to decide if you can't find anything to replace, you got to decide how significant it is, and then whether there's a scope, a limitation that needs to be added to the report, whether assumptions can be made, or whether scenarios can be utilized, or whether you can't even render an opinion. So the exposure draft I'm talking about, we've always had this issue, maybe not issuing a report, but I think the practice has generally been, even if it's potentially significant, we've rendered opinions and made assumptions. But the exposure draft, the CBV exposure draft, is really saying that significant scope limitations must be identified in a prominent manner in the report and adequately explained, setting out the reasons for the limitations and their potential impact. So a lot more transparency, and that's exactly what the standard said. They want more transparency on these things for users. And then the exposure draft also requires that any scope limitations that are significant to a degree that they're likely to jeopardize the opinion, the conclusion, evaluators can't issue a conclusion. So that right now is something that a lot of evaluators are saying, oh, I'm not sure quite how to deal with that in some cases. So it's going to have a little bit of time to wind through, and evaluators to figure out what that exactly means, and if we have to stop issuing conclusions in some cases.
Melanie,
Yeah, I've
go
had
ahead,
to
Jason.
say for marriage date valuation situations, if you don't have financial statements for the company at that time, I can't do a report. I just can't.
Yeah, at our marriage date, we often can support the book value, but then we can't do what we can't normalize, because we don't have any information about salaries, personal expenses, non-recurring events. Like, the records just don't exist. So you can kind of get an answer, but it may be understated.
But at least it's something, right?
It's something, yeah. And it sort of works, it almost works against the party that's asking you to do the date of marriage.
Right.
The date of marriage credit is being understated. My sort of takeaway is there's always more we can have, but if we have financial statements and we don't think that there's a big gap in our normalizations, right, that we're missing because we can't get the source documentation, then we're kind of in the ballpark. But if we have the exact, you can always search for more documents that may create evidence that will change your opinion.
Right.
And I'm going to give a perfect example. We start off and we usually assume that the financial statements are correct, and we don't delve down into what's on the balance sheet. But maybe there's an inventory problem, that if we could get a whole bunch of inventory source documents, and we think there's an inventory problem because one of the partners said there is.
Mm-hmm. Yeah.
So I think maybe we should move on just because of timing. So order on number 9.
Mm-hmm.
Yeah.
So Jason, I'll read this for you. What if the client is a minority inactive shareholder and is uncomfortable getting other shareholders and staff involved in his or her family matter and requesting information documentation?
Yeah, this is a good question. And it's one where I don't think you can use the excuse, well, I'm only a minority shareholder. I don't have access to the information. I can't provide it. I don't think you can use that excuse, or sensitive information. My other shareholders don't want it out there. I don't think you can use that. I think that there's an expectation and a legal requirement to provide a certain level of disclosure if you're a shareholder, even a minority shareholder. And I mean, correct me if I'm wrong, but I think minority shareholders are legally entitled to certain financial information or disclosure about the company.
There's one thing I'll just mention here. I saw an OCA case come out recently that basically says if you're a minority shareholder and haven't followed up historically, you're subject to the statutory limit, whatever it is, 2-year limitation. So that creates an interesting thing. So what if it's someone who is minority and hasn't requested financial statements historically? They may only be entitled to go forward information based on that case.
Yeah. My view is always too bad. You need to provide it. But I have had files or situations in the past where it's become a real issue and it's become a legal battle between counsel, between the sides on the sensitivity of the information and redacting certain information and providing information. And ultimately, I guess the parties have to agree, or a court will step in and provide a motion on. Yeah.
I think this is a case where a court can be really beneficial. Like,
Yeah.
I'm the majority shareholder. I have a 12% minority shareholder who happens to be my sales manager, and he wants this, this, and this. And sometimes you don't know what's going on behind the scenes, whether it's wink, wink, like make it difficult. As soon as the sort of majority shareholder sees a court order, they're usually more likely to comply and be cooperative.
Yeah.
Right.
Yep. Yep.
No more polls, right, Melanie? We're good with that?
No, I think we're done with polls.
Yeah. And then I think we got one more. So someone want to read off the question?
Yeah, I can read number 10. So what if the business owner is concerned about sensitive information, privacy, confidentiality to the former spouse, to the general public, if the matter is in court, etc.? Paul, any thoughts, comments?
Yeah. So I think this is a really, really fair comment for people to make. One of the things I like to say is we are all, the three of us and all the lawyers, we're all governed by professional confidentiality.
Yeah.
On top of that, we have, it's in the engagement letters, like that we'll keep everything confidential. We have a lot of stuff that comes across our desks that we keep confidential and we don't talk. So sometimes the parties just don't know. They don't know that. So it's like, it's good to tell them that and give them some comfort from that perspective. I don't think I've ever been asked for an NDA in a family law. Actually, probably have, but it's pretty rare. And often in my
I have too, but it's rare. Yeah.
And in my corporate work, sometimes they ask me for an NDA and I'm like, you don't need one. I'm not going to say a word and we're governed anyways.
Yeah.
And half the time that makes the request disappear. Like people just want to hear it. And once they sort of hear that, they get a little bit of comfort. Next thing is I wrote down is sometimes they want confidentiality from the other spouse. Like they're competitors in a way, like, like they both are in the same business doing something now and they're competitors. So I've seen where there's agreements, like we can look at the documents, but the spouse can't look at it. I've sort of seen that come up. I've seen redacted information, but I find that we often have a lot of, like when it's redacted, there's a lot of back and forth that goes before that's produced. And so those are sort of the major ones. Like I think it's a fair comment. We will keep it confidential. Once it gets into court, like we can't help them there.
Yeah, I agree. And I've been asked to do NDAs in the past. So I think depending on the industry, also of the individual we're valuing, they may be more sensitive. Like the tech industry is more sensitive to NDAs, for example. But I always remind them that we're all subject to the rules of confidentiality for clients, which doesn't necessarily cover the other side, but of CPA Ontario and CICPV.
Yep, agreed. I think it's a good incentive to use collaborative or mediation instead of being litigious and going to court.
Or arbitration too.
Yeah, arbitration will get them that protection. So Daphne, I think we've come to the end,
Any
right? And I think we're
questions?
running out of time now. Yeah, any questions?
I just put into the chat that case I mentioned about the limitation periods for minority shareholders, OCA court case Lagana versus 2324965. Interesting case. It just came out recently that I don't know if it'll affect what we do in family law, but it might in other areas as well.
Interesting. Thank you, Melanie. I'll be sure to provide that in the YouTube description for everyone watching. In a few moments when the session concludes, you can access the case there. We did have an audience question come in. If we review the documents and those are part of our scope of work, how can we keep it away from the other spouse?
You can't.
No.
Yeah, you guys said you can't.
Can't, no.
Well,
No, if
that's
it's
the
in
only
our-
one is if you don't want the other spouse in, I think you need an agreement up front before we get it. And even
Yeah.
then, I don't even know, like maybe customer names, I think that would probably work, but to keep the financial statements out, I'm not sure that would work even.
Yeah.
Yeah, anything provided to us that we rely on for preparing our report that gets listed in our scope of review. I mean, when we provide a report, we're always asked to provide the scope documents because the other side's entitled to them.
Excellent, thank you. One more came in. What is the absolute minimum disclosure you need to complete a business valuation or income assessment?
Do you want me to do this?
Two
Why don't
words?
you do income
Sure.
Two
first?
words? It depends. Yeah.
Yeah,
No, but I think the bare minimum is we need to see the financial statements.
For
like in
sure.
tax- And for
For sure.
guidelines income, the personal tax returns. If
For
you
sure.
just don't have the personal tax returns, it's a made up number.
yeah, yeah.
And another one here as well. How do you respond when the other party is requesting disclosure that feels excessive or irrelevant?
Should I take that? Because I
Yeah,
covered that in so you guys feel free to add in. I very carefully, I mean, I prefer this to be the lawyers responding to this as opposed to me as an expert saying another expert is asking too much. If it's not an expert asking on the other side, then someone who isn't experienced with family law, that may be a different issue. But I would prefer I'm not asked to write letters to say it's excessive, but I might give comments to the lawyer that says maybe this is an area that doesn't need to be reviewed because it's insignificant, but most of the time I find other experts' requests are not unreasonable.
I always tell my clients when they're provided an information request list from the other side and they want to get my thoughts on is it reasonable, I always say, I mean, to the extent that it's available, it exists, and it's easy for you to access, just give it.
Mhm.
Just give it. If it's something that you think you'll have to search for, you'll have to create, it doesn't exist, then just be truthful and just provide that as a response.
Yeah, it's our job's a lot easier when they say we're not providing this because it doesn't exist or it's not applicable. Then we just think they just ignored us, right? And you, Jason, reiterated on it. Does it exist or does it need to be created?
Mm.
And I think that actually reiterates or reinforces one good point is that it's a good idea for counsel to get the experts involved initially on the request and maybe help with sometimes it's experts request another expert understands the request better than someone else. So if you get the expert to help out fulfilling the other expert's requests, I find that makes things run a lot smoother and less suspicion sometimes that one of the clients are trying to hide things. And we speak the same language, so it often is a lot easier that way.
Thank you. We have just a minute left, so just a couple more audience questions if I can get them in here. So this one is, due to information limitation, if we cannot issue a conclusion, can we then issue a letter of information received with the facts of the documents without any implied conclusion to assist court?
I don't see why not. We're basically saying we didn't issue an opinion and here's what we're missing. I think we do that a lot.
Excellent. Okay, I think that wraps up our session today. So thank you so much. I just want to express my gratitude to Paul, Jason, and Melanie for sharing your time, expertise, answering audience questions. I think it's been a really helpful session. So thank you so much to all of you for your participation today.
Thanks. Thanks everyone for listening.
Thank you.
Thanks for having us.
Okay,
My
bye.
pleasure.
Perfect. Thank you.
And to our audience members, feel free to take a quick break and we will resume at 11:45 with Power, Protection, and Prejudice, a women lawyers fight for justice with Sandra Fava and the Honorable Thomas B. Manahan. This upcoming session has been accredited for 1 hour of EDI professionalism content. So we will resume shortly in about 15 minutes.
fighter. Slightly inspired. Fight.
All right, welcome everyone to Power, Protection, and Prejudice, a woman lawyer's fight for justice. My name is Michelle Mulchan, and I'm your host for today. I am so excited to be here, and I'm so excited to have these two wonderful colleagues here with us. So this session has been accredited for 1 hour of EDI professionalism with the Law Society of Ontario. So after this session is done, you can go ahead and input that. As well, all resources mentioned today will be included in the show notes, which you will receive via email later this week. So as I said, my name is Michelle Mulchan. I'm the senior managing lawyer at Russell Alexander Collaborative Family Lawyers. I've been practicing family law for over 15 years. I'm telling you guys my age in this. And I specialize in divorce, custody, access, property division, child and spousal support, FRO enforcement matters, and a host of other issues. My focus is on creating comprehensive, creative resolutions for family law matters. And my specialty is helping clients deal with complex financial issues that arise as a result of separation. With me today is the Honorable Thomas Manahan. Mr. Manahan is special counsel at Fava Law. He's a retired judge of the New Jersey Superior Court Appellate Division, and he brings over 40 years of legal and judicial experience focused on mediation, arbitration, appellate matters, and legal strategy. As well, we have Sandra Fava. Sandra is the founder and managing partner at Fava Law in Morriston, New Jersey. She guides individuals and families through life's most challenging transitions with empathy and strategic counsel. And she serves clients across Morris, Essex, Union, and Somerset counties. So just a high-level outline of what we're going to talk about today. So first, we're going to talk about a personal entry point in Sandra's story. I'm very excited to hear about that. Then we're going to hear about gendered power dynamics in custody battles. The third topic is the invisible abuse, coercive control, and legal systems. Then we're going to hear about cultural competency and equity in family court. Then we're going to move on to bias in legal decision-making from judges to experts. Then we're going to move to professionalism and protection when the lawyer is also a survivor. Then we shall move on to the role of female lawyers in systemic change, and then trauma-informed practice in family law. Lastly, we're going to talk about strategies for equity-centered advocacy and a call to action for the legal community. So take it away, Sandra. Can you please tell us a little bit about your story?
Sure. I'm very excited to be here today and to be speaking with all of you. So thank you very much for joining us. I am a first generation child here in the United States, here in New Jersey. My family emigrated from Italy when I was very young. I was also what we call a whoops baby. So I have a sister who is 13 years older than me and a brother who is 9 years older than me. And I am the first in my family to go both to college and then to go on to law school. And I had known from a very early age that I wanted to be an attorney, largely from television shows that I really enjoyed watching, as we had no other, point of reference for me. Particularly, these were both Judge Wapner, which I don't know if that was aired there in Canada, but also Ally McBeal as I got older. Yes. And I really had this idea that I was going to practice international corporate law. My father, as a child, my father had his own business and I could speak a few languages. And thanks to Ally McBeal, I enjoyed the idea of traveling and having this sort of jet set lifestyle. However, when I was probably at the end of my middle school tenure, about to enter into high school, one of my family members, one of the first, went through a divorce. And at that time, New Jersey did not have anything in place that helped families in transition move through the legal process with some sort of effectiveness or timeline. That has since changed. We now have a statute that does require certain things to happen, and we have programs in place for people going through the system, but at the time it didn't. So this individual spent about 5 years litigating in family court for just to be able to, establish a custody and parenting time plan, as well as equitably divide assets and address the issues of spousal support and child support. Unfortunately, though, this family member was also a victim of domestic abuse. Again, with many families, this was hidden, so nobody knew about it until it was disclosed. And then when you go back, having hindsight as 2020, you kind of could put the pieces together of the puzzle. So for example, New Jersey, we have very warm summers, a lot of humidity here, and this person would come during the middle of the day and always have long sleeves and long pants on. Their spouse was a heavy drinker, very well known throughout the family, particularly at holidays or celebrations. But, everybody kind of thought that they were what I would say is a happy drunk, not realizing that that would change often when they were alone in private. So those are some of the signs that happened. So this was all very, very new for the family to understand and to grapple with. But I remember very poignantly it impacting me in seeing how long it took to kind of get some answers and to get to the finality of things, as well as the emotional impact it had on all of the family, not just the individual going through the actual process. And so I tucked that away in the back of my, pretty young adolescent mind and moved on through life, and really thought I would never practice family law almost as a result of that. However, when I was in law school, there were a couple of events that seemed to just keep happening, even though I was actively trying to avoid family law. One, for example, was that I needed some credits over my first summer after my first year of law school, and the only thing I could get into was the family law clinic, which at my law school and many schools here in the US, we have clinics that are set up in law schools where students are supervised by professors who are licensed attorneys, and they are able to appear in court on various legal issues. In particular, my school had a family law clinic. And so I worked with a victim of abuse who had fled from their country, was here under asylum, and it was an international child custody matter. And so that was that. Then again, as I returned from my second year of law school, one of my mandatory classes was family law, so I took that. Then in my following summer, I worked at a firm. I was recruited, and the partner who was my supervisor was assigned a pro bono domestic violence matter. Here in New Jersey, we are asked to do certain pro bono matters. Some of them, mostly they are either landlord-tenant or domestic violence matters. And my supervising attorney literally said, I want nothing to do with this, figure it out and tell me where I have to be and when. And so I was working on mass tort litigation. This was very different. This gave me human interaction. It was very personal. And so I did that. And it seemed in retrospect that the universe was sending me multiple signs that perhaps this is an area of law that would be good for me. And so I kind of at some point succumbed and really leaned in to the practice, both in my clerkship, which is where I met Judge Manahan while he was already a sitting judge in the family court. And then later on, as I pursued my legal career. And so having that experience really made me very sensitive, not only to the domestic violence issues that are very pervasive in family law matters, regardless of education, wealth, socioeconomic class, religious belief, ethnicity, none of that really matters. At the end of the day, this is a pervasive problem. But it really seemed that I could, because I had a personal experience and really understood it as a third party, but firsthand, I could really work with people and provide the sort of sensitivity and guidance that I think are needed when you're dealing in family law matters. And so that is kind of how I got into this practice area. And 21 years later, here I am.
Thank you so much. That's such a great story. And, I would be willing to bet that a lot of family lawyers have some sort of origin story like that. I have a similar one in my family. So it's such a pressing need to have lawyers who are trauma informed, who understand the system, who understand IPV issues, things like that.
Yeah.
All right. So thank you so much. Why don't we move on to our next topic? Sandra, I think you're going to talk a little bit about this, about gender power dynamics and custody battles.
So I'm not sure how the history of the law there in Canada, but as I said, when I first started practicing family law, there was really I'm not going to say a bias, but a general belief that if you were a mother, particularly a stay-at-home mother, that you would have a better chance of obtaining a greater amount of custody or parenting time if you were divorcing. And I would say that in my first 10 years of practice, that started to evolve, where that was becoming less common. And the research from the experts, the forensic child psychologists who perform for us the best interest evaluation, because New Jersey's standard, like many states here in the US, is the best interest of a child standard. It really became prevalent that some of those preconceived notions needed to change, because there were, in fact, more and more dual working families here. Women were not typically staying at home. And in fact, we were having a growing rate of stay-at-home fathers, and we all needed to kind of get up to the times as they were evolving and changing. And so that happened. And I would say that now we are in a place where there are many judges who believe, without having any sort of expert opinion, but they will start from a bias that both parents are entitled to access to their children. And in some cases, some judges will start from the basis that both parents are entitled to equal access to their children. And you, as the attorney or the litigant, have to demonstrate that the other party, the other parent, should not have that type of access, which is not the standard, but it has become a very, I think, unfortunate, commonplace position that judges will take when they are assigned to a matter. And this leads to, I think, a lot more litigation, a lot more, at least, where I practice, lawyers advising clients very strongly that they do need experts, because the expert is the one who performs the forensic evaluation and does the psychiatric and psychological testing and the observation of the parent-child relationship, and delves into the dynamic between the two parents as to whether or not co-parenting is possible. As many states have, New Jersey has, as part of our statute and case law, certain things that should be present if there's an expectation or an order that parents are going to co-parent a child or children. One of those very basic things is the ability to communicate with one another. And that is oftentimes, particularly when you have intimate partner violence, and other types of psychological or psychiatric issues, including substance abuse issues, simply not possible at the time. Not to say that that couldn't change at some point, but generally at the time, it's just not possible. And that really is the foundation from a lot of the background and research about having a co-parenting situation. So I find in my practice that it has become much more difficult, because there is this unspoken bias where parents, especially where there are dual working parents, that there should be an equal delegation of parenting time or custody, and you have to demonstrate why that would not be. And for many families, these experts, particularly here in New Jersey, there are but handfuls of experts who are qualified, who have been vetted, honestly, both, by the way of their written report, their deposition, and their actual in-court testimony, to be the people that you would want to work with if your client is going to invest, tens of thousands of dollars oftentimes in this process. And there are oftentimes other biases that come into play from the family court perspective. So here in New Jersey, we do have a part of our family courts that specifically only address domestic violence proceedings. And if there is a final restraining order or final order of protection, as many other states refer to them, that does provide a basis that the protective parent or the victim should have a presumption that they should have primary custody. And it is a rebuttable presumption, which means the aggressor can, in fact, demonstrate that, they should have more access to a child. And there are many judges who will say, well, after hearing after having a full hearing and hearing testimony and from both the litigants and witnesses, and perhaps even having some documentation in the form of evidence, will say, well, everything you've just explained to me, counsel or party, is really an issue between you and your spouse. And none of this violence has affected or been perpetrated upon your child or children. And so where I think we are is really needing to provide education to our judges and our judicial staff and to other attorneys about what this research shows, that children who grow up in homes where there is, in fact, domestic violence. And, we know that domestic violence takes many shapes and forms, right? It's not just physical abuse, it's coercive control, it's verbal abuse, it's emotional abuse, that those children are, in fact, victims, and they are, in fact, highly impacted as they develop and mature and go on to become adults, and how they then behave in their own intimate personal relationships. And so I think that we are still really working towards providing that type of education to the people who have the power and the control over these things. Family law, for all of us who practice, it is a very emotional area of the law, more so than many other, if not most other areas of the law, regardless of where you practice. And a lot of times, judges who are trying to, make difficult decisions, it is, I'm sure that Judge Manahan will say this to you, and I'm sure he agrees with me, that it's very difficult. It's a heavy burden to have to make decisions that, for someone else's family, and to be able to be unbiased and feel that you are doing the right thing, particularly when children are involved. And so a lot of times judges who feel that pressure, and there's a lot of different reasons why they may or may not, or what level of pressure they feel in this regard, they often want not to hear the drama. They want you to tell them, why you think they should do what you're asking them to do based on the law of your jurisdiction. And the story that helps you explain things, there is very little, and again, this is what I found, there is very little patience in hearing that. And I think that where that becomes difficult is where you have a situation where there is coercive control. That is recognized as a type of intimate, partner violence, but it's very difficult for most people to demonstrate that. And you can't just do it with one example, right? There's not just one police report that's going to say, I came to the house and, the victim had a bruise or was bleeding or there was a scratch. It's often much more subtle and it's much more pervasive over a period of time. So I think that that's where we need to provide much more education and understanding why these pieces of every litigant's story are relevant when you are tasked with the decision-making power.
Thank you so much, Sandra. What such great points. I'm really interested to hear, Justice Manahan, what your thoughts are on cultural competency in family law and your experience.
Well, first, let me, if I may, I'm here to present the judicial point of view, but that does not mean that I turn a blind eye to those aspects of decision-making that are in many times hidden. And I'm referring specifically to some implicit bias that a decision maker has. And that's something that needs to be recognized at the outset. When we're dealing with cultural competency and equity in family court, the first step is to make sure that you as a judge are not influenced in any way by those factors, certainly not cultural competency, and that you as a judge, and being aware of that, you must engage in a self-critical analysis to make sure that your decision is based upon the facts as you find them and the law as it should be applied without any preconceived notions. I was going to mention this again in the topic of bias in legal decision making, but this is a good point to start. As a litigant, just as an advocate, what is paramount when you're appearing before a decision maker is that that decision maker is a neutral, that they are objective, that they do not have preconceived notions as to how the case should be decided. But as human beings, it is vital for the decision maker to recognize that your decision could be influenced by a bias, and it could be a cultural bias, and it could affect an equitable outcome. So I think the key word here for judges is to be aware personally of how their own life's history, their own experience, their own background might in some way, and I say this in a polite way, infect the decision-making process. So that's pretty much it in terms of this topic. But again, it's an awareness. And I'll just add this too, and Sandra certainly could echo this, I'm sure. And I remember this as an attorney, because long before I was a judge, I was a practicing attorney. One of the most difficult aspects of a practice is to make the argument that the judge is biased or predisposed. And as difficult as that is, because sometimes the conflict may be a financial conflict, it may be something involving a family member of the judge. But when you're making the argument that a judge should recuse themselves because of a bias, that's an exceptionally difficult argument. And so it is incumbent upon the judges to recognize it and not wait for an attorney or a party to make that argument and put you in an uncomfortable situation.
Absolutely. Have you had any examples of this happening, and especially with marginalized families facing double standards? Because I know I see it all the time in my...
Yes. I think that when a judge is faced with a very important decision, which is custody of a child by a parent in New Jersey and in New York and in many states, and I don't know what the law is in Canada, there is, as Sandra mentioned, a statute that provides equal rights of a parent to parent that child. Now, does that mean that the parent should have co-parenting time or equal parenting time? No, that's on a case-by-case basis. But I will share with you, I had, when I was in the family division many years ago, I had a case in which the father was alienating the child very clearly, and trying to disrupt her ability to have a relationship with her mom. Her mom, unfortunately, had some addiction issues. She had spent some time in custody, but she had done her time, had gone through treatment, and wanted to re-engage with her daughter. And the father just blocked it at every step. And it could have been, I'm not saying it's easy, but it could have been the easy path to say, well, mom, you really haven't had a good relationship with your daughter for a few years, given your own issues. No, the point is that the mom had a right as the mother to parent that child. So, but you can also see it sometimes with, here's a sad footnote. The father, we ordered reunification. The father, unfortunately, became ill and passed away. And but for the reunification, the mother and daughter never would have had that ongoing relationship. So particularly judges, you have to be careful about gender stereotypes. And one quick way I'll mention it is that, and Sandra mentioned it, that there is this sort of double bind that women face. They're sometimes viewed as the nurturing parent, which is maybe, but if they're working, sometimes they're viewed as the less nurturing parent, and the fact that they are employed is held against them. So I just think that it's something that, again, judges need to be aware of through a self-critical analysis.
Thank you so much, Justice Manahan. And Sandra, I'm sure I'd love to know if you see this in New York, because I see this where I am. But, you talked about the cost of having these professionals come in and the tens of thousands of dollars. There are a lot of clients who just can't afford that. And without that secondary piece, without a professional saying, hey, there is an issue here, you can have a ton of evidence. But, judges will sometimes default to the 50-50 parenting. Do you see that in your jurisdiction as well?
Yes, absolutely. And while we have some every vicinage, or that's how we're separated in our courts here in New Jersey, they do have programs where people can get either income-based experts or virtually free experts who will serve either as a joint, they work as part of our judiciary system. However, even for those underserved members of our community, right, that oftentimes means arranging for childcare or taking off from a job that they desperately need, and having resources or the ability to get to and from these places that for these meetings and appointments, because we know evaluations are not done in one day or one meeting. It often happens over a period of time. So, those people in particularly are severely prejudiced and impacted. And it's easy for the rest of the world, or, to say, well, if this was really important, you would get there. But that's not really realistic. And I think that there's a disconnect oftentimes between understanding that even in cases where there may be like average or, middle income parties, if you're in a situation where, you're a spouse, oftentimes a woman, and you don't have a name on a bank account and money's been hidden from you or moved, and all of a sudden the car disappears and you've got $50 to your bank account and all the credit cards are shut down, you have a lot of hills to climb to try to get back on par. And that costs money. So you're racking up a bill trying to get back what, may rightfully be yours. And then you have to make even more efforts to go and even get this, this additional help or services that you need, because otherwise you are going to be dismissed in what you say, even if you have documents or some sort of evidence that you could present on your own. And it's like this with experts, I think, in other areas of family law. My favorite are the clients who said, well, I made an Excel spreadsheet for that. and it's a, complicated financial issue. And I'm like, great, are you a forensic accountant? And they'll say no. And I say, okay, so you can send me that and I will use it internally, but you still need to go ahead. And they don't understand that, they're like perplexed by it. And they think that like, sometimes they ask if we're trying to like, if we're going to get a cut from this person or if there's like some sort of benefit that financially will trickle to me. And it's not the case. It's just, this is the reality. And for the underserved, particularly in the areas of intimate partner violence, if you have it available to you and have not already watched it, Netflix made a movie called Maid, M-A-I-D. And while it may be triggering, because I've had clients tell me that it was very triggering for them and they couldn't watch the movie, it is a very, in my opinion, accurate depiction of what underserved people really face, particularly women, when they are in the process and going through the system. I think that there is a lot more bias. I think that mothers who are trying to be protective are often viewed as mentally unstable. And again, if you are someone who is already a victim, so your self-esteem is, invisible or non-existent, and now you have the system that is supposed to help you, telling you things like, we don't believe you, we're not going to help, we can't do that, what you're asking, it's not going to happen, go figure it out. People oftentimes will do very drastic things because they don't know what else to do. And they are really in fear of their safety or their child's safety. And it becomes, honestly, this snowball effect. And what I see is, again, that we're really missing the right type of education, again, to the people who operate our court systems and who are our judges who are making decisions and our attorneys who are, working with these families to really understand that this is not just like every other case. You have to have a heightened level of understanding when you are working in this area.
I absolutely agree. And it's a fine line, exactly as you say, between, trying to show a court that there's a systemic issue here versus having the courts disbelieve a client and believe that they're being emotional or irrational in the things that are, that women face and those terms that women face. I can tell you, I had a client a couple of years ago, and it was really sad because she went to the police multiple times. And, it was a young officer she kept getting, and he did not understand. He did not understand. He kept asking her things like, why didn't you do this? Why didn't you, why didn't you change? And she tried to explain to him, look, I have no money. I don't even have a car that's in my name. Every single penny I get is from him. It's not easy to walk away with 3 little children when you have no funds. And so, we had to escalate that to the supervisor, who thankfully had a lot more education and said that they would educate that officer. But it led to a re-traumatizing of my client, saying,
Yes.
he doesn't believe me. So what can I possibly do?
And it's those clients, who I think end up staying in these relationships because they don't feel like they have any other choice. And sadly, sometimes end up dead because of that, because they have that feeling, not because they didn't understand that there was something wrong, but because the system in many situations can be so broken and you can become so defeated that, you don't have, you feel like you don't have choices, or it gets to a situation where things escalate to such a situation that, something tragic like that happens. Similarly, I've had cases where, in the area where I live, there's affluence, certainly, and I was working with a very affluent family, 7-figure income, home worth, 7 figures, children attending all sorts of activities and events. And my client was a victim, and the court did not believe her. Luckily, I had an expert who was a specialist in intimate partner violence and really understood coercive control. And so my briefs were, yes, they relied on law, but they also were like encyclopedias for those, binders, let's call them full, of psychological and psychiatric studies and research and data, because I really felt that the judge that was handling the case, at least initially, had no understanding that, no concept that this could be a real thing. And, while we have Child Protective Services, even that organization was inept at finding the problems that, to me, were so obvious when you looked at the circumstances, but they did not do it either.
Absolutely. And as you said, it's hard enough when there's physical violence, because sometimes people can write off bruising or cuts as, oh, she fell on the stairs, or oh, she did whatever. But financial abuse, it's very difficult to see. And you do have to have resources to some extent, or a judge who really gets it and is able to look at this and say, yeah, I understand. I understand why someone would not have them. So, Sandra, can you tell me, so because of your history and your experience with this in your family, how has that changed you and your, balancing your personal experience with your professional responsibility?
Yeah, I will say that definitely took some time for me to learn the balance. And there are even matters now where I have to remind myself of the boundaries, because and I first started out, I was definitely very passionate and fiery about helping these victims and, getting them what they need, and took it very personal if I was not able to do that, as a personal failure. And over time, I have learned to have more balance in that, and to realize that, listen, are there certainly victims out there and people out there, like we've been talking about, who are victims of the system and of abuse? 100%. There are also a smaller, I think, group of people who, we have buzzwords in the legal profession, right? Everybody's a narcissist. How many times a day do you hear that on a phone call, right? And so you have to be, as the attorney, as the person that they're coming to, and frankly paying for guidance, to say, okay, is that really what's happening? Or do you have someone that you simply no longer get along with, right? Or you've grown apart from, or has changed a bit, and not just using words lightly. I say this often in court: words have meaning. They matter, right? So you have to kind of be that person, especially in your professional capacity, to listen. I think listening is hugely important for family lawyers. And then assessing, okay, what's happening here? Triaging almost, right? What level are we at? Where are we in the process? How is this affecting everyone? And then working from there. At the same time, though, having that experience, to me, I think, has made me adapt quicker, on the learning curve, if that makes sense. And I think that a lot of times, clients feel heard when they work with me. They feel, and I think that's what people want in family law. They want somebody to listen to them, to hear them, and to provide them the appropriate guidance. And sometimes my guidance is, I think you need to be in therapy. And here are, people that I think will be very helpful to you. I think you need to have a better understanding of your finances, because this is not abuse. This is simply somebody who believes, for whatever reason, that you are not able, or you have not taken an interest in your finances. So go educate yourself and work with, this person. So providing resources and being able to parse through the information, I think, is something that my personal experience has helped me develop, and is a continued reminder, honestly, of what I'm doing and why I'm doing it, and how to best help individuals.
Thank you so much. Yeah, I agree with so much that you're saying. And even though we are in different jurisdictions, I'm seeing so much similarities between, our systems and the flaws with it. So saying that, what do you think the role of female lawyers are in systemic change and moving this? I don't know about you, we still have a judiciary that is, a large percentage of males. A lot of our newer judges are, female, also people of color. And to me, I think it's so important to have representation across, especially in family law, because it's important for me to be able to see, both sides and to have that lived experience. But what do you think in your, in your jurisdiction and in your experience?
Yes, I agree. I think that where I practice here in New Jersey, we still have, I think the primary number of our judges are male. There is definitely systemic change that has been trying to be implemented. So here in New Jersey, our judges are not elected, they are appointed by congressmen in their counties. And so there are women and men and women of color that are being appointed to the bench, and I think that that is the right step. But I think that there are other pervasive factors that impact everything in our day-to-day lives, right? So our overall political process and where we are today, here in the US, where I don't think it's a secret that, we have a lot of divisiveness in our politics. And how does that shape and trickle down to these local, my county, which is how our Superior Court, which is our lowest level of, let's call it state court, how those are operating, and, how that affects litigants and women. I can tell you a story that, probably about 5 years ago, I was in the middle of a trial and my adversary was a counterpart, a similar age, but a male. And we were in the we were on trial and the judge wanted us to come back on Halloween. And I, politely asked if perhaps we could not use that day. And it was only going to be a half day because I had young children and they were in a parade, et cetera, et cetera. And the judge looked at me and said, well, that's just too bad. This is your job. And until my adversary said, well, Judge, I also have child commitments that day, which was untrue. He did not have children. But he took one for the team, which I call a mally. Can we not use the day? And then without even saying another word, the judge is like, okay, no problem. And I've been in courtrooms, I was in a courtroom and I had a female judge and I was 7 months pregnant and I had to walk out of a courtroom because I needed a break for lunch and she did not want to give it to me. And I said, well, I'm leaving. I'm sorry. I'm going to faint. I have to go. And I took that risk. And I think that sadly happens pretty often, where still you walk into a courtroom as a young professional woman or as a professional woman, regardless of your age, but there is a preconceived notion about you dependent on your, let's be frank, your looks, your physical appearance, the way that you dress, the way that you speak. And if you are there with, a counterpart that is male and that is more relatable to the judge that you are in front of, I can feel it every time I'm in that courtroom. And I can know without question that I am a far better attorney. And it almost doesn't seem to matter. I have to work so much harder on a basic issue. And I think that, and I don't know about the statistics in where you are, but here, 50% now of our law school graduates are women. So we are graduating a lot more women into the practice of law. However, we still have very low percentages of women who become partners and even equity partners in law firms, by and large. So women are still generally still leaving the practice earlier than their male counterparts. But I still think that there is a lot of bias that we need to work on it. And, and I've talked to other women who look like me. I've talked to other women of different, economic or cultural backgrounds who, often will say, you think you have it tough, imagine me. And I believe that to be true in many situations, sadly. And
Yeah.
it trickles down to the litigant, right? If you're the attorney and you have the education and the license to back you up, imagine if you are the litigant and you're coming there.
Absolutely. And I have a similar story to you where in court, I told a court that I wasn't going to be available for a certain date. And, when you're at the podium, it's this high, so they can't really see much. And the judge asked me why. And I said it was a medical issue. And the judge asked me in court, well, what's the medical issue? And I looked at him and I said, I just was like, took a step back. I will be giving birth around that time. I cannot commit to a court date at that time. And, the judge was very nice. As soon as he understood the issue was fine. But even the idea of asking someone what that medical issue is, while, pregnancy is not something that I was scared of telling people about, there are other things that could be going on in someone's life. And imagine if that's how a lawyer is treated, how a right? At least we do have some level of deference. All right. Well, thank you so much. Tom, would you mind telling us a little bit about strategies for equity-centered advocacy and things that you can suggest to our
Sure,
team?
I will. I just want to, I'm not looking for equal time because I think that what Sandra said is absolutely accurate and unfortunately absolutely accurate. And even though judges in New Jersey and in other states receive training now on bias recognition and bias spotting, it still is very individualistic. Some can choose not to do that. I just thought of when I heard both of you talking about your situations, your medical situations, that as a judge who presided over jury trials, which we do not have in family law, and I think a lot of judges would have benefited from having to deal with jurors and jury selection, in which there's a strong emphasis on bias and the lack of bias, but also how we deal with jurors when they ask to be excused. We don't make them stand up in open court and give us a reason that could embarrass them. We bring them up to the bench. We'll even go off the record. Certainly that was my practice, and ask them confidentially what the problem was so that they would not be embarrassed or would not feel singled out for any of those things. And that's just all part of training. And it's necessary. I'm glad to see it's taking place. There still are gender stereotypes. There still are, particularly in domestic violence cases, there could even be in a very invidious way where a judge may require extra proof or corroboration that this has taken place. That's not required. It's not required by the rules of evidence. It's not required by the Domestic Violence Act in New Jersey. But sometimes judges do that. And so I can understand the frustration of an attorney, particularly a female attorney, who feels that not only are their clients not receiving justice, but they themselves are not being treated professionally as they should be. So that's personally disturbing to me. But getting back to your question about the equity-centered advocacy, first, I think there has to, like anything else, there has to be an acknowledgement that there are flaws in the family law system, in child welfare, and even mental health systems. And I just want to take a quick step backward, because in family law, as much as any other area of law, we rely so much on experts. It is incumbent upon the judge, as the finder of fact, to be able to recognize bias in the experts' reports, not just the attorneys to draw it out if it's there, but for the judge to recognize it as well. And it is there and it exists. Not in every expert, but certainly in some, and that's something that's important. So we need to acknowledge that. We have to emphasize, particularly as judges, that there is fairness and equity in the system. And how do we do that? We do it by our demeanor. We do it by our rulings. We do it by the way we conduct ourselves. One of the most difficult aspects of being a family law attorney is trying to deal with individuals who are in crisis. They're angry. They might be looking for validation. They might be looking for vindication. They have been physically abused, emotionally abused, perhaps. And they have to deal with that. And then they go before a judge who their clients believe is unfair or not impartial or is not listening. It's very difficult. You're doing a lot of damage control out in the hallways and back in your office. So I think that there has to be an emphasis on fairness, and that's from everyone, particularly from the bench side. Attorneys and judges as well need to build trust through communication, through clear communication. Attorneys can use court proceedings, motions to ensure voices are heard, but we have to recognize that there is this issue of bias, and it's inescapable. And we do not and should not make decisions based on anything but the facts and the law. And that's easy to say, but it's a little more difficult to implement. So strategy is training. Strategy is recognition, awareness, and a strategy then, of course, is to act upon that to ensure that every person who appears before a judge or in an adversarial proceeding feels as though they've been treated fairly and equitably. And even though as decision makers, we might believe, we might even be deceiving ourselves. We think we're fair. We think we're doing a good job, and we need to really be conscious of it at all times. Anyway, that's pretty much what I would consider to be the appropriate strategies for equity-centered advocacy.
Thanks so much, Sandra.
And for judicial rulings.
I really appreciate it. Sandra, do you have anything that you would like to suggest as well?
Oh, okay, just wanted to make sure I could be heard. Sorry about that. I do. I think that we, as part of our continuing education, need to speak about these issues and bring them up. I think that there's oftentimes, at least from the attorney's perspective, you don't want to make the judge you're going to be appearing in front of upset with you. You don't want to offend them. You don't want to anger them, right? They are humans after all. And so, while they are trained to be unbiased, there are certain circumstances. And I think that by having these conversations and having this type of education be a part of all of the other training that both lawyers and attorneys receive regularly, I think that that is the way that we're gonna change these biases and these issues that we're talking about here today. It's difficult, as Judge Manahan mentioned earlier, extremely difficult to get a judge recused based on bias here in our jurisdiction, here in New Jersey. However, and nobody wants to have that one-on-one with the judge who's presiding over your case or your matter. But if we have more education, more of a conversation, I don't know how it is, again, in your jurisdiction, but I'll use an example that I think we can take from. Since COVID, mental health issues for practicing attorneys and judges has become a very front and center conversation, both in continuing education, but just as a general part of the practice from both our local and then our overall state bar association, programming, etc. And I think that what we're talking about here in this particular area is something that we also need to do. And perhaps it is, by lawyers sharing their individual stories, because I could write a book, and I'm not being funny here, about the times that inappropriate things have been said to me, about the times that it has been clear that bias has been shown against me for one reason or another, gender, medical issues, just a dislike of me, perhaps. Some of them are just unexplainable. And I think that you share, my husband is also an attorney, and I will tell him things, and he is in disbelief. He doesn't practice family law at all. And he jokes and says, what kind of practice is this? I've never heard of these things before. But it's real and it happens. And I think that the only way we really make a systemic change is by that we all talk about it. And whether it affects you or not, if it has never affected you, great. You can still help talk about it and bring about change for the people that it does affect. And whether that be other attorneys, again, or, your clients particularly. I mean, we talked about it previously, but the bias that men face in domestic violence court, if they are the victim, is astonishing. I mean, it is terrible to be anybody in that courtroom. Nobody, I think, wants to be there. But if you're a male and you're a victim of abuse, particularly, coercive control or verbal abuse or financial abuse, you have to say many a prayer before I think somebody can really take you seriously. And that is really, it's much more common than it was, again, when I first started practicing this area of law. So, there's that perspective as well that we need to address.
Absolutely.
Michelle, may I just add one? I'm sorry to interrupt you. May I just add one more? This is following up on the difficulty it is with attorneys to address the issue of bias with the judge, certainly one-on-one. I think what would be an effective strategy for any jurisdiction would to have we'd have bench bar conferences where these complaints could be brought, or criticisms or thoughts could be brought up in a general sense, not a particular sense, not directed at any particular judge or any particular instance. What we do is we train in silos. We have attorneys that train and go to continuing legal education, and we have judges that go to continuing legal education. But sometimes we don't think about that. It would be how effective it would be to have these joint conferences where there could be interaction. It could cover a lot of ground and could also explain, perhaps from a judicial perspective, why certain things that were perceived to be bias or prejudice perhaps were not. And similarly, a judge in the audience could listen and say, oh boy, I hope I'm not doing that, or, oh, I never thought of that. But to have these conversations separately, both attorneys and then judges, it doesn't serve really an effective purpose. And it might help to reduce this issue. And I agree with Sandra, by the way, in the bias against men in domestic violence cases. But it helped to reduce these issues and certainly increase awareness. And I think that is very, very important to do so. And if I may, this is my final note. We do have available here, this is not a plug, by the way, we do have alternative dispute resolution, and sometimes these matters through mediation or even sometimes through arbitration outside the courtroom in a different setting can be resolved, and clients can get a feeling that they've had a full and fair hearing or an opportunity to be heard. So that is a forum that is encouraged in our jurisdiction. I'm sure it's encouraged in Canada as well, but I believe it is a very effective way to deal with a lot of these issues. Frankly, to sit in a conference room or to proceed through like today through a Zoom, I think it's less likely for the mediator or the arbitrator to engage in that sort of bias. I just do, personal thought, but I just do. So that's a very effective way of dealing with some of these issues, but it is not the way to deal with the issue.
And I think that really sums it up, that it's not a one size fits all. You really have to have a very client and family specific approach to each and every single file. And, one other thing I would love to see is a bit more collaboration between counsel I have a file where there is very, very, very clear financial control to the point where mom has no funds whatsoever. And the opposing counsel still insists that, there have been criminal charges, there have been breaches of the criminal charges, and counsel still can't wrap their mind around the fact that there are domestic violence issues at play here. And, while I understand that our role as counsel are to represent our client, I also see part of my role as representing the children. And while if I truly think that my client does have some problematic tendencies, I also think that my job is educating, counseling, therapist, whatever resources I can give that client so that they can understand their role in this. Because, I always use an example in my own family life where we've seen the long-term impact on children who are, victims of domestic violence, who witnessed this, whether or not they were directly, abused, or the effect on their lives of seeing abuse or seeing things like this. It's truly got a massive impact on those children for their life. And if these parents really cared about their children, they'd want what's best for them at the end of the day.
Yeah, I would agree with you. I think that that's a comment that I've heard the entire duration of my professional life about professionals. I think it's there's a lot of reasons why attorneys are less collaborative in certain circumstances, that we could probably do another seminar just on that type of thing. But I also, just as a final point is, when people are looking for attorneys and they're interviewing, these are the things that they need to be asking, or you as the person, need to be asking them if they're willing to hear, there are some matters where I'll say to somebody, I will help you, but you must be in therapy. And otherwise, I just don't think this is going to work, because I know that there is just, bigger issues than the legal issues at play as well.
Excellent. Justice Manahan, I don't want to exclude you. Any other final thoughts as we wrap up our session today?
No, I'll just ponder the eloquence of Sandra's statement. I'll end it with that.
We both will. Well,
Thank you.
both. This has been absolutely wonderful. I greatly appreciate your time today, and I know the audience does as well. We truly appreciate you both coming and talking about your perspectives. Justice Manahan, I can tell you that we don't get that access to our judiciary and to our bench in Ontario, where I'm from. So, having judges on our panel is a rarity, and we really appreciate it. And Sandra, hearing your story, giving us that personal perspective, being so open and honest with us, I learned so much today from you, and I can't thank you enough both for being here today.
Thank you
You're
for
welcome.
having us.
To echo what Michelle has said, thank you so much to the Honorable Thomas V. Manahan and Sandra Fava for sharing your experiences, personal stories, and shedding light on the legal systems in both New Jersey and Ontario. A quick note for the family lawyers that are tuning in from Ontario: the session that you just watched was accredited for 1 hour of EDI professionalism content. If you are enjoying the summit so far, please give the video a thumbs up on YouTube. We do have a lot of educational content on our channel, so you are welcome to explore over the lunch hour. Please do subscribe and click the bell to be notified when we upload new videos. And we will now head on into the lunch break. So feel free to stay on the video. We will resume at 1:45 with managing tough collaborative practice files and taking a compassionate and strategic approach. This session will be moderated by Jane Ha, Natalie Derbyshire, Cindy Shizman, and Matthew Krofchick, and has been accredited for 1 hour of professionalism content. So thank you so much to our panel and to our audience, and we will see you back here at 1:45.
inspired.
Slightly inspired. Fight.
I'm gonna get a. The hardest thing is to get started. You have to get.
Let's go back.
Hello, everyone. Welcome back from lunch. Hope everyone enjoyed the hour break. So we are going to get started with the next session shortly. We're looking at managing tough collaborative practice files and taking a compassionate and strategic approach. This session is going to be led by Jane Hood, Natalie Derbyshire, Cindy Shisden, and Matthew Krofchick. And just a reminder, it has been accredited for 1 hour of professionalism content. So without further ado, we can get started with this session. Jane, Natalie, Matthew, Cindy, thank you so much for joining us today for our 4th annual Family Law Now virtual summit. We are so grateful to have you donating your time today.
We're happy to be here. We just need to wait for Cindy, though. I think Cindy is on her way. We just saw her.
Okay, sounds great. You're looking nice and cozy by the fire, Natalie.
Yes, I said to Jane, this is where I would like to be. So mentally, this is where I'm putting myself.
Yes, I love it.
A virtual fire is probably not quite as good as a real thing, but you do what you can in these situations.
It's got some ambiance to it, right?
It's true. It's true.
Can Nicole call Cindy? Maybe she's having a little bit of a tech issue.
Yeah, for sure. Will you?
Oh, she seems to be on. Cindy.
Is she here?
Here.
Awesome.
There we go.
Awesome. Cindy, thank you.
With the link.
Okay, awesome. Thanks so much, Daphne. Okay, let's get it started. Okay, so again, my name is Jane Hall. I am a family lawyer who has always practiced collaborative family law. And I am a senior associate at Russell Alexander Collaborative Family Lawyers. This presentation is called Managing Tough Collaborative Practice Files and Taking a Compassionate and Strategic Approach. So in CP process, what we strive for is a customized, flexible process. And for those of us who went through CP training, we've already learned this. What we learn while we're practicing, though, is how to adapt, really adapt to the unique challenges of every file. The assumption we're making here today is that most, if not all, of those who have joined us have had their basic CP training and that they've had some files, maybe some tough files that we're going to be referencing today. We will be discussing some unique challenges without specific client information, of course, that each of us have faced and the lessons that have stayed with us. So we as CP practitioners who've learned to adapt to challenges, we're going to be talking a little bit about ourselves too, to make sense of our own experiences, because we're all people with very unique skill sets, some flaws, and distinctive styles. We're here to have a frank discussion about what each of us can bring to the table when things get tough. So now I'll ask each panelist to please introduce yourself and say specifically what your distinctive personality is in terms of how you practice. So Natalie, can you start us off?
Absolutely. Hi, everyone. I'm Natalie Derbyshire. I'm a senior associate at Russell Alexander Collaborative Family Lawyers. In the past, I've served on 2 different collaborative boards, that of Toronto and York Region, and I was called to the Bar of Ontario in 2006. I've been practicing collaboratively since 2011. My strengths as a collaborative lawyer are, I believe, that I listen more than I speak. I'm an empath and I'm highly intuitive. Knowing the facts of the case, I find is, of course, of importance, but navigating the emotions of the clients and anticipating their reactions is what's important, in my view, to understand the likely trajectory of the case and it's paramount to devising a strategy and canvassing sound solutions. I double majored in sociology and law and society at York University, and the bulk of my elective courses were in psychology. I believe this gives me a bit of an edge in understanding the family dynamic and identifying triggers that may hinder or facilitate settlement. I bring compassion and heightened awareness to issues of disability, mental health, and intimate partner violence. Over to you, Matt.
Thanks, Natalie. My name is Matthew Profchik. I'm a business valuator and accountant. I'm certified in financial forensics, and I have a designation from FIDRIO, meaning that I specialize in family and estate cases. I am the chair of the Family Dispute Resolution Institute of Ontario, and I sit on the executive of the Grey Bruce County Collaborative Group and a member of the Toronto Collaborative Group. I've done numerous presentations to OACP and OAFM, and my role in this whole thing obviously is the financial side. I'm doing business valuations, income valuations, and tracing assignments for collaborative files. My big focus is always settlement. That is what my end goal is. I'm always trying to figure out what is the best that we can do to get the clients to the end. And the end is a settlement where people can continue to move on. I believe in trying to minimize the trauma to families as much as possible. So really looking at what is important, not just doing work for the sake of doing work. It's about doing good work, and not just doing good work as in getting the numbers correct, but doing good work as what do the family actually need as opposed to what do they think they need. And so I like to really focus in on that. Jane mentioned something about flaws. I don't know what that's like. I'm perfect. At least that's what my wife tells me all the time. And so, it's when we're dealing with families in these situations, it's about, as Natalie said, listening and understanding. And that gives us some empathy to help drive these families in the right direction. Jane, why don't you tell us a little bit more about yourself?
Okay, a little more about myself. After taking a course on collaborative law at Osgoode Hall, I knew that that's what I wanted to do. So CP is what I've been doing since I was called to the bar, which is why I don't ever have hesitations about advising clients that a collaborative process is the way to go in most files. I would say as a CP lawyer that my strength, in my humble opinion, is that I'm able to see perspectives from different angles simultaneously. I think it really is an ability that I attribute to somewhat of a disability, that is of having some ADHD, therefore being a nonlinear thinker, which I admit used to hamper me, but now I've learned to harness it, incorporate it as a skill in life, and in particular to practice CP effectively. In addition, I identify someone who is kind of direct in communication style. Not that that's always a good thing. Unlike Matt, I can acknowledge my flaws, right? And I think it's not always a good thing because sometimes the other lawyer may not appreciate what they sometimes think is demanding. So I often have to check myself using I statements just as we coach our clients. I would say I also bring an extra sensitivity to EDI issues, and in particular LGBTQ issues, to my files because one of my kids identifies as being part of that community, the LGBTQ community, which I want to embrace and celebrate. So that's a little bit about me. Cindy, please tell us a little bit.
Last but not least. So I'm a psychotherapist and I have a master's in clinical psychology from U of T. And the focus of my master's degree was on family dynamics and child and adolescent development. I also trained in basic and advanced mediation skills. I took that training with Barbara Landau many, many years ago. I was also a professor for 16 years. I taught psychology and sociology at both Humber College and at Seneca College. And that gave me not just the academic knowledge, but the way I related to my students and listened to my students. I had many students who would come and talk to me about interpersonal issues. So that enhanced the skills that I bring to my role as a neutral family professional in the collaborative field. I have practiced for over 35 years in psychotherapy and specifically over 10 years in collaborative practice. I was the former chair of York Collaborative Practice, and I currently sit on the board of both York Collaborative Practice and Collaborative Practice Durham Region. And I'm also a member of the Ontario Association of Mental Health Professionals. And I champion for mental health initiatives and taking the stigma away from people with mental health challenges. And I bring that perspective into my work as well. When I'm working with families, I work with parents in helping them create parenting plans that focus on the needs of their children. You know, I have a philosophy that a child has a birthright to have a healthy, loving relationship with both of their parents, regardless of how their parents feel about each other. I coach parents on how to effectively co-parent for the sake of their kids, and I support the difficult emotions that clients experience as they navigate through the separation process. How do I describe my personality? I'm very caring, I'm very warm, I'm compassionate, but I'm not fluffy. So, which means I'm able to have the difficult conversation with a client to help them move forward in this process if I need to. I can, with care and compassion, help them understand where they are stuck. And I think having sometimes a little bit more of a direct approach serves our clients best. That's about me. So as we're moving through this program, first question that I want to ask is, what is the one big difference between collaborative practice negotiations and negotiations in a litigation context? And Matt, I'm going to throw this question over to you to answer first for us.
Sure, thank you. So my experience is obviously quite different than maybe Jane's and Natalie's as being a financial neutral. So when I'm hired in a litigation context, sometimes it's jointly, but often it is not. So when we're negotiating, likely there's another valuator on the other side of the table. So right then and there, you've got positioning on the valuation side. Even though we are supposed to be independent experts, it just comes with the territory. And so when we're in a CP file, it gives us much more flexibility than when we're in a litigation file. So what do I mean by that? Firstly, we're looking out at what is going to help both parties. Right? In a litigation file, that might not be the case. I might not even have any information related to the other party whatsoever. So how are they going to fund the EP, for example? That's something that we may end up helping them with. I'm looking for options in that. You know, are they going to go to their RSP? What is available to them, and how are we going to do this? We're in the same room, right? So we're having a conversation where it's not just necessarily siloed like it generally is in litigation negotiations. We're in the same room, and the parties can ask me questions at the same time and hear my answer to both, to their questions, their lawyers' questions, and the other side's questions. We have a pre-meeting. We get to discuss these things amongst the professionals generally and say, what are the areas of concern that we should be looking out for? How do we want to necessarily not script, but direct the meeting to help best suit this couple that's going through this? You know, we're always looking at the situation from a much broader lens, whereas when you're in a litigation focus, it's really, what have you been given? What information do you have about this client? What is it that we've been told? How do we write our report based on that? And then what are we showing up with? And so if you can imagine where you have two valuators who have been given two wildly different set of assumptions, you're going to have two wildly different reports. And sometimes you have reports that are just completely not based in reality, but that's what a evaluator has been given and asked to assume. And, you know, the justification might be there for that. Whereas in a collaborative approach, that tends not to happen as much because both lawyers are there from the beginning. And they get to say, okay, well, these are the assumptions that we're going to make, or here's the situation. And while we might do an A and B scenario, it really gets rid of this valuator said this and that valuator said this, and it brings down the temperature in a lot of negotiations. Jane, what's been your experience with this?
Well, in my view, the difficulty in collaborative negotiations as opposed to a litigation negotiation, from what I hear and what I experience, is that there's no real playbook here. I have a colleague, for example, who only litigates even though she's been trained in CP, because she says she doesn't know what to do in a CP file. There are no specific collaborative family law rules as there are in litigation. And she's right. There are no specific rules, only principles like transparency and guidelines regarding like respectful communication, for example. So the big difference, in my opinion, is that if you practice CP and you want to get good at it, you have to continuously learn through training and practice, being really mindful of the particular CP negotiation context. So of course, in any negotiation context, it's very important to build a good rapport, first of all, with everyone you're dealing with. In CP context, this means the other CP lawyer and the neutrals, your team, as well as the other spouse. To do that, I think the most important thing is to approach every dialogue with empathy, which I understand to be the ability to see the world through other person's eyes. For example, the lawyer on the other side. It's important for me to be able to understand who they are, which informs, after all, how they are looking at the issues. More specifically, for example, to see whether that lawyer will respond more readily to a legal model argument rather than one based on an equity principle or an emotional argument. And if you have determined that the lawyer will respond better to a legal model argument, you have to frame the issues of your client within the context of the law, even if it's at minimum just a reference to the law. That way, if your argument makes sense to the other lawyer, that lawyer will be more inclined to bring it to their own client and work with you on that issue. So to give a more specific example, if it's an issue around entitlement to spousal support and my client is the party seeking support, I wouldn't be saying, well, it's only fair, or that my client will be upset, because that may all be very true, but it's not going to have an impact on the other lawyer. So I will instead apply my client's specific circumstance to legal entitlement bases, whether compensatory or non-compensatory arguments, and do a lot of calculations maybe ahead of time to show different scenarios to the other lawyer. That way there is more likelihood that my client's interests will be heard. Of course, what you are also trying to do at the same time, however, and this is very important, is to keep in mind that the other lawyer also has to serve their own client and respond to their own client's interests. Because in the end, there is no settlement if only one person gets their way on every issue. Cindy, what do you think is a major difference between negotiations within different contexts?
So for me as a family professional, first of all, I'm a neutral and I am jointly retained by both parties. I work for the family. I don't just work for one side against the other, which tends to be what the litigation model prefers. And I have the benefit of speaking to both parties. So when it begins and when I'm retained, I will conduct an intake, a confidential separate intake with each person, with each client. And these will occur before a full team meeting. So I speak to the clients about their goals, their interests, their concerns. I screen for if there's any kind of serious challenges, and I'll get into that in a minute. And then once I've had this meeting with the clients, I will then schedule a professionals meeting with the lawyers and the financial professional. And in that meeting, I will catch them up to what I've heard from the clients, where there might be some challenges, where there might be some concerns, where we might run into certain blocks because of the way a client is feeling. And that way the team can strategize on how we're going to approach this file, and we're going to design this file to best meet the needs of this family. So as was mentioned earlier, collaborative practice process is not a one-size-fits-all. It works to meet the needs of the specific family, and us as the team of professionals will guide what that will look like. In my intake meetings, I am able to identify where there might be certain triggers that might impact the process. For example, if there are infidelity issues, if there is some financial disagreements. Different parenting styles is a big one when it comes to talking about parenting plans and schedules, different views on best interests of the children. Every parent tells me they love their children and they want what's best, but then they have a very different definition of what that might look like. I also, in my intakes, screen for concerns such as power imbalances, intimate partner violence concerns, drug and alcohol issues. These challenges do not necessarily exclude a family from participating in the collaborative process, but they do need to be addressed. And this is where the professional meeting prior to a full team is important, because then I can catch the team up to what they need to be aware of so that we ensure that the safety needs and all of the needs of the clients are protected and that we're able to move forward in a way that serves the best interest of this family. Once I begin working with the clients on a parenting plan, I do this offline. I don't do this in team meetings. I do this in separate meetings with the clients outside of the full team meetings. And I emphasize to the clients that it's the parents who should be making the decisions for the children. It's your children. You should be deciding how you're going to continue parenting them post-separation. In the litigation model, you have a stranger, a judge, who doesn't know the family, doesn't know the children, doesn't know the backstory. Because they're going to turn around and make these decisions for what the family's parenting plan is going to look like moving forward. I work with the parents on building trust, learning how to co-parent, to put the emotional, physical needs of their children as a priority in all agreements. I also work with families where there are no children. And the benefits of the family professional on this the benefits of family professional in this is to address fears tied to money. So we do know that there are a lot of fears in and around money. Collaborative practice is more of a flowing process, whereas court is more black and white. It's based on law rather than the needs of the family. It's a win-lose process. It can trigger conflict, anger, and resentment, and the parents lose their voice. In collaborative practice, parents still have a voice. The clients still have their voice.
So we'll move on to the next question.
Do you want me to jump in there, Jane? I didn't contribute yet.
Yeah, please.
Okay, thanks. So for me, I would say I find that CP negotiation takes the pressure off of people, which is fantastic because they tend to make better legal decisions when they're not under pressure or feeling anxiety or stress. That's not to say that the collaborative process means that people don't have the jitters or nerves when engaging in negotiations, but I think that they feel more comfortable overall with the setting and the protocols. And that's because everything within the process is without prejudice, with very minor exceptions, which I won't get into. And CP to me is like an open-handed game of poker. I explain it to clients as a very open, honest, and transparent process that's based on interest-based negotiation as opposed to rights-based negotiation. And clients tend to like it because they're able to be creative about the solutions that they formulate, and they maintain control over the outcome, much like Cindy just mentioned. The other great thing is we can be out of the box in terms of what we come up with and brainstorm for the family. It can very much be custom-made solutions. So for example, we can put funds that would ordinarily be paid to one spouse in a legal outcome in court, instead apply it to an education savings account for the child. That may be one type of compromise. Or instead of selling the home, there may be feasible solutions for a buyout of the home if there's a deferred sale, flexibility in paying installments, or a vendor take-back mortgage, for example. CP ultimately allows for brainstorming as a team, and it avoids pitting spouses against one another. And it also helps people co-parent down the road together by improving their communication skills. So Jane, I have a question for you. How do you work with counsel of different experience and perspectives in CP?
Oh, wow. That's a big question. So I've been on files where maybe in the beginning there was little or no trust with the other lawyer. I mean, you're both retained, so you have to work together, but you're trying to sort of figure out, how to navigate sort of the negotiation process that we were just talking about. And sometimes there's a little bit of awkwardness for a variety of reasons. One might be because for the other lawyer, it might be their first CP file, for example. And some first-time collaborative lawyers I found tend to question everything. For example, they might say, why do we need a financial neutral when, my client is very savvy with numbers? So something like that. And I think that in general, when I hear questions like that, it's sort of a mistrust of the process and not seeing the value of professional neutrals. And that might just come from a feeling they may not be able to protect the interests of their own clients if they're not involved directly. So if the other lawyer has this sense, it's also hard for that lawyer to persuade their own client to retain a neutral professional. They might also be thinking that their client will not want to spend the money on a neutral when in fact, a neutral professional often saves clients money in the long run. We see this all the time. But on the whole, I have to remember I've been there too, where the new CP lawyer is when I was in the earlier stages of my practice. And I have to keep this in mind what I've learned throughout though is to trust the process, trust my team. And the most important thing I can do in a scenario with a new lawyer is sort of to be steadfast in my responses, be patient, and also recommend oftentimes to the other lawyer that they seek the opinions of other collaborative professionals that they trust. That way they don't have to take my word for it when they're really looking at me as the opposing counsel. I always keep adding to my personal database senior practitioners who are willing to mentor and have offline conversations with new CP lawyers. That's the other thing I should mention for all of us. I mean, I think our collaborative community is very strong. I know that, for example, I can call Matt anytime and he's going to get on the phone with me like quickly to give me a quick answer. Cindy as well. So that is something that is very, very rewarding in this kind of practice. Nonetheless, sometimes there are challenges between two lawyers because you just don't see eye to eye. And, although we're professionals, we all have some personal differences. And in this scenario, I have to keep in mind that it's a question of two different approaches and not one of being right or wrong necessarily. So by way of example, I was recently on a file with a very experienced CP lawyer. And on that file, I try to insist on a particular neutral to join that file. And my insistence, no surprise in hindsight, was met with resistance. Yes, it was partly because trust hadn't been established yet, but also because I was insisting on one person. When I spoke with a friend, senior CP lawyer, they told me that they always recommend more than one neutral as a rule because nobody wants to be told what to do and there needs to be a choice. So in my mind, I was only insisting because I thought that was the best and most efficient way to proceed. But in the end, I learned to let go of it. I also made sure I communicated to the other lawyer that my communication style on this issue wasn't meant to be disrespectful in any way. So you have to be fluid in how you're navigating every circumstance. Natalie, how do you handle working with different counsel?
So I try to stick to the Four Agreements, which is a book that I once read by Don Miguel Ruiz. The first rule that I stick by is do not make assumptions. This one is pretty key because I've made that mistake in the past. I try to remind myself that my client's perspective is not their spouse's perspective, and maybe I know things that the other counsel doesn't, or vice versa. And so it's always good to ask questions, particularly when in doubt. And it's also good to be open to new perspectives. I try to be very open-minded. It's good to share past experiences, particularly in collaborative practice, and discuss our concerns and hesitations as a team. This ultimately, I feel, enables us to be more proactive instead of reactive. The second rule I live by is to avoid taking things personally, because we all come from different experiences and backgrounds, and it's really easy to misinterpret what somebody else is saying. So, in order to try to get on the same page with somebody, I try to listen, as I said before, more than I speak. And I remember that there's always more than one way to slice a lime. As a third rule, I know I must be impeccable with my word. It's really important to manage not only the expectations of our clients, but also the expectations of the team. So I try to undersell and over-deliver. I know I can't control my client. And so if I don't know that they're ultimately going to follow my advice, I try to make the team aware that there may be some hurdles that we have to face. And by having our team members aware of that, we're in a better position to pivot when necessary. And then the fourth rule is always try your best. And I do think as collaborative practitioners, thankfully, we do strive to do our best for the families that we're serving. Trained collaborators, I found in my experience, are highly collegial with one another and ultimately want to model best behavior for our clients. The best part of CP is that we can rely upon our team members to troubleshoot and also think of things that may not necessarily be at the forefront of our minds. So I'm so happy to lean on my interdisciplinary team members, the family professional and the financial professional. PTO meetings are also critical. These are professional team-only meetings where we're able to advance different ideas with one another, check in, and make sure that we're all in a good frame of mind. And debriefing is also, I feel, paramount for us to be able to support one another and keep up the momentum on the matter. Cindy, what are your thoughts on this question?
So, we all come to our teams with different experiences and different perspectives and different ideas. Having the PTO at the start of a file is key on learning about each other, asking questions, understanding the differences we have, and then creating mutual trust and respect for those differences. Sometimes as a family professional, I find that my role entails managing these differences within the team. So bringing together where we have common ground is important. And then also understanding how these differences might be a challenge. Sometimes I have to have, and I have found, have to have confidential meetings offline with a particular professional because of the differences. And then talking about how do we strategize? How do we manage this? How do we go forward? What needs to be said? Is it a joint email that needs to go out? Is it mine bringing up a certain topic at the next PTO meeting? That we can address these issues so that we can support the family that we're working with. Another key tool, and you mentioned it a little bit, Natalie, is the pre-brief and also the debrief. So pre-brief is the meeting we have before a team meeting, where we strategize, we set the agenda, we talk about what we want to accomplish. We as the professional team talk about our goals and interests. And the debrief is, how did the meeting go? What did we do well? What could we have done better? And then creating strategies for how we can do better in the next time, because we can always improve. Open and respectful communication is essential to identifying and addressing these different perspectives and finding the solutions. It's also important to recognize that each team member adds value to the process, regardless of our experience. We can all learn something, regardless of how long or short we've been working as collaborative professionals. And Matt, what are your thoughts on this?
So I look at it, I do a fair amount of litigation. And so I always am kind of looking at one to the other. And the nice part about CP is that generally, not always, but we get to know each other through collaborative events. And so right off the bat, it helps break that tension, right? For the most part. And so I find that it allows me to be flexible in how I deal with situations. So have I met this person before? If not, obviously I'm introducing myself. It's about being adaptive to them and understanding their background. And so if we have a practitioner who has just come from the litigation world and all of a sudden they're starting CP, they might not be quite as comfortable in the team setting yet. So it's about letting them maybe catch up with the rest of us who have had more experience with that. It's about being adaptive, but providing my input, right? I'm there not to be a yes person. I'm there to provide my input on these things and make recommendations as needed. Do we need to do this work? What years do we need to review if we're looking at income? What's the relevant purpose of this? Do we need a forensic tracing of some sort? What's the outcome that you're hoping to get? And talking through with them. And so sometimes when we start a file, we might say halfway through, you know what? We don't want to look at that anymore. That's not as relevant as what we once thought. And so we'll switch and we'll change the scope. So it's about also being flexible in how we approach these things and not being so rigid. And that goes for how we deal with lawyers with different experience. We all may have dealt with things where it's very straight and narrow and it's always this way. And then sometimes we have to be able to pivot and turn. And so it's being responsive and understanding the communication styles that everyone has. Some people love to be, I want that follow-up every week. What's going on? Tell me, ask me for that information. And there's other people who are, leave me alone. I will get to it and you will get your email. So it's about understanding the different perspectives of counsel and then trying to adapt to that, but at the same time, trying to push the whole process forward as best we can. So that's from the lawyer's perspective. Now, from the client's perspective, how do we navigate a difficult situation? So Cindy, why don't you go first on this one?
Thank you. So I'm often able to ascertain how difficult a file might be from my intake meetings, because again, I'm able to understand a client's goals, interests, and concerns. And I share this with the team so that in a PTO, we can preemptively discuss how to address this if it does arise. In team meetings, I always set up breakout rooms so that I can have a confidential and supportive conversation to understand why a client is presenting as challenging. Sometimes it's just myself who goes into a breakout room, myself and the counsel, the financial neutral as well. But again, the breakout rooms give the client a safe space, a confidential space to talk about what's troubling them, what's triggering them, what's causing them to appear challenging, and to feel heard. Because for clients, feeling heard is one of the most important aspects of this process. If a client feels they've lost their voice or don't have a voice, they will shut down. And when a client shuts down, that's going to make them appear to be challenging, and it doesn't help the file move forward. Outside of team meetings, I will schedule one-on-one meetings with a particular client, again, to give them a confidential space to talk about a concern, whether it's concern about what's being discussed, a concern with another professional, or just a concern about the process itself. Once they feel heard, they're able to talk it through, they're able to understand somebody else's perspective, they often are able to come around and negotiate in the team meeting in a very effective way. If there are children involved, helping clients stay focused on their kids and on best interests of their children is one of the key ways of reducing some of the challenging moments in these files. Discussing parenting time and to a lesser degree decision-making creates a lot of difficult emotions for most parents. Helping them feel that their voice is heard and that they will be able to make better decisions for their children moving forward often calms them down. One of the things they find hard is that they know that post-separation there are going to be experiences with their children that they're not going to be a part of. And it's those emotions that sometimes get in the way of helping them achieve some certain results and settlements in the file. If clients are unable to accept my recommendations, I will reach out to their respective counsel and the rest of the team for support. Addressing challenging clients is a team effort. It's not just on one person. We are all part of this to help the process move forward, and I look to my team for the support in this endeavor. Natalie, Can you guide us through your thoughts on difficult or challenging clients?
I'd love to. Much like you, Cindy, I encourage triad meetings. If there's an issue that arises or somebody can't seem to accept a proposal or solution that's being put forward, I want the client to be able to canvas issues openly with the neutral. Often there are questions that I don't know to ask, frankly. And so by having a meeting with you or with Matt to maybe explain, hey, why does this make sense in the financial report? Or, how did you come up with this figure? Or what formula was applied? Or in Cindy's case, why is it that you feel this is in the children's best interests? That can be a conversation that is very eye-opening, because although I may think I'm asking the right questions, often it requires the expertise of the parenting professional, or the financial professional to give some insight and hopefully shed some perspective on the situation. I write reporting emails to my client so that there's a solid record of my advice that I've provided. I actively listen to my client and I do acknowledge and validate them whenever possible and appropriate. But I also acquaint my client with their BATNA, which is their best alternative to a negotiated agreement. I aim to understand my client's hesitations and reluctance, where they're coming from, and hopefully get to the root of the problem. But I also give them a cost benefit analysis so that they're understanding the estimates of the costs moving forward and how much any particular position might cost them if they were to withdraw from the collaborative process. I think it's important for them to understand the raw financial implications of being intransigent. By managing expectations from the outset, there are fewer surprises for the client, and ultimately, I do find we can usually get over those hurdles. Matt, what do you do to navigate a difficult situation?
Yeah, I would say first and foremost, it's about listening. It's finding out what the situation is. Why is there this difficulty? Is it a mental health issue? And I should say that's another difference between maybe a litigation and a CP file. In a litigation file, I might not find out that there's a mental health issue. But in a CP file, I would more likely than not find out about it and find out about it earlier. So what is the driver of this difficult situation? Is it something related to my work? Is it something related to something else that's going on in these people's lives? So once we find out what's really going on, then the question is, how do we address it? Is this a situation where we need to apply a little bit of pressure? They're having a really hard time with disclosure. Can we talk to their accountant? What other services can we provide to move them forward? Is it that they don't understand what I'm asking for or why we're doing this? Is there an education piece that we have to provide? Do we have to sit down and say, the reason that we do the support calculation is because you have to pay child support? And not to say you don't want to, but this is just part of the process. And we need to know what your true income is because what you've written down on your tax return is not what your income is under the guidelines. And so there's always this piece of education that I might have to do for people when they kind of reach this point. It's steering them in the right direction, saying, okay, now you've told me what the problem is. Let's find out what we really need to do. And to Natalie's point, there's a cost benefit to everything that we do. Is it worth going back a few more years and looking at income? Is it worth doing forensics? What is it that we're trying to achieve? And how much is it potentially going to cost you? And what's the benefit that you're going to get from it? We need to potentially provide options. Okay, you've said that there is unreported income and other spouse say that there's none. And before we undertake a very expensive review, why don't we talk about what options are available to you so that we can get this done in a timely manner and not cost a lot of money compared to doing a full forensic review over many, many years. Really, at the end of the day, we want to try steering them to settlement as much as we can, get our report done as fast as possible, not because we just want to move on with the file, but because that's the benefit to the family as well. The longer these things drag, the harder it is for people sometimes to settle and get to that point. So, it's identifying, listening, and then providing options for them, and then trying to get them to that end point. Jane, how do you deal with these difficult situations?
So all of those things are so important, Matt, and all of the things that Nat said and Cindy. I think for me, I have to always remember to be respectful. So to be very respectful to our clients' choices, no matter what the situation is. So sometimes we do have a client who's not able to accept the recommendations of the team, though. And yet, of course, we have to be respectful of their choices. But at the same time, we have to figure out what to do about the process. So when the file is not going smoothly, we do have to try to intervene. That's what our PTOs are for, to figure out what the next step is. And it helps if we can do it as early as possible. So knowing how early, I think it's a tricky thing. It comes from experience. And even with experience, you may not always get it right, but it is good to be mindful from the start that there might be a need to shift in the midst of a collaborative process. And when intervention does become necessary, for example, there might be a roadblock where the parties are very far apart on the range of settlement. What do we do in this case? Well, when this is happening, or better yet, when it's likely to happen, an outside litigation opinion supported by the team, both counsel, might help. The important thing here is still to be working together as a CP team to make joint or team recommendations to do this. Otherwise, you run the risk of one party going off and obtaining an opinion, then deciding unilaterally to make changes, and the other party is just blindsided. And sometimes you're at an impasse. A shift to a mediation process makes sense. That is a shift to a mediation process within a collaborative process, though. There are really good mediators out there. A lot of them have CP training, and they can offer assistance by looking at the issues with a fresh perspective, but also respecting parties' wishes to stay within the collaborative process. So within this shift, it's not a whole new process, but a continuation of the process with same lawyers, but adding another strategy, in effect, to overcome an impasse. And I have heard when I've suggested this to some lawyers, they say it might be too expensive for the clients to enter mediation after CP has started. But I have found, I've done both, stay in a process where it's still tough, or shift. And I found it's often less expensive to go through a mediation route or try something different than keep hammering away at something that may just not be working for both clients. Okay, so we're gonna move on to the next question. And the question is, how do you work most effectively with neutrals, whether that's a family neutral or family professional neutral or a financial neutral? What happens what happens potentially when the clients are not working well with the neutrals? Natalie, do you have any thoughts?
I do. So first and foremost, I would say I have an open door policy. I am a big believer in frequent communication with neutrals. I know that some team members are not always fond of the idea of offline communications between one lawyer and a neutral, and so involving both counsel often has a better, I guess, feeling or vibe to it, and that's okay. I just think that the regular contact goes a long way in making sure that we're moving along at the same pace and we're on the same page insofar as possible. So I do talk to the neutrals frequently with and without my client in advance of full team meetings to avoid misinformation and to also all be aware of anything that's transpiring or potential issues that may be arising. I try to discover why there's a rocky relationship between neutral and client, if it exists. If it's a lack of responsiveness, then I know I need to step in to help my client perhaps complete their homework or whatever next step is required of them. If the neutral and the client don't see eye to eye, I can often help ease tensions by facilitating communication or perhaps softening messaging. I can welcome my client to discuss calculations and options in triad with the neutrals, and I do think it's important for a client to have their questions answered. This can also be an informal setting in which they feel comfortable, maybe asking vulnerable questions. I also encourage my client to discuss goals, interests, and fears because I find that this helps develop a rapport between the neutral and the client. And it can also help neutrals gain an understanding as to why some solutions being proposed are unappealing or anxiety inducing for the client. Neutrals are often able to then tweak their proposal, or they may perhaps suggest, with the help of the team, that a second opinion or a joint opinion may be helpful. Matt, what's your perspective on this?
I mean, I'd like to believe that I never have an issue with a client, but the reality is that, and I'll kind of answer this in the reverse. I'll start with, what happens when something's not working well. Typically, the issue relates to disclosure. That's probably the number one issue that we see. And in this case, it's not so much that the client isn't working well with us, it's that either they're going back to a time period where they might not have a lot of information for, or they're not ready to take on that homework that Natalie's talking about. They maybe haven't paid their accountant, or they haven't really put their mindset, their books aren't up to date. This is creating pressure on them or stress. And so it's about walking through the process with them of, okay, this is why we need this information. If this information doesn't exist, what information does exist? Who can we talk to help you get this done? And so there are times when I'm talking to the accountants directly saying, okay, tell me about the situation. How far back have they not filed? And so on. So it's about piecing together what we can, and then trying to figure out if that's the roadblock. Sometimes it's about providing options and saying, okay, I understand your concern. You feel that this isn't addressing unreported income. Okay. So again, going back to that cost benefit, how do you want to deal with it? Here are your options that are available to you. And because we're in a collaborative sense and everyone's sitting around the table, virtual or in person, the other side can hear those concerns and then we can address it all together, as opposed to sometimes when it's what's going on in one room, no one has an idea in the other. And so the next part of it then relates to how do you work most effectively with a neutral? Well, it's about open communication, hiring us early. And that tends to happen in the CP process, which is a good thing, and litigation does not. We're usually hired towards the end of the process. But by hiring us early, we can actually run through those options at the beginning as opposed to at the end. So we all know what goals we're trying to achieve, and we can pivot if needed, but we all have an idea, this is what we're trying to get done. And so if you hire a evaluator early, then you've got that input on what are the financial issues and how are we going to address those and what kind of report needs to be done. And when I say what kind of report, it could also mean, is this an oral report or a written report? What are the benefits of each of those and what are the costs associated with them? Another big thing is communication, right? How do you want to communicate? Is everything open communication for all parties? Am I allowed having a conversation with the accountant or the business owner to find out about something? Does every person need to be on those communications? Again, what is the cost? What is the benefit of each of those? Sometimes people say, listen, just find out the information and whatever you use, put in your scope, and that's what I want to look at. I don't need to hear them say X or Y. I just want to know what the final verdict is and what you base that off of, right? So it's about understanding this. It's building that framework in. And if a client has a particular need, to understand that need and to make sure that we're addressing that as best as possible. So, I go with the keys here are figure out your scope, figure out the disclosure, open lines of communication, and that tends to make us work in the most effective way possible, and not being afraid to pick up the phone and have that conversation with the other professionals on the file and say, what's going on here? How do we address this? and not let maybe one client's lack of disclosure per se derail the whole process. But stay in open communication with the professionals on the file at least, so that we can have an understanding of how we want to move forward, as opposed to it just sitting, in this abyss of a situation for forever. So, Cindy, what's it like? Oh, sorry, Jane, actually, what are your take on working with us neutrals? Let's hear it. We're willing to take it all.
Oh, I don't have criticism. Actually, I have so much respect for neutrals, and I'm so grateful when they chime in with process suggestions. And I hear you, Matt, when you said, hire you guys early. That's what we always aim to do. I get on my first call with the other lawyer and say, okay, these are the clients. This is the issue we have to overcome. Who can do this for us? We have a business here. Definitely, we're going to have to hire Matt or someone else, not as good as Matt, to be the CBV, and let's see what we're going to come up with. So I actually look to the neutrals to give us suggestions on the process. And some neutrals actually take on the roles of being sort of a project manager. I kind of love it when they do that. And I trust them if they tell us, for example, if it's a family professional, that they come to us and they say, for these clients, it's much better to meet in person. Because since the pandemic, we've pivoted to a Zoom environment, which is more cost effective for the clients, but sometimes it's not the best process for particular clients. And having said that, I always try to support the neutrals on files. But there are times when one of the clients just not working perfectly well with that professional. And, it happens. One of the most delicate things I've had to do in the past is tell a neutral that my client does not wish to work with them anymore after the file is started. So in this kind of a sticky situation, I think it's important, again, to be respectful and keep in mind, though, that this is not the worst thing that can happen on a file. And it's got to be normalized. It's also important to offer a team brief to that professional. In addition, it's important that the client who no longer wishes to work with a professional not be made to feel as if they did something wrong, and the remaining team, including counsel who represents the other client, that counsel must see this as an event that's not out of the ordinary, and we have to pivot quickly to continue working together to proceed with the collaborative process. So Cindy, what do you think?
Well, I think early on getting hired on a file early on is important, as both you and Matt have stated. It's also allowing, from my perspective as a neutral, allowing the lawyers to get to know me. Who am I? What's my philosophy? How do I work? And for them to be able to decide, would I be a good fit for this family? Because we do have different personalities, and not every person is a good fit for every client. I then also let the lawyers know that I offer a free consultation call with both clients. I won't ever just talk to one client. And in that call, I talk about my philosophy, I talk about my beliefs, I talk about what I can do for them in the process, but I don't allow that as the opportunity to understand their personal ideas yet. And then from there, I've had files where clients have not loved working with me. It's my responsibility to ensure that I'm showing up for them the way they need me to. So I will have conversations with that client to try and understand in a confidential space what their issue is and how can I do better? What do they need from me for me to do better to hear their voice? I will also reach out to the rest of the team to say, do you have any insight into why a client's having difficulty with me? As I said earlier, it's a team process. And we all need to work together. And remembering that the client's in a heightened emotional state, not taking it personally is a key important factor. It's not about me, it's about what they're going through. And I find when we're able to address that, we're able to move forward on any of these challenges.
So I'm going to just jump in here. So sometimes, so we do need to shift as I mentioned, we have to be flexible and shift in process. So how do we do this and protect the clients if the process has to shift? So by way of a wrap up kind of question, can we all chime in with maybe one thing that you might recommend? Matt?
Sure. I agree. I think it's about trying to fit our abilities to what the clients need. And so if they need that extra bit of handholding, then provide that bit of handholding. If an issue comes up, be flexible enough to be able to say, okay, we can address this other issue, and this is the impact of that, and here's the new timeline, and managing the expectations at the same time. And that flow, which you don't get in regular litigation, because all of a sudden you have a court date and the court, you'd have to go seek an adjournment. We have that ability within the process. So it's about using the process in its best ability to stay flexible as possible. Natalie, what's your thoughts on that?
So when the process shifts to mediation, I do ensure that the client understands that the mediator may not necessarily disclose everything said in the room to the other side. However, the mediator may disclose something that is said, and I think that is a nuance that needs to be appreciated. I help frame the client's viewpoints, goals, and interests in a way that will be persuasive for the mediator. And I also explain to the client the difference between viable claims as opposed to interests, goals, and preferences. That shift in process obviously very much dictates whether or not it's interest-based as opposed to rights-based negotiation moving forward. And I spend quite a bit of time talking about process options and identifying the best option for my client moving forward. What about you, Jane?
Well, sometimes the team also needs to make sure the clients are protected in the unlikely event that the file needs to go into litigation. So when I say unlikely event, I can really count on one hand where this has occurred in my files. Nonetheless, it is important to make sure that we're able to get ahead of the curve and make sure that some terms, for example, are papered in a partial agreement, especially if there's potential for one party to be prejudiced. And in some cases, even at earlier stages, we have to make sure that the PA reflects terms that protect the client's entitlements given the party's intentions. But just as a wrap up, I think in every circumstance, the team communication and respect for one another is key in determining the needs of every client in every file. It's always very customized. Cindy, parting words for us?
Parting words, in the words of the illustrious Stu Webb, father of collaborative practice, any process that keeps clients out of court is a collaborative process. So because of certain circumstances, which we've discussed today, the usual collaborative process might not be possible. Shifting to dyads, triads, mediation, any different framework will keep the process going, helps the clients reach a settlement that keeps them out of court, and then we have a situation where the family wins all around.
Great. Okay. There's Daphne.
Thank you so much. What an incredible session on collaborative practice. Thank you, Jane, Matthew, Natalie, and Cindy. We really appreciate you donating your time to the summit today. So thank you so much.
My pleasure.
Thank you.
Thank you for having us.
Yeah, thank you. Just a reminder to the audience that session was accredited for 1 hour of professionalism content. And so we're going to take a short break and resume at 3 o'clock with Business Skills for Family Lawyers, What Law School Didn't Teach You, with Paulette Naram and Steve Benmore. So we will resume shortly. Thanks again, everyone.
Thank you.
Thank you. Bye now.
Bye.
Hello and welcome back, everyone. Just before we get started with the next topic, Michelle and I would like to highlight some CP collaborative practice training that will be happening the next couple of months. So registration is now open to register for the CP training, and there is a discount code for 10% off. You can use the code early bird. and register. And just give me one moment to allow Michelle to join me here.
Hello, everyone. Nice to see you.
Hi, Michelle. Nice to see you too.
Excellent. I'm sorry I was off camera for a minute there. We were having some tech issues, but I'm glad to be here. And Paulette, it is lovely to see you. Thank you for joining us.
Thank you.
I just wanted to echo what Daphne said. Yes, we have our collaborative practice training coming up. It is absolutely wonderful. There is a discount code for 10% off. That code is early bird. So if you are interested in joining, please, I know that this team of people here, Brian, Russ, Carrie, and Jonathan, I work with them on a weekly basis, and they're just a phenomenal team. You're going to learn so much about CP training. And speaking about learning so much, I am so excited to introduce Paulette and Steve. Guys, thank you so much for being here today. I can't tell you how excited I am for this seminar. I'm looking forward to learning lots from you both. So just doing a quick introduction. So thank you everyone for joining us for today, the business skills for family lawyers, what law school didn't teach you. Well, that's a lot. This session has been accredited for 1 hour professionalism with the Law Society. So as I said earlier today, please go in and get those CPD hours. So we have a whole host of topics here. Today, we're going to discuss the gap in legal education, transitioning into leadership, essential business skills for family lawyers, overcoming the should-know mentality, effective delegation and team management, business development, client acquisition, financial literacy, practice management, and investing in professional coaching. Guys, how are you going to do this in 1 hour? I don't even know. I can't even say it. I had to take 3 breaths in that one. So as always, we encourage everyone to participate in our polls and ask questions throughout the event. We'll try to get to all of them today. All the resources mentioned today will be included in the show notes, and you're going to get those later this week. And now, without further ado, let me introduce our 2 panelists. Steve is the founder and principal lawyer of Benmore Family Law Group, a boutique matrimonial law firm in downtown Toronto. He is a certified specialist in family law and was admitted as a fellow to the prestigious International Academy of Family Lawyers. Steve is regularly retained as a divorce mediator, arbitrator, and parenting coordinator. Thank you for joining.
Thank you for having me, Michelle, and hello, Paulette.
Hi, Steve.
Paulette is the CEO for Creative Choices for the 21st Century Lawyer Incorporated and a certified career coach and strategist. A 21st century lawyer herself, she built a platform of services exclusively for lawyers after identifying a gap in career building skills in the profession. Paulette has helped hundreds of lawyers develop personal brands rooted in their values, leading to stronger client engagement. And her expertise has been sought by law firms of all sizes to boost business development, client conversion, and practice growth. She brings a practical, values-driven approach to bridging the gap between legal education and essential business skills for lawyers. All right, and you guys have heard about me. I've introduced myself a couple of times today. So moving right along, I think we have a poll. Is that right, team? All right, so you guys are going to see it magically appear on the screen in front of you. Please go ahead and participate. And our poll question, when you crossed the stage after law school, did you feel you had all of the business skills to own and operate your own law practice? Wow.
Steve, I want to know what you were thinking as you crossed that stage.
Don't trip.
I had 2 sets of family who weren't speaking to each other at the end of the program, and I had to mediate as a newly graduated LLB between 2 feuding family members. So that was what was on my mind.
Oh my goodness.
Oh my goodness. Well, we are babies, right? I was a baby when I crossed that stage. And the thing is, and I always say this, you don't know what you don't know, right? You don't realize how woefully underprepared you are for the business aspect of all of this and all the things that, that you should have learned or you should have turned your mind to. But that came with time, and definitely for you both. I know you've both done an amazing job in your professions. All right, let's see some answers. How did we do on our polls? Oh, there we go. Oops. All right, guys. Sorry, just taking a minute to open it up. Okay. All right. Yeah. So most of us said that they didn't feel that they had enough information, and that's not a surprise, right, guys? Steve and Paulette. So starting into that, why don't we go directly into our first topic, which is the gap in legal education. Paulette, why don't you take it away?
Yeah, I mean, it's not surprising that we heard that answer. And to the audience, just so you want to understand why we asked it, we just wanted to get a sense of also like this generation of lawyers, because when Steve and I and Michelle went to law school, it was a different curriculum. But to me, that really just proves the point that our legal education hasn't changed much, that it's still narrow in its focus. And I think it necessarily has to be in terms of thinking like a lawyer. I mean, that goes without question, but there are complementary ancillary skills that are necessary to also practice the law, like, reading a financial statement, right? Like understanding how to read profit and loss statement, how to set billable targets, like how to manage a trust account beyond compliance. So there are things that law schools are leaving out. Now, I mean, I know law schools have become more progressive. There are externships and things like that where different types of practical, like, legal skills are being exposed earlier, which I think is great. But as far as I'm aware, like in terms of business skills, you'd have to get like a dual degree in business law and business, or do some other training or education. And it's just problematic because it leads to some of the other problems that we're going to talk about later on, where people feel like they should know these things once they do receive their law degrees. And I think for family lawyers in particular, I think that can add just another layer to an already difficult yet rewarding practice, right? It's emotionally challenging. You've got lots of different aspects that you're trying to manage as a family lawyer, like not to mention, like, do you also need like a social work degree? But, to understand all of that financial aspect of it, I just feel like for family lawyers, there's so much to navigate that you need to know. Like, to me, I think of like, that can all like, amount to burnout pretty quickly, which is a problem for all lawyers. But as I was reflecting on family lawyers in particular, I think you do have a lot more that you need to know to practice the law.
Let me jump in and add to that, when it comes to law school, you've got a lot of entry points into law. You have people who, first of all, mature students, they've had prior careers, they come into law school in that way. You've got people that are coming from other jurisdictions, in some cases from other provinces. What's the difference between somebody that spent the last 25 years of their life living in an urban center versus out in the country? So when we talk about the different entry points, you've got people who come from very different backgrounds entering law school. That's number one. Number two is there's a lot of people that start law school, such as myself, who didn't know what life was going to look like upon graduation. Was I going to work for a big firm? Was I going to work for a corporation? Was I going to open up my own practice? Was I going to be a partner? Now, the business skills that you need are going to differ based on the course of action that you take. So if you are entering first year of law school or exiting third year of law school, and it's your intention to be in-house counsel for a corporation or to work at a legal clinic or to be an associate at a large Bay Street law firm, the sort of business skills that you'll need are going to be very different than if you're running a practice like Russell Alexander, Steve Benmore, or Paulette Norum. So first things first, where are you? Where did you come from? And where are you going? And if you can answer those three questions, then you're going to know what sort of skill sets you're going to need to acquire in order to run a successful career as a lawyer. I myself went into law school with a significant amount of business skill. I knew how to sell. I knew how to buy. I certainly knew ROI. I knew the difference between value for a customer versus value that customers will not pay for. These are important sort of base innate skills that are, for me anyway, it was intuitive. And so when we talk about somebody buying an hour of Paulette's time or Russell's time or my time, one of the things that weighs heavily on me is what I charge less expensive than the value that the client gets? And that is partly economic and partly psychological. And so these are innate skills that some people have. And if they don't, they need to acquire them. And sadly, to the category of this program, law school does not teach that. And so the person in first year law, third year law, or 2 or 3 or 5 or 10 years outside of law school needs to figure out which course of action am I taking in my career and what sort of business skills do I need?
Absolutely, Steve. Those are all such great points. And then, life happens. You have a business plan and you really should be looking at it every couple of years because things change, whether the direction that you're taking with your company changes or whether there's staffing changes. And now you've got, for instance, for me, my greatest fear is the trust balances and reconciling all of that, doing that work. But if you've got a great accountant or a great bookkeeper or a great person in your team who's doing that, then you may say, okay, now I need to, redelegate myself and put myself somewhere else and, take up this part of the business. All right. So thank you both for that. Why don't we move on to our next poll? So what is your greatest challenge as a leader? Reluctance to delegate, handling employee HR issues, non-billable practice management, or business development and marketing? So thank you so much for running that for us in the background, Daphne. We have our results already. So the number one thing that people are challenged by and concerned by is the non-billable practice management. We've got 45% of people. Next, we've got the reluctance to delegate, 24% of people. Business development and marketing at 21%, and then handling employee HR issues, we're at 10%. So while we're on that topic, Paulette, do you mind if I lob you a question?
Sure.
All right. So this is a great one that came in from an audience member. Why do you think traditional legal education continues to underplay business and leadership skills? If law schools were to change, sorry, I guess it's a two-parter. If law schools were to change just one thing, what would you want them to teach to better prepare lawyers for practice management?
I think having definitely as an offering client-focused financial literacy. So I think reading financial statements is a must. And just recalling on my own experience, it wasn't until I started practicing that I even knew what that was. And I felt this pressure to think that I should have known this somehow. Did I miss a class? Did I, did I skip something because it was presented to me as, just such a basic form of information. And now with, artificial intelligence, it would have been very easy to access that information. Back then, not so much. But I think, breaking down the kinds of information that clients bring to you possibly in terms of building that financial literacy? Because I feel like financial literacy is actually like such a deficit of lawyers, notwithstanding what Steve has presented. I feel like you're a bit of a unicorn, Steve, in terms of what you brought with you to the practice of law. But I do feel like financial literacy is something that lawyers do need significant help with. And I think law school would be the perfect place for that.
Let me jump in on the poll results, and that I'm looking at them right now. You know, this notion of non-billable practice management skills is a challenge as a leader, 45%, and reluctance to delegate, 24%. And so when I look at those two together, I actually see them almost one, because if you know how to delegate, you may very well find that the time that you have available to do actual legal work for clients that you can charge for will go up. Now, lawyers like me, and most likely all of the people watching, are perfectionists. They like things being done a certain way. And that's the reason they got into university. That's the reason they did well on their LSAT. That's the reason they got into law school. That's the reason they probably got an articling job. They tend to be people that want to get the right answer. And giving somebody else the privilege of answering a question that somebody's asked you is something that people don't like doing when they are perfectionists. So lawyers have a hard time delegating. Now, as it turns out, a lot of the work that we do that's non-billable is delegatable. The work that we're supposed to be doing, which is what we have been asked by clients to do, which is what clients will be prepared to pay us for, that's the part that we need to focus our energy on. Now, any business owner knows that you can't have 100% of your professional service time devoted to billable time. But in fairness, if you look at a work week, whatever number you want to set for yourself, 40 hours, 30 hours, 50 hours, if you could say, look, I'm going to devote a third to the business and 2/3 in the business. I'm going to spend 1/3 working on the business and 2/3 working in the business. And if you were to be able to track that, it's almost like you're a split personality. Part of you is business owner, part of you is service provider. And it's important to keep track on the ROI on both. So for example, if you are spending 15 hours a week writing articles, speaking at events, connecting with people over lunch or dinner, hanging out on social media and engaging with other people, that should produce, for example, new calls, revenues, new clients, and so forth. And then that allow you to spend the time on the other parts of the practice that actually generate revenue. And the more you generate revenue, the more you can pay people to do the 1/3 that you originally did, possibly shrinking it to 1/4 or 1/5. And so a very good business owner knows where their value is and knows where their value is not. And to take somebody that's being able to bill out at $300 to $600 an hour and have work that they're doing that they could pay somebody $50 an hour for is not good business sense. And that requires tremendous discipline.
And that's the challenge, I think, that we have transitioning as lawyers into these more positions of responsibility. Because everything that you said, Steve, I wish that I had you as a mentor or somebody who was sharing that knowledge and wisdom with me. So if we're talking about the difficulties that lawyers have transitioning into leadership roles, is that there is an expectation that that knowledge and maybe even that skill set is somehow magically going to appear when it just doesn't work that way. Just as we became lawyers and having to go to law school for 3 years, the same goes with these other skills, this other knowledge. And I think that's the problem when junior associates become senior associates, and now they're, responsible for maybe leading and dealing with clients more and being responsible for the billing. Like there's a new subset of skills that go along with that. And I see from my practice, a lot of this is done where no supporting coaching or mentorship is provided with this promotion.
Except for you, Paulette, because that's precisely what you offer lawyers, especially young and junior lawyers, the necessary coaching skills to be able to set a target and then achieve that target. And you also serve as an accountability manager to make sure that they stay on track to do so. Quite frankly, no different than a fitness trainer.
Yeah, you're absolutely right. Don't you see it, Steve, as a responsibility of the employer to impart this knowledge as well and to set up some sort of training?
Smart employers, not just in law, in all fields do that. For those of you that are Netflix or Crave fans, you might know of a TV show that I watched from beginning to end and loved called Billions. And in the show Billions, there is an in-house industrial psychologist, in effect, a performance coach who helped every one of the hedge fund traders succeed to their maximum ability beyond what they could have even imagined for themselves. And that's precisely your role, Nanette, and other people like Nanette who help executives achieve greatness. And sometimes it's actually psychological. Sometimes people literally put a glass ceiling above themselves and they say, well, I can't do more. I'm not the kind of person that goes to a social event and hands out business cards, or I have nothing to add, so I can't write an article, or I don't post on LinkedIn. No. That's not true. If you have a law degree, you have something that other people don't know. And if you chose to go into law, law is one of those fields of work where you actually have to deal with other people. You cannot hide in a cave and be a lawyer. Now, there's different areas of law and there's different roles within law, but for the most part, law is a social and academic profession. You have to think, but you also have to talk and you also have to listen. And if you can do those three things, talk, listen, and engage with people, you'll be a good lawyer and you'll be a good business owner of your law practice.
That's great advice, guys. I'm learning so much already. So do you have any real life scenarios illustrating some of the common pitfalls that people see?
Well, I'll jump in on that one. I think it was like 20 years ago, I walked into the Gap in a mall and I looked at the person's name tag who greeted me when I walked in, and it said associate. And I started reading about the psychology of large retailers. They started training even the lowest level employee as though they were part owner of the success of the business. And some of their revenues, like if a sales associate sold X dollars in their shift, they got a little bit extra. They felt invested. We lawyers, we hire a lot of support staff and we ask them to do just this, but we don't engage them and include them in the large project. And if we were to be more inclusive and treat each case, each client, each project as a team effort, now you're going to get people far more engaged. And so when I hire and train a new person, whether it's a law clerk, a paralegal, a articling student, or a young lawyer, I want them to treat my business as though it's their business. My success equals their success. Their success equals my success. And quite frankly, even on the minutia, when they dock it 0.5 for something, I want them to look at that as though they are paying for it. What you just docketed 0.54, if you were the buyer of that, would you find value in that? Would you run to pay that bill? Would you send a thank you card to the person that just docketed you 0.5? If you can do all that, if you can empathize and put yourself in the position of the buyer, the consumer of the legal services, now you're part of my team. Now you're part of my family. And now my family is your family. And our success is owned by every one of us. And that's a different way of thinking than lawyers of the past, where you graduated law school, you joined a firm, and you just put your nose down to the grindstone and docketed X hours per day or per year. This is a very different mindset, and you need to make everybody in the office, from the bookkeeper all the way to the senior lawyer, part of the script, part of the plot. Everybody is on stage at this production, although there are different roles, and sometimes different people get the applause or the bow. But just like when you go to a show, they often at the end, the actors come on stage, and then everybody's standing up and clapping, and then the actor generally points to the orchestra and then points to the lighting crew, because all of them made the show go on.
And I think that's Michelle, I just wanted to jump in here just to maybe highlight the different models of law firm management that exist. And we are in a time where there is much more experimentation and a lot of different ways to run a law firm. And what you're describing sounds to me like an ideal way, Steve. And yet there are other places. I'm thinking of a client who I worked with recently who was working at a firm and was trained by a partner who only focused on the substantive skills and never really spent the time to train this associate who later became a partner on the business side of skills. And then maybe people in the audience will be familiar with this. Then that partner retires. And not all of that work went to that associate that they had trained. And now that associate who has become a partner is left in, their 8th year of practice trying to learn how to develop a business. And that is a real challenge for many lawyers out there, unfortunately. And it is, as I was listening to you, Steve, I just wanted to address this quickly, Michelle, that is something that maybe if you are looking for work to really understand how an organization really does train its associates, its lawyers, how the business sort of acumen is shared with people. And that could be a helpful thing to know as you're investigating in a job search, for example.
Absolutely. Those are some great points. Okay, so while you guys are chatting, Daphne ran our next poll, and the poll was, what thought crosses your mind most about business and leadership skills? So C, I don't feel qualified. That's so sad. We want everyone here to feel qualified and, to feel like they have a place at the table. A, 26% of us, I should already know this by now. D, I'll seek help when I need it, 19%. And then I'll figure it out as I go, 11%. What were you guys feeling when you were starting your own businesses?
Somebody once said to me, look in the mirror, find your greatest weakness, and then make that your number one priority. And then keep doing that until you go down the list and start all over again. And so, yes, as I said before, law is a social career. And some people, they don't feel so comfortable being in the social environment. And so there's different ways to approach that. You could actually find a wing person, and then you and the wing person together go to a law association event or a CBA event or a advocate society event, or you contact one of your old classmates and you say, hey, Would you like to go with me to such and such? I'll buy the tickets. And so you slowly build a small social network from which you can meander and move around. And that way you're building a network. That's one way. Another way is, which didn't exist when we graduated from law school, social media. There's so many ways for people to connect with other people on social media. LinkedIn, for one, is a fantastic way. Listen, people can throw themselves into LinkedIn or social media for hours a day, read articles, learn, connect with people. There's umpteen ways for people to not respond to the poll by saying, I really don't feel comfortable doing that, because there's a way to sort of slowly get out of that discomfort and finding ways in which to connect with others. Now, I'll just tell you personally, when I graduated from law school and I came to Toronto, one of the things that was very important to me was community involvement, both within my religious community, but also in my professional community. And so I started volunteering. And so I would devote an hour here or an hour there. And slowly but surely, it just became part of my life. And for the last 30 plus years, there hasn't been a moment in time when I haven't sat on a committee or on a board or some association and where I haven't volunteered to draft something or to take care of a project. And it's allowed me to be engaged, but more importantly, it's allowed me to connect and meet people that I would have never otherwise met. And and that is a tremendous opportunity that's available to lawyers and law students because you can build a network from day one.
That's such great advice, Steve. Thank you so much for that. All right, so I know we've got so many audience questions coming in. I'll try to get to them all. But while I'm looking at all these come in, Paulette, why don't we start with overcoming the should know mentality?
I started volunteering, and so I would devote an hour here.
Sorry, I'm just hearing the feedback. I feel like it's Steve talking again.
Don't worry, we are working in the background to that. I'll work on that in the background.
So that should mentality, we've already alluded to it, and so it's that that misconception that just because I went to law school, I should know all of these things outside of law school training, right? And so I've passed the bar and now I should know everything about running a practice, leading a team, handling a difficult client. And so I think that comes from some of what Steve was talking about earlier, the legal profession attracting certain personalities, a lot of type A personalities, perfectionism is rampant. And so I think as a result of people who genuinely want to do their best and bring their best to the work that they do, set expectations from themselves that are too high and they're unreasonable. And so thinking that, okay, I should know these things that I'm being asked to do. And instead of, using a curiosity and learning mindset, it'd be like, okay, so I don't know what that is. I've got to figure it out, shaming themselves and saying like, well, why don't I know that? And starting from a place of deficiency as opposed to a place of, okay, well, this is a learning opportunity. And I mean, that compounds into many other things where someone can really take a turn for the worse in their career when they allow that should mentality to really dominate their mindset. But all is not lost. I mean, there are many people who I work with where it's really a lot of it has to do with confidence. And confidence isn't something that I coach head on. I can't say, oh, I'm going to coach you to be more confident. It's always, I tell people it's the outcome or the consequence of other things that we work on together. So it could be like, okay, so you didn't know the answer to that question. what are some of the options that you have because you didn't know how to do that thing that was being asked of you? Okay, and then so we start working from a place of let's retrack and deconstruct what happened there and show more possibilities that existed for you to think about yourself and to think about that assignment and sort of trying to create habits around those responses opposed to the default ones that the person has developed over time, because eventually it becomes a habit, right? A cognitive distortion. And these things are possible. It takes practice, it takes accountability, like Steve mentioned. It's not about perfection, because you'll encounter yourself thinking that way sometimes, but it is about just looking at yourself through a much more productive lens and just trying to reframe things in your mind to see, for example, well, okay, if it's called the practice of law, that suggests that it's lifelong learning. Would you not agree? It's the practice of law. It's not the perfection of law. And so if it's the practice of law, it means you're going to be constantly learning. Isn't that true? Yeah. Okay. So what do you need to learn? What did you see today that you needed to learn? Wow. Yeah. Okay. So let's come up with a plan, right? Have you learned things in the past? What did you need to learn last week or last month? And did you figure those things out? Yeah. Okay. So you're capable of learning too. So it's really just about changing people's perspective. Obviously, that's a very one-dimensional view of this topic when we're talking about the should. There are many other things that could be at play here. This is just one where I am sharing with you that comes up quite a bit in my coaching practice, where that kind of work is really great at sort of breaking down some of these barriers that we have let or built up in ourselves over years.
Some people actually allow the I should know this mentality to shrink themselves. And that's a really bad step. We lawyers are sadly guilty of having this notion, this complex that says, I must know that. And the reason for that is you can go to a wedding, you can go to a party, you can go to an event, and as soon as you say, I'm a lawyer, someone's going to ask you a question. My cousin just got fired from a job. What should she do? As though you've got this sort of ChatGPT processor going on in your brain, and you've got this answer like points 1, 2, and 3. No. We lawyers are a very wide group of people with different experiences and different practice groups. And even within any one practice group, I'm going to have family lawyers who are going to know way more about one area of family law than I will ever know about that. And so I, in my later years, now feel comfortable saying to people, I don't know the answer to that, but if you would like, I could research it, which, by the way, happens to be a very good way of selling legal services. Because if you give somebody the answer that you're not positive about, you're not sure about, you're actually doing a disservice to both you and them, because you're providing an answer that may not necessarily be a reliable answer. That's number one. Number two is you're letting the buyer think that you've got all the answers in your head, which therefore means that when you try to bill a client in the future for maybe reading 3 or 4 hours of case law, they're going to be like, why are you charging me for that? I thought you knew that. You went to law school, didn't you? So you actually need to recognize what you don't know and confidently say, I don't know that. Now, that's for legal services. But what about I don't know how to set up a newsletter on Mulchan? Or I don't know how to shoot a video about foreign divorces in Ontario for YouTube. Okay, fair enough. Not all of us know that. In fact, very few do. But guess what? You go onto the internet, you go onto ChatGPT, you go onto YouTube, and you ask, give me a video on how to create a newsletter for a law firm. Or you go onto YouTube and you go, show me how to load a video that I just shot on my computer on YouTube, or how to create a YouTube channel. I'm just using those as small examples. If the question is, how do I do this non-billable business development, marketing, or clerical job, then research it. And then guess what? If you graduated high school, graduated undergrad, graduated law school, got called to the bar, there's a very high probability that if you want to learn how to set up a MailChimp newsletter, you're going to figure it out pretty fast. So therefore, this notion of I should know, I don't know, and now I'm throwing in the towel, that's just a mistake, because it's in you. And if you work with a coach, someone like Paulette, you're going to have that person bring out the capacity that's inside of you. And you're going to achieve the very thing that maybe right now you think I can't do it.
I just had an idea, Steve. Every morning, we're just going to have you record a 1-minute, self-help tip. Like be great today, or learn something new. I've learned so much from you in these last few minutes, all these tips and tricks you have. All right, so why don't we move on to our next topic, which is effective delegation and team management. What a great one, because we've seen a lot of questions come in about this.
I'll just jump in, Paulette, if that's okay with you.
Go for it.
When I was a young lawyer, at the office, there were different levels of lawyers. There was the 40-year-old lawyer, like 40 years of practice, 30 years of practice, 20 years. And it ended in terms of billing somewhere around the junior lawyer articling student place. We're at a place right now where certainly in family and estates law, clients are very cost conscious, and they would be more than happy to have someone less expensive than the lawyer do the job. Why am I saying this? Because if you actually delegate and you bill out the junior at the office, the law clerk at the office, the law student at the office, at a much lower hourly rate than you're actually winning on many levels. Number one, psychologically, you're elevating that person. They're no longer a gopher. They're a responsible party to this project, whatever that project might be. Number two, whatever you're paying them on payroll, you're going to bill them out for more. So if it's an articling student, you might be billing them out for $125 an hour, but you're actually only paying them $30 or $40. If it's a law clerk, you might be paying them $50,000 to $100,000 a year, but you might actually be billing them out per year at $200,000 or $300,000 a year. And by the way, the more you bill them out, the more savings the client benefits from, the less work the lawyer does, the more profit the lawyer does, the more satisfied the client is. It's a win, win, win. And so when we talk about this category, it's so critical that when we look at the ladder of services in a law firm, we don't only bill out at the top rung or the top 2 or 3 rungs. The more you bill out at the lowest rungs, the more money you earn, the more satisfied your clients are, the higher the turnaround in terms of the project. And that's, by the way, where really effective hiring and training is so critical. Because if the low-end person is able to do the job successfully, the client's going to be thrilled that they only paid $125 an hour for 4 hours instead of $500 an hour for 2 hours. It's a win-win.
I would just say to this topic, in my experience observing lawyers who have difficulty delegating, I think it goes into this bigger topic of leadership. And what I mean by that is, like, leadership requires some proactivity, some sitting down, some, visioning. And so does delegation. But a lot of people are reactive in their practices, right? So they are putting out fires all the time, all day long. They don't feel that they can afford to delegate because that just takes too much time. If they just, took the time to do it themselves, they would be much more efficient, which is a wrong conclusion to draw. Steve is nodding and agrees. Because it requires for you to spend time on a daily basis, on a weekly basis, on a monthly basis to look at the bigger picture and see what needs to be done, how much time it's going to take, break things down into manageable pieces, and then figuring out the best people using and leveraging their strengths to accomplish those tasks for you. And so you're right. If you are just going to constantly be, using your fire hose to be putting out fires, you're not going to be an effective delegator. You won't. In fact, you'll find that it won't work for you at all. You'll get frustrated and it'll just reinforce for you that you'll never do it again. But you'll have to try it a different way, which is to set time aside every day and ask yourself, what do I need to do and who can help me to do it? And include those aspects that Steve said as well. Who will be the best suited price point for this task, given what needs to be accomplished? So you do have to think bigger picture when it comes to delegation, which I would also say falls into that leadership category where you are thinking, team orientation and beyond just the scope of you yourself as an individual unit. You've got other people helping you, and as a result, you need to be thinking about them and designing for them as well. This is a design issue as far as I'm concerned.
Thanks so much, guys, for great comments. And that leads us really nicely into our next topic, business development and client acquisition. Paulette, do you mind giving us a little bit of information about that?
Yeah, I see the time, so I'll just mention two things as quick as I can without watering it down. Steve already talked about some other things that you could be doing in terms of like the social aspect of it and like community. I would like to focus on the consultation process if I can. Am I jumping too far ahead, Michelle, if I do that?
No, Paulette, the floor is yours. You go right ahead.
So consultations, because I know that a lot of family lawyers offer consultations as a way to get business. And so I did want to address this with the audience because there are two main issues that I see so far in my practice with family lawyers who do the consultation work is one, they don't have a process, they don't have a design, going back to my earlier point. Even though they understand the importance of it, that's the way you generate business, because they haven't been trained or haven't taken the time to really understand the importance of it, they see it as an inconvenience. So in the middle of the day, they're working on, motion materials, and now they've got to do a consultation. Oh, now I've got to do a consultation. Like I really could be using this time better for, something else. Whereas like this is the engine of the business, right? And so part of that, I think, is a lack of thinking about like, what is the process? If you don't have a process, you end up defaulting to whatever that person shows up and brings to your lap for a consultation. So you should have in mind, even writing it out, like what your process is. Like step one, I, introduce myself, I say this and the other. This step two, like, I ask them like these specific questions. Like you should know what your process is and how you end it in terms of is it, this vague question like, okay, like I'll just wait to hear from you, which I would suggest is not a very effective end to a consultation process, but you should have an understanding about what your process is. And then the second piece is that I find that a lot of lawyers tend to privilege the competency aspect of their brand. So there's so much that goes into this topic, but in a nutshell, in my mind, there are two components to a brand. There's the competence aspect of it, what you know. So obviously as lawyers, that's clear. But then the second aspect of it is warmth. And I'm just using the language from some research that I think is included in some of the additional materials on social psychology on client retention. So the research is 82% of clients want to know your competence and your warmth before agreeing to purchase your services. And warmth isn't, let me just dispel that right now. It's not like, giving somebody a hug. The warmth aspect is really just another way of describing like what your intentions are, like your why. Like, why do you do the things that you do in the way that you do them? Why do you approach the practice of law in the way that you do? People want to know, not only are you capable of doing what they're asking you to do, but how are you going to do that, right? So I find that a lot of lawyers spend so much time on the competence aspect of it, just showcasing their knowledge. People don't actually pick up on the kind of human being that you are. And that can leave somebody feeling suspicious and distrustful, frankly. And so it's a balance. It's not, like I said, as simple as like, oh, you're just going to give everybody a hug. That's not what this is about. This is understanding like what your own personal values are. If for me, authenticity is, a personal value of mine. And so when I'm meeting people in my own consultation process, I know that I'm doing my job well if I allow like my quirky moments to come out. And if I leave a conversation and I feel really stiff, I know that I haven't been authentic, and I know that I haven't really let that person know who I am and why they should trust me to be their coach. So it's that humanistic side. That can feel really uncomfortable for some people, and it doesn't have to be so much, but you have to show some of it, is what I'm suggesting. So those two pieces, like that, rounding out your brand to demonstrate the why piece and that warmth, and then having a process to begin with is really important for the consultation process, because if you're going to be spending a significant amount of time in there, you better do it right, because you can change that conversion rate so much. And I've helped people do that. So don't undermine that process, because you're really shooting yourself in the foot, aren't you?
Yeah, that's some great points, Paulette. Thank you so much. All right, Steve, why don't you tell us a little bit about financial literacy and practice management?
Sure. In fact, I'm going to pick up on where Paula left off, which is the consultation. So assuming you've done a very good job establishing yourself as a viable business, you provide legal services, let's just say in family law, and the emails come in, the phone rings, however the initial contact is made by the prospective client and you, the lawyer or the law clerk. We live in a world right now where people ascribe value based on price tag. If you walk into a store and you see a lovely jacket that you want, and it's all of a sudden the tag indicates it's extremely cheap, right away you wonder what is this made out of, or is this going to last more than one or two wears? But if you look at the tag and it's extremely expensive, you're going to examine it a little bit more closer. You're going to appreciate it. You're going to maybe look at the the fabric that went into it, the brand name, the reputation. And that's very similar to the purchase of legal services. And so there's not a person in Canada that can't drive up or down a street and see personal injury lawyers advertising free consultation. And so the rest of us lawyers, like family law lawyers, we often get calls from people. Do you offer a free consultation? And my answer, and this is an answer that I've come through from many, many years of studying the subject, my answer is no. Because when I speak to a person, I cherish their time. Their time is valuable, and my time is valuable. And if I'm going to speak to somebody, if I'm going to take myself away from something that's important to give somebody else the importance of my time, I'm going to honor their time, and I'm going to engage with them. I'm going to help them. I'm going to analyze their situation, and I'm going to give them advice. So I do not want a client who is looking for something for free. I don't offer anything for free. And in fact, most retailers do not offer anything for free. And so after at least 6, 7, 8 years of university and 30, 32 years of law practice, I don't think anybody would fault me for admitting openly that I don't offer anything for free. But what I do offer is high quality legal advice, strategic planning, and process design to assist them from where they are to where they want to go. And so from a financial literacy standpoint, anybody should first look in the mirror and go, do I have value to the caller? If the answer is no, then do it for free. If the answer is yes, state your rate and confidently express why you charge for your time. You don't have to say it over and over each time when they call. You can put it on your website. You could put it on your LinkedIn page. It could be public information. It could even be an outgoing voicemail message on your call. Whatever you do, you're either declining clients who only are looking towards you as a freebie or as a deal. You don't want those clients. You are also screening out those people, but screening in the people that value your time. And that carries through to the retainer agreement, to the bill, and ultimately to the advice that you give them to settle their case or to go to trial. So you've got to start with having value for yourself. You've got to demonstrate that value to those that are knocking on your door. You've got to deliver value so that the person who gets your bill compares it with what they've got from you, and they run to pay the bill. And then beyond that, they then give you a Google review and then tell all their friends about you. That is financial literacy. And that carries through at so many different stages. So when a client says to you after a case conference, what do we do now? You could say, well, you can follow the judge's advice at the case conference. If the other side agrees, we could settle, or we can go to questioning, or we can go to a motion, or we can go to trial. And I just want you to know that to do that for you, it will require X amount of hours of preparing X documents, and the cost will be X. And if that's what you want to do, we can do that. But you're going to have to provide us with a deposit to do that project. And if you want that done and you provide that deposit, we will therefore do that thing that you are just directing us to do. Last thing you want is to be financially illiterate, where the client says, do that thing because they don't have to pay for it, or they think they don't have to pay for it, or they think there's going to be a result that they don't get. Then you do it, and the result isn't exactly what they wanted. And then they say to you, why am I going to pay for that? Now you've got a disgruntled client, a disgruntled lawyer, the end of a relationship, and by the way, bad debt. So financial literacy requires self-worth, the demonstration of self-worth, but the ongoing establishment that you are a valuable professional, providing valuable services, and expecting clients to respect the service that you provide.
That's wonderful advice, Steve. Thanks so much. All right, Paulette, why don't we talk a little bit about investing in professional coaching? Because that's what you do. And tell us a little bit about your services and why it brings such great value.
Yeah, I work with lawyers exclusively. As mentioned earlier, I transitioned from law practice to coaching because I recognized this skill set that I didn't possess as a lawyer. And the more I started studying other skill sets to help me become a better lawyer, I enjoyed those more than the actual practice of law. So I work with lawyers and offer them two sort of buckets of services, either looking for work and excelling at work. In terms of excelling at work, it's professional development, helping you to execute your goals, helping you to clarify what your professional development goals are, offering a fresh perspective, giving you basically time and space, judgment-free space where you get to come and plan and really think aloud about what it is that you're working on. And as a result, you have somebody who starts to really understand you and really becomes a good partner for a variety of things that you could be working on. And I think as a result, it builds your confidence, and it does have tangible results, like I was talking about earlier, like increasing your client acquisition rates, things like practice management, improving your time management. To Steve's point, improving your self-worth, helping you to design things like, raise your fees, making that decision around, like, do I charge for consultations? Do I not charge for consultations? All of that training and all of those things where we didn't get in law school, basically, I can help you with those pieces, help you with those should knows, to that mindset of I can figure this out, and by the way, this is knowledge and information that grows with me and my practice no matter where I go, in terms of making that investment for yourself as opposed to relying on your firm or an organization to pay for it. I have a lot of lawyers who come to me and pay for it out of pocket because they understand this is an investment in themselves and that it's going to go with them wherever they go. And it's work that I really love doing. I've been doing it for 15 years and I hope to do it for a little while longer.
That's amazing. All right. So the questions have been pouring in. So I'm going to throw a couple to you guys if you don't mind. I know we are just over our time, but I think we've got some buffer in there. Do you mind giving us about 5 minutes of your time still? Awesome. All right. So, Steve, I'm going to send this one to you. What's the role of retainers and billing to financial health?
A retainer is no different than a contract between you and Bell Canada or you and the seller of the house that you are buying. If you don't have a contract, you don't have consensus ad idem, you don't have a meeting of the minds, you don't have reasonable expectations of one another. And we, in 2025, live in an era where the Law Society of Ontario would wonder what kind of lawyer you are if you don't have a retainer agreement. And that retainer agreement does not have to be pro forma, the one that you download. After you have dealt with different scenarios, depending on the area of law that you do, the nature of work that you do, how you do it, and so forth, you can put in terms in there that express to the client things that you do and things that you don't do. So, for example, I'll use a basic one. There's still a lot of lawyers that collect a retainer when they open up the account, and then when they bill against the existing retainer. We don't do that at my firm. That retainer sits there until the very end. And every time we bill a client, generally speaking, between the $2,000 to $3,000 mark, while we have $5,000 in the retainer in the trust account. And that way, the client is conditioned at low-level bills to know what things cost so that when they send us back and forth 30 or 40 emails in the course of a week, they realize very quickly what that costs. And there's conditioning involved in that exercise. And that's right in the retainer agreement. Another one is some clients think that because we live in an era where all of us have iPhones, that means that they can communicate with us 24/7, weekends and holidays. Well, retainer agreements, no different than a sign on a store, says the open hours. And when a client says, I sent you an email on Saturday, I didn't hear back from you until Monday, you can very honestly say, oh, I'm so sorry you forgot, but this is contained at paragraph such and such of the retainer agreement. And so another thing is some clients will say, well, I want a copy of my whole file. Well, in the retainer agreement, it could say throughout the course of the retainer, everything that I get or send out, you get a copy of it contemporaneously, so that at the end of your case, you've got everything and there will never be a need to package it all up and send it to you or to another lawyer in the future. So whatever situation might arise is covered in the retainer agreement. And generally speaking, you cannot sign another retainer agreement during the retainer. So you actually have to think in advance, what am I getting myself into? And for those of you that do not want to find themselves locked into not only a retainer agreement, but being solicitor of record, you have to think about, is this going to be a full service retainer agreement or a limited scope, or also called unbundled legal service, in which case you are narrowing the scope of the expectations of the client and of the court and of opposing counsel of you. And although some judges may not like the notion of agent work, that's a tool that the Law Society has approved and that you as a lawyer are permitted to execute with respect to clients. And if you've got a client that you're not so sure about, do I want to get on the record? Will this client be able to afford having me on for the totality of the case? Then that's a conversation that you should have with a client to determine the limitations on the nature of the retainer.
Thanks so much. That was such a well-rounded answer, Steve. I really appreciate it. And I actually wrote some notes for our own retainer agreement. I will check to see if we have our hours of practice in there. I do not think we do. Paulette, this one came in for you. What were your biggest challenges when you first launched your niche practice, and how have those evolved over time?
Well, I remember I was practicing at a big law firm. I knew that I didn't want to be there, but I was conflating this notion of leaving and needing to have another job. So in my instance, despite all the great advice that I was getting, I just ended up resigning one day, much to the surprise of my husband, where I came home one day and said, I really, I mean, this was a conversation that we had had for a couple of years, but it was not a decision that I was prepared to make anytime soon, but I kind of had reached a breaking point. All of that background is to say that when I started my coaching practice, I had a pro bono client. So I had used my vacation time while I was practicing to take mediation courses, to take coaching courses. I mentioned earlier that I had invested in all this extra training, and I found that that training was where I was really actually thriving and realizing that's something that I wanted to invest in. So I had done like all of that work. And through the coaching training, there is like some business development that is part of that training and education. So I was working with pro bono clients and had one at the time, but didn't have like a website at the time. This was in 2010. So it's a different era for people in the audience who are wondering, like, you didn't have a website. It was 2010. So that the challenge for me was to build a business really, and to start thinking about it from scratch. And I needed that personally for my own journey. I was not going to do that if I had remained where I was and started to build all of those steps. I needed to treat those decisions as separate. I needed to leave the firm because it wasn't a good place for me in terms of my strengths and values. And then I needed to start working on this business. So basically, to answer your question, I needed to learn everything, Michelle. And it took me some time. I continued to work part-time as a lawyer, offering services to another lawyer on a part-time basis, on a consulting basis. So I did those two things as I grew my coaching practice. And then after about 5 or 6 years, I parted ways with that lawyer and went full-time. So I've been full-time about 10 years. I continue to practice. I am also very involved in my community. I offer pro bono legal services. So I haven't given up my skill set completely, but I'm just not charging for my legal skills. And every year, I love what I do, because every year I get to choose a different area that I want to learn. So in terms of what I'm continuing to learn, like I haven't stopped learning. Most recently, I've really gotten into how to express empathy and to provide empathetic services. And so for me, it's taking things that are just little pet projects and really deepening them. And so that's been a pet project of mine most recently. And I just love how nerdy I can get on subjects, and I get to pay for whatever I want because that's my own business development. And I really do love what I do because it allows me to explore the things that I am passionate about.
Well, Paulette and Steve, thank you so much for donating your time, sharing your knowledge, telling us all of your wonderful stories, and giving us so many tips and tricks. So just a reminder to everyone, this has been accredited for 1 hour of professionalism with the Law Society. There's a ton of resources in the show notes that will be sent to you later today. And it includes contact information and Paulette's website, which I'll be honest, Paulette, I did go on and poke around in your website when we first met. So I'm really excited for everyone to get this. Thank you both so much. We truly appreciate you being on here. Thank you for sharing your wisdom. Thank you. Thank you.
Goodbye.
All right. So I think we have a break, Daphne, for a few more minutes.
Yeah, thank you again, Paulette and Steve, for the very informative session. We do have a break for a few minutes. We will resume at 4:15 with Succession Planning Done Right with Russell Alexander, Heather Suti, and Michelle Kroll. See you soon.
See you soon, everyone.
Welcome, Heather. How are you doing this afternoon?
Hi there, Russell. Great to see you. Thank you so much for your invitation.
Yeah, Michaela, welcome. Daphne, welcome back.
Hi, Russ.
What
Welcome back to you too.
what a lineup today. My goodness. So much head scratching and learning going on. That was fantastic.
Good
Yeah,
stuff.
it's been an excellent day, and I'm really looking forward to your session, Succession Planning Done Right. We are joined by Heather Suti and Michelle Krell. So thank you so much for joining us today. This session has been accredited for 1 hour of professionalism content by the Law Society of Ontario. Today, the panel will discuss the gap in legal education, transitioning into leadership roles, essential business skills for family lawyers. Oh, I'm sorry, I'm reading the wrong. I
That's okay. It's been a
apologize.
long
That's not
day.
what we're
This is the
talking
I
about.
It's been
wondered
a
about that. It's okay.
It's like, I
it's
don't
been
know
a
what to click
10-hour
on any
day.
of those,
Okay, Heather
but
and Michaela, we're switching topics last minute. You're good with that, right?
That's fine.
wait.
Fine.
Okay, so what we're really talking about is why succession planning matters, common pitfalls, impact of firm size, the baby boomer wave, timing, hands-on handover strategy, cohort laddering model, choosing the right successor, overcoming barriers, and action steps. As always, to our audience, we encourage you to participate in the polls and use the chat feature throughout this event. So it is now my pleasure to introduce the panel for today. We are joined by Heather. She is acknowledged as one of the world's leading authorities on legal market strategy and management of legal services. Since 1998, she has advised leaders of premier law firms and legal service providers, global to solo, big law to new law, on innovative growth strategies pertaining to business, markets, management, and clients. The result is creation of new value and accelerated performance achieved through a distinctive one-on-one legal market position and sustained competitive advantage, leading to greater market share, revenue, and profits. Thanks again, Heather, for joining us today.
My pleasure. Thank you.
We are also joined by Michelle. She is the National Director and Head of the Vancouver office of Life After Law, a national recruitment firm dedicated to placing legal professionals in private practice, corporate counsel, quasi-legal, and executive roles. Michelle has her BA in psychology from McGill University and her law degree from Osgoode Hall Law School in Toronto. She is called to the bars in Ontario and New York. Michelle has been in legal recruitment for the past 19 years after leaving the practice of law. She boasts a wide Canadian and international network and has a diverse range of clients in a variety of industries, including real estate, finance, insurance, and emergent companies and crown corporations. Thank you, Michelle, as well, for joining us today. And I will now hand things over to Russell to get started with the presentation.
Yeah, thank you, Daphne. That was a very kind introduction throughout the day and right now. Let's run our poll, but this is really a nice bookend to our presentation today. We started with Aaron and Adam talking about case law and legislative updates, building your practice, collaborative practice, what you didn't learn in law school, and business of law. And now, okay, your career's over. What do you do? This is the bookend. We're going from start to finish. Law school, baby lawyers, building it up, bringing this train into the station. You might wind up your practice, sell your practice. Who knows what's going on? So let's see what our first poll says in terms of results. What have we got, Daphne? I'm seeing a blank. Maybe she's still getting us the results. So we're going to come back to those results. Let's make a start. Let's talk about our first item, which is why succession planning matters now. Oh, sorry, I just got the results. And most of them, 85% lawyers, other professionals are with us today. You can throw that in the chat box. But why succession planning matters. Heather, you want to take a kick at this? First of all, what are we talking about, and why should we be talking about it more?
Well, this area is becoming a bigger part of my practice all the time. And I think, Russell, it's because succession is going to be impacted over the next decade as the boomers start aging out. That is going to be a big part of it. The boomers, the youngest of whom were born in 1964. So they are aging into their 60s now. And so there's going to be a retirement of the senior lawyers and a bumper crop of associates coming up behind them. And these folks have new styles and different working styles. So we've got to take this into context as we look to succession, because nobody lasts forever. And we want to keep refreshing the firm, because that's the only way you stay in business. So as the baby boomers shift out, whether it's willingly or not, the upcoming ranks are looking at things differently and have different expectations, but their clients are going to be looking for the same results: speed, timing, cost, all of that. So we've got to be cognizant of it.
In common pitfalls, what should we be looking out for?
Sorry, who is that question addressed to?
You want to take it, Heather? Just common pitfalls? What should we be
the common
thinking about?
pitfalls. Well, golly, there's so many. We could be here until next week. But among the common pitfalls, and Michelle, you're going to have insight to this too. There is fear. There's a lot of fear. It's something that people don't want to face for, I guess, the same reason that many people don't want to do a will. There is a fear of the end. And Russell, you deal with this all the time when it comes to an end of a marriage, or the end of a relationship, or the end of a job, or the end of a career. The ends are frightening because people aren't sure what comes next. And that fear of what comes next can really cause folks to lock up. It can cause them to become territorial. It can cause them to be angry. A whole plethora of emotions bubble up to the surface and need to be dealt with, and can be dealt with, provided they're dealt with a long time horizon and great attention to sensitivity.
Shoemaker's kid, right? You hear about these lawyers, they don't even have wills or power of attorney in place. And it's just one of those things I could put aside. Michaela, you want to jump in here in terms of why it matters now and some pitfalls you're seeing?
Yeah, I think, what Heather touched on is that definitely the fear and not wanting to look at it, but it's also, I can imagine it happens with a prenuptial agreement. You don't want to think about it. You don't want to plan for that. It's sort of, you want to service your clients and get what needs to be done. And at the end of the day, if you're not billing, why am I going to waste my time when I could be charging this for this many hours, thinking about the next step? So it's like, I'm going to do it on a rainy day. I'm going to save it for a rainy day. And you never get there. And then that bus comes and knocks out proverbially a person, and you're left with nothing. So I think that's also a big thing that we're seeing. It's just, I'm too busy. This isn't a priority. Things are going well, and suddenly they're not going well. And that's why we're just trying to take that step back before you get to that stage.
This career is like a black hole, right? It'll suck as much of your soul as you're willing to put into it. And we get so busy putting out client fires and urgent matters that we don't really take the time to make sure our practices are safeguarded, our families are safeguarded, that the legacy can continue. So really insightful. I want to thank our audience, first of all, for being here today and online through YouTube, participating in the polls throughout the day. Your feedback and questions have been fantastic. We really appreciate all the effort. So one of the poll questions that just came up, what size firm are you part of? 81%, less than 10%, right? And these are the ones usually that are, some of these lawyers are doing the bookkeeping, the marketing, trying to comply with the Law Society regulations and service our clients at the same time. Really, there's just no time left at the end of the day to be thinking about succession planning. 10 to 30% small to mid-sized firm, that would be a large firm if you're a family-only firm, 14%. And then more than 30, so 8%. Some large firms too, which if you're a full service firm, you could just flip it over to one of your departments and have them structure something for you. So there's really no excuse there. But impact of firm size, we know what our audience is comprised of today. Michaela, what do you think? Does this affect succession planning?
It really does. And that's really helpful to know sort of the breakdown. And those are the three sizes I'll talk about. We'll talk about quickly the sole practitioner or small firm, medium firm, which tends to be the regional firms, and then we've got the larger global national firms. But succession planning is imperative to all. What we really see is that there's sort of the three categories. The small firms, the solo firms, what happens is not just a lack of continuity, but they could be closed up overnight. So succession planning is imperative to the survival of the firm. When we get into the regional firms, it's not about survival anymore, it's more sustainability. And then when we get to the larger firms, succession planning comes into play, not again about survival or sustainability, but continuity. But again, I'll give you examples where we've seen big firms and regional firms collapse. But the size of the firm has a huge impact. Sole practitioners, they really are tied to the business itself. It's not the firm or the brand typically. So the relationship between the client and the lawyer is different, which makes it so much more impactful and necessary to have the succession plan in place. You can't just rely on to the person down the hall or the associate coming up the ranks. And like we mentioned before about getting hit by a bus, but like there's sort of the retirees, what if I just don't want to do this anymore? Or what if somebody becomes ill or gets in an accident and you're the person behind the firm? Or one partner leaves. If there's a two-partner shop, can the other partner sustain the whole practice? Are they even in the same sort of, one could be a litigator, one could be corporate. So do they have the same practice areas? And the other thing is associate attrition. Again, we see that more at the bigger firms. But, with a small firm, if you don't succession plan, you just may not have a firm the next day and you may not be able to service the clients. With the regional firms, you mentioned that, it's easier. It's not as imperative. It's more about sustainability. How can we continue to service our clients? And as opposed to the survival. But there's a few factors that have to be taken into consideration, like client transition, talent pipeline. Do we have people coming up the ranks? Do we have them in the right practice area? Ownership structure. So you really need to delineate clearly the partnership structures. There's things to consider: capital buy-ins and buyouts. They're complex. These things, you can't just wake up one morning and expect it to be all taken care of. The larger firms, again, like you had mentioned, Russell, they are a bit more sheltered because they tend to have institutional clients. They have policies and protocols that are in place. They have teams often that, make sure there's enough summer students and then enough associates, or if there isn't enough associates, they hire laterally. They have those things in place. But again, I think it's false to say that it's just the smaller firms that are at risk. And we've seen the collapse of Goodman and Carr. That was, pulled the rug right under people. The Heenan and Blakey, same thing. It collapsed overnight too. There was things that led up to it, but it all comes down to poor succession planning. So the fallout can be, much more impactful on the smaller firms, but we are seeing it at the mid to large firms also. But again, just to recap, I think what's most important is to recognize succession planning in a small firm is instrumental for survival. The mid-level firm, it's instrumental for sustainability. And then at the large, more international global firms, it's more the transition, legacy, next step. So it's not as much as, oh my God, we're going to fold overnight, but what are the next steps? So they kind of each have their own sort of, what's the word, Heather? Like subtle
their unique
nuances.
situation, every last one of them.
Yeah.
Their own blind. They've got their own blind spots, right? They're just in different spots. Yeah.
They do. And sorry, Russell, carry on.
I was just going to say, you want to jump in on firm size and what you're seeing at your end?
Yeah, I agree with what Michelle is saying, but there's another way to look at it too, is that the big firms do not have it going on. Do not get the wild idea, please, that they really know what they are doing. It's a different animal entirely. There is territoriality that comes into play. The competition gets fierce. There is also something else that I want to bring up, and it is something that is very much on my radar, and I'm going to be writing about it shortly, called the pyramid rollover. And that is about what is going to happen with firms of all sizes, from the small to the large, about what's going to happen when the twin juggernauts of AI and pricing come into full effect. And it's going to wipe out the bottom of the traditional law firm pyramid. And when that happens, the pyramid, which is kind of like an iceberg, supported by a big bottom under the water that you can't see. What's going to happen is the bottom of that pyramid, with the younger associates, all the junior talent, some of those associates who have been doing the rote work as part of their training, and I use the word loosely, are going to be
their 100-hour week training.
Yeah,
sessions.
exactly. Yeah, exactly. The rote work. Yeah. They are going to be displaced. AI and pricing are going to displace people. And I'm sorry to say that, but it's the ugly truth. And when that happens, you are going to see these traditional firms have the bottom wiped off them, part of their supporting structure under the water, if they were an iceberg, wiped out from under them, and they are going to roll, and they're going to pitch right over. And there are going to be mergers like crazy. Watch for this. And this is all going to impact what's going to happen with succession. So firms need to get on that, regardless of size. It is going to happen. And this is something that is a big concern. And it's going to be a huge, it's going to be a sea change when it happens, and it's going to happen gradually and then suddenly.
What do you think will happen at the top then, right? The bottom of the iceberg is wiped out.
At the top, well, that pyramid is going to get shorter, and there's going to be fewer people on the top holding the financial reins, because I think a lot of the seniors are going to go, holy cow, I think I've got to get out of here. And they are going to depart as fast as they can. And they're going to leave the middle, the people who are used to managing up and having support underneath are going to be in the middle. That's where things are going to get interesting. I don't have all the solutions to this. I wish I did, but I don't. But I am watching, and this is what I'm seeing coming.
We can spend a whole session just talking about this. We had the remote transition after COVID. Lots of people don't want to go to the bigger centers, bigger firms. They want to work from their cottage or their boat or the beach somewhere.
Mm-hmm.
And you're right. We're starting to see the old system starting to teeter a little bit, and AI is a complete unknown. I love this story, but it's a little bit off topic. Just think of Yellow Pages 20 years ago. Mm-hmm. That's how lawyers got their work. And they could have bought Google. They didn't. Google wiped them out within 2 years. And so these seed changes can happen, just think of Uber and what it did to the taxi industry. So it can come a lot quicker than you think. But this is a nice tie into what we want to talk about next, the urgency of the baby boomer wave. This is, this is the age group, Heather, that you're looking at, right?
Yeah. Well,
the top of the pyramid.
Yeah, the top of the pyramid and the bottom of the pyramid, Russell. That's what I'm keeping my eye on. The middle ground is going to move up or move down. I'm not quite sure what's going to happen there, but the top and the bottom are really concerning. And I'm just going to give you some numbers so that you understand what the context is for this. In 2023, the American Bar Association found that nearly 14% of all lawyers in the US, and Canada will be similar because we follow along, but 14% of all lawyers in the US are 65 years of age or older. And that is in stark contrast to about 7% of all US workers who are 65% or 65 years old or older. So that means lawyers are sticking around for a long time, probably staying a little too long at the fair. And in addition to that, the American and Canadian Bar Association said that 30% to 40% of lawyers in private practice are beginning to retire or considering winding down. But those findings also indicate that most law firms have actively practicing lawyers in their 60s and 70s, and many of them are rainmakers, and their partners age 60 or older control at least one half of the firm's revenue in 63% of those firms. So that's what I was talking about, the people holding onto the purse strings.
Heather, Michaela, we're getting some feedback from our audience. Remember, 81%, 10 lawyers or less. So
right.
Do you apply the same pyramid
yes.
theory to the smaller ones, or
yes.
how do we treat the 80% of the audience that we're seeing or watching us online right now?
It's going to be impactful for everybody regardless of size, because regardless of size, clients are going to expect that you have adopted AI into your practice. There's going to be questions if you don't. There are also going to be, because pricing is the flip side to the AI coin, there's also going to be an expectation that you A, are using AI, and B, you are charging accordingly. So it's not going to really matter the size of the firm. It's going to matter about how you approach your clients, and it's not going to matter whether you are a soloist or whether you are a partner of an international firm.
Yeah, I'm just thinking about this on the fly. The impact might even be bigger. If you've got a smaller firm with one or two senior lawyers and they're gone, there's their network, there's your clients coming in. You could see how it would even go quicker, I would imagine.
Well, that's why watch for mergers. Watch for mergers. Yeah. It's going to happen because this is going to catch people unawares, which is why we're trying to talk about it now.
Well, we are.
Yeah.
We're not trying. We are. So,
absolutely.
Michaela, what's your take on all this in terms of small firms? 10 lawyers or less. What should they be thinking about in terms of what we're talking about?
Well, yes, this is huge. Well, we see there's sort of 4 types of kind of exit strategies for, succession planning at the smaller firm. It's the sale of the firm. So you either identify another firm and to buy the practice or the firm itself. We see the wind down when we're done. I want to close up shop. I'm out of here. The successor model, someone, whether they're internal to the firm or external to take over. And then what Heather was saying is the merger. And, that tends to happen more at the small, medium, and size and large size firm level. In terms of succession planning, oh yeah.
Let's talk about timing. What kind of time frame are you seeing? Are we talking overnight, 3 years, 5 years out? What are you seeing, Michaela, in terms of timing?
3 years minimum. I have firms that are now just looking at succession planning, like the actual putting the wheels in motion, that I touched base with 4 years ago to just say, have you thought about this? You're a sole practitioner, you're in your late 40s. What's your next step? And they took 1.5 years to even wrap their head around the fact that, oh God, like, yeah, what am I doing?
I may not be here anymore. Yeah, what's going on?
Like literally, what if you're ill? What if you there goes your revenue? What are you going to do with your clients? How are you going to keep this going? The legacy there, or even, your lifestyle. So just even in terms of getting them on board mentally, I think that's the first step. Then it's, Heather and I will talk about action steps to really implement a succession plan. That's almost the easy part. I find it's the barrier of let's talk about this. Let's think about it. Let's face it, head on, and then figure out how we do it. So 3 years minimum, especially for a small firm. And the other thing is sale of a firm. It is so hard to identify a firm that not only aligns in, it doesn't always have to align in practice area. You could have a, great real estate firm team up with a litigation firm, but the values have to be there. It has to be a similar culture. Little things. What if one person's billing at 500 and you're billing at 300? That could collapse it in and of itself. The other thing that collapses these mergers, even after you've gone through the hoops of identifying the firm that wants a sale or a merger, is conflicts. What if you're completely conflicted out? So there's so many little things that you have to think about. So in terms of sale of a firm and a merger, it's not just you anymore. You're dealing with you've got to identify another target that wants the same things that you do. The wind down is obviously, easier and more seamless in terms of a succession plan. But then you really have to be careful of Law Society. Like their interest is to protect the client. And we've seen a lot of them go awry if you're not in complete compliance. There's trust accounts that have to be closed up or transferred, or so that's where that comes in. So that tends to be the most seamless one. And then second is finding a successor. You know, in the big firms, that's easy. You should usually have people coming up the ranks. Um, you also have to make sure you have a really strong pipeline of talent, and that's you're being poached from other places. And attrition, we see attrition or burnout at the 3 to 5 year level. And then when you get into the sale of the firm or the merger, that's just a whole other ball game. And if you don't start 3 years behind, you know, it's just not going to be feasible.
There's a lot to
12
unpack there.
years ahead. Yeah. Yeah.
You're right. You know, associates may go out and just start a competing firm. I've had that happen several times. Conflicts. If you're in a regional or a smaller community and there's a handful of family lawyers in that community, you're going to be conflicted out of maybe half your files. The other thing you said, Michaela, that really resonated with me is core values. You know, we've heard speakers earlier today talk about your why and empathy and warm relationships with clients in terms of understanding, having them understand what's important to you. A lot of firms don't have core values. Big companies do. They hire professional people to help think this through. So when you're merging these firms, their values may not line up. And I thought that was really insightful. But we're not thinking about it. We're worried about emotion we got to prepare for it tomorrow morning. And the other thing that really resonated, Michaela, is, you know, lawyers in my vintage, I know one or two, they started planning 8 years ahead of time, the succession plan. So, you know, 1 to 3 years could be quick if you can get the lawyer to move that quickly. So what about hand-on, handover strategy? What are we looking at here? What do we need to know, Michaela?
Well, what's interesting is we see it throughout, no matter what the firm is, that the most successful, the most seamless transitions is a hands-on handover strategy. The larger firms, you know, they can get away with the exit memos and sort of a bit more hands-off approach, but it doesn't always resonate with the clients. You know, if the client hasn't been integrated with the new person, whether it's a junior partner that's worked with a senior or a senior associate, you can't just show up one day and say, here's the file. Like these are, even if it's an institutional client, they really have deep, especially if it's a rainmaker, they have these deep connections and deep loyalty. So whether you're in a small firm and handing off your clients, you're going to need like a 2 year runway sometimes to bring these successors on to the file, get them acclimated. And sometimes there just isn't a mesh. You just don't like the person, you don't like the lawyer, you're just different people. So, you know, what happens. So you can't just say it's not like a business where you're selling widgets and you sell the whole thing and anyone can sell it and you hang up your
Are you
shingle.
saying there's lawyers that don't like each other? That's not possible. Everybody gets along so nicely, right?
And we don't like their clients. That's the thing.
Yeah.
Sometimes
They
you're
all
not
have a little
that
black
fit.
book of somebody who's done them wrong for some reason. Yeah. So is this sort of what we're seeing in other industries where a company will get bought out, they keep the CEO or the founder on board for a couple of years and pay them it's just sort of the handover that you're talking about, this transition?
Exactly the same way. It's right. It's not usually that external, you know, especially with the larger firms. It's more of an internal handover. But with the case of the merger, yeah, it could be an entirely new person who's never been on the file, and you can't, you know, it's so personal, especially the small firms and family law. You might have divulged your deepest, darkest secrets over the past 5 years. Like that's a personal relationship that you can't just replace overnight. So it's a matter of bringing them in, integrating them into the files. So, and I think Heather will talk more about the actual strategy. That's what's the one that the cohort laddering model. But again, what we see throughout all is the most successful, whether you're in a small firm, medium size, or large firm, is a hands-on handover. It makes it seamless as to the extent possible.
I guess if you're handing it off to existing associates, that'll help reduce attrition as well. they've got some skin
100%.
in the game.
Yes.
Right.
And with institutional clients where you're at a firm and you can't build a book, that's a really good way that they can really kind of clinch their spot at the firm without having to go out and business develop. It's, getting
All
in on
right,
those
so I'm learning lots of new stuff, even as we're talking right now. Cohort layering model. What are we talking about here? Heather, first of all, tell us what it is, what it means, and then how is it going to help us?
Well, you know what, Russell, that's something that I hatched myself because people say to me, I have no idea what that is. I've never heard of it. And I think I may have hatched it my very own self, much to my own surprise.
I'm telling you, I don't know. I'll be the first
I
one
think I need to get
admit
it
that.
trademarked. Somebody help me with that.
That should have been a poll question.
Yeah.
What does this mean?
Yeah, what does it mean? Well, you know what, just to circle back to what Michaela was saying, you have to have the client involved in this whole process. If you ignore the client in a succession planning process, it is at your peril because the client wants to be involved. I can tell you that from having interviewed many law firm clients, and they will say to me,
you're not talking about the owner of the firm who's your client. You're talking about that lawyer's specific clients. The divorce
asking
cases
the
he's handling,
asking the question, when is my lawyer going to be retiring? I haven't heard. I need to know because I need to plan internally how I am going to deal with that. So even if the lawyer
clients want to know, some clients want to know when the lawyer's going on mat leave. They can't
absolutely
wait, And so imagine the whole firm's going on a change of ownership. Yeah.
Absolutely. And so they should. So that's why I say you ignore your client's participation at your peril because they can really get their nose out of joint, and rightly so. Nobody wants a surprise, even if it's a happy one, such as, can you read that?
Look at that swag.
Look at that. That came
who's names on the other side of that mug?
My name.
Wait,
see what you can get if you participate in a summit. You're going to get swag that shows up. When did that come in today?
It came in this morning.
Well, there you go.
So brilliant timing. Thank you. Anyway, back to our topic. Laddering. Laddering is kind of a flip side of secondment, and secondment isn't unique to large firms, although large firms can usually facilitate it better just because they've got more bodies. But in fact, I was talking about this morning with a cohort from Australia because somebody with a recruiting firm, an international recruiting firm, had said that secondment was on its way out. I disagree with that heartily because smart firms will second their best and brightest into a key client to enable an anchoring of that talent into their key client. It is a win-win strategy. The client secures their top 10. The law firm's client secures top talent without having to go out and look for it themselves. The talent secures usually a plum position within the legal department, and the firm secures an exclusive bridge to the client as well as their former talent, and as a result gets first preference for new files. So that kind of secondment is pure gold. The flip side to that is the laddering concept. And laddering, if you think of it, is like a stairway or an escalator where you've got, let's say you've got people at the legal department and people at the law firm, and you've got, let's say, talent at the 5-year out level and the 10-year out level and the 15-year out level and the 20, and then you've got the seniors, say, at 25. And at 25 years out, you should be a senior partner probably, and probably a GC at the in-house. So as people progress and come up together, they know each other. There is commonality in terms of their cohort, their understanding, their experience, and these people can rise up together. It doesn't mean that it is a forever thing. If one of those rungs on the ladder, say on the law firm side or the legal department side, happens to depart, then the people on the upper rung and the lower rung can fill in, or you know what you've got to get as a lateral talent to plug in at whatever level in the firm or on the law department client. So that is how laddering works. when it comes to smaller firms, it's not quite as easy, and I will recognize that. However, it still can be a shortened version of the ladder, and it can work depending. It's just a matter of scale. That's what it is.
There's one real
Michaela,
issue that we're seeing. Yeah.
when you check your mail, your mug will be waiting for you. So don't worry.
I just saw a little
All our
message there.
presenters
I got
today
so
are going to
sad.
get one. So sorry, I just want to let you know. Don't panic. But go ahead.
Oh, no,
What were
that's
you
so
going to
sweet.
say?
I was only teasing, but thank you. But you know what we're seeing also that's been like an impediment to succession planning is senior partners hoarding files and clients,
Oh
and
yeah.
to the detriment of the firm. And it's unbelievable. And that kind of, with their cohort laddering, you end up with a real problem because they're hounding the clients. They're not bringing the associates up to speed. And that could also be the demise of a firm if they're just not on board. They're not a team player.
They're not running a good business. We heard Steve
Oh,
Benmore saying the more you delegate, the more profit you're going to make. If you're hanging on to these files, you're doing so to the detriment of your firm.
Right.
yeah.
And
And
it's
to the
all
client.
about the billable hour. People want to, keep their billable hours up. Well, you know what? There's pluses and minuses to that. And the minus to that is that good talent's going to depart. And that's what I was talking about in the first place about,
But you're not delivering value to your client. Why
Right.
do you need to hang on to that file when there's a junior lawyer, paralegal, law clerk, do the work for a fraction of the cost, and you take on more
Because of the
clients? So
billable hours, to get your hours up.
yeah.
That's what we're seeing. They're just, it's sort of, I don't have to go out business develop. I have it here. I'm going to mine the clients I already have rather than go and develop further. It's like, I've got another 5-8 years. I'm just going to ride it till the end. And they're not thinking about the succession of the firm. Whereas in the
I'm
smaller
gonna
firm,
I,
they're tied to
I'm gonna
you.
push back on you two for a moment, and I hope that's okay. The smaller firms, if you're a divorce lawyer, family lawyer, you might have the client 6 months if you settle by way of agreement outside the court. It might be 2 years if it goes into litigation, and then you got a whole new set of clients coming in. So, in terms of these institutional clients, I'm not sure if the handoff is that important to this specific area of law. But I think what would be more important would be the network and the referral sources where these new clients are being fed in. That's what's really been developed over a family law practitioner's career for 20, 30, 40 years. And that's really, I think, the sweet spot in terms of a transition. You want to keep feeding this machine. It's not that one client who may or may not get divorced again. You may do some work in the future in terms of a variation or something of that sort, or a parenting change. But wouldn't the network and the source of the clients be as important, or maybe even more important? What would you say, Heather?
It always is. I mean, you're only as good as your network. It is what it comes down to. And you know that, Russell. It really is. It's who you know, who are going to support you. It's an important factor, and don't ignore it. Please don't ignore it. And again, with AI and pricing coming into the picture, that network is going to be even more important. It's going to be vital because we all deal with, it's a people business. And as long as law is a people business, then that is your toehold. And that is the most important part about what you provide. It's not the stuff that you do. It's that you have an ability to listen and be empathetic and to counsel and provide judgment. Artificial intelligence is well named. It's artificial. It doesn't have a heart.
Right.
And until it does, people still have an inside track.
I suppose that's where the strength of the handover model would come into play, right? You're also handing over these networks, these referral sources. Michaela, what's your take on this? My little pushback. Sorry to throw you guys a bit of a loop, but
On your little
networks,
pushback.
new clients, do you agree with that analysis, or?
100%. Yeah, I think it is the value of your network. What do they say? Your network is greatly, more so than your network is equal to your net worth. And I think, yeah, even with the institutional clients, you're seeing there's always one person who's the point person. And if you don't resonate with them, go across the street. You can get a cheaper price, a cheaper value. You can get a fee for service. There's always something else out there that looks more, if you don't have that connection, And again, I think, like you said, especially with family law firms, it isn't repeat business, right? So it's
Right.
not, can't just rely on.
Well, there are clients that get divorced 2-3 times. It's just not as big of a repeat business as a widget company or whatever.
Right.
But that's very insightful. Thank you, Michaela. The so what about choosing the right successor? What should we be looking at? What are some of the things we want to consider? Heather, you want to take a crack at this one?
Yeah, I'll take a crack at that one. Again, it goes back to having the client involved, because the client has a voice here and the client needs to be heard. To have a replacement for a lawyer who is pulling back, the replacement for that lawyer doesn't necessarily need to be the person with the whitest hair. One reason for that is you might be handing off, a 65-year-old might be handing off to a 63-year-old. Well, what's the difference? So you need to consider the next rung down, and this goes back to my laddering, example, to be looking at the next rung down, and to figure out who the best match is going to be to the
How
client,
far
and the
down that
client is
ladder?
going to help you.
How far down that ladder do you go?
Maybe 10 years, maybe 15. And
Right.
but the client will help you. If you ask your client and say, I'm Heather Suddy, I'm going to be retiring in the next 5 years. I need to look ahead at who would be best for you. I'm looking at this person, and this person. How about we all sit down and meet together and you tell me what you think is going to work best for you, especially since from a corporate position, not from a family law position, but from a corporate position, where you think your business is going to go and what kind of talent you're going to need, because the client will know their situation better than you ever will, with all due respect.
That's why succession planning it's so important, succession planning, that you have that active pipeline, because you can't necessarily go down a few rungs if your 3 to 5 year pool is no longer there. So then, that becomes an issue. That's why planning in advance is so important, that you always have a good pipeline at the mid-level, at the more senior level. But Heather's right. It's not who has the whitest hair. You're just going to end up in the same position, or even seniority. Again, it goes back to client and lawyer alignment. And like Heather said, you have to get them involved to some extent, but also, you have to be careful that you're not giving everything away before you're ready to wind down. So a lot of when we're doing mergers and firm sales, we discuss it with the person who wants to do the succession and do the merger. And then at a certain point, we're like, you know what, I've really wrapped my head around this. I want to go forward. I'm going to talk to my clients now. Because again, you may not have a book to merge anymore. That could be it. If they're not on board, if they're not in line, again, does the billable targets line up? So again, so it's not the person who's the most senior. It's if they can do the work and if the values align. So there's just a few kind of subtle things that it's just not about. You can always find somebody to do the work, but is that client going to want to work with that lawyer? I think that's a huge thing as well. But I think you do see that when you're staffing files. You can see the ones that rise to the top and the ones where the client starts to, call the senior partner and say, "Oh, you're busy on this. Is Joe, down the hall available? He worked on that last acquisition with you. I really liked him." So you can kind of get a sense along the way. There's those little nuggets. But if you're hoarding those clients and you never get them involved, so it's a matter of, bringing those senior associates onto files to staff them, doing the delegation in advance. So when the time comes and you do approach the client and say, "Hey, you've worked with these 3 associates. I'm sort of winding down and getting more help on these files. Any preference?"
That's really where the power of a team comes in, right? When you're working as a team as opposed to these, solo practitioners that just happen to be in a firm together. It really makes the transition easier. In terms of what other industries can family lawyers look at, just to get a sense in terms of what other businesses would, how are they approaching succession? Do you have an industry that would line up closely with us?
To model after?
Yeah.
I see a lot with accounting firms.
Is that right? Okay.
Small mom and pop shop accounting firms. I guess it is different in the sense that it may not be like a one-off transaction. There's usually more to it. But we find those service industries are very similar. I don't know. What do you
Heather,
think?
do you agree with that?
Yeah, I hadn't even thought about it, except for lately. I would look at the medical industry. I would look at doctors who are starting to retire. My doctor is going to start to retire, and I've asked her about succession, and she says she's going to keep practicing until 5 years after she's dead. Well,
I know some lawyers that may be dead right now,
does
and they're
that
still
sound familiar? Yeah.
practicing law.
Yeah. So you know what? I've taken the initiative and I've gone on to a new doctor because I can't wait. And so I
What
have
was
to
that
move
movie
ahead.
called? The Fifth Sense, The Sixth Sense?
Pardon?
With Bruce Willis. There's a whole movie about that. He was already dead half through the movie, you figure it out.
Yeah.
But yeah, no, it was pretty insightful. All right, so we actually have had poll results go up and down. We're going to get to the poll results in a moment, but I want to thank everybody who continue to participate. Overcoming barriers. Michaela, obviously procrastination is a big one. I'm hearing you say 1 to 3 years would be quick. What are the barriers family lawyers need to start thinking about and breaking through?
Not having a plan and wrapping your head around the idea. I think, well, the first one is wrapping your head around the idea. I think that's the biggest impediment. It's just, I don't want to deal with this. I don't want to think about it. Now's not the time. I'm too busy. My clients need this. I'm going away this weekend. It's just saying, facing it that you need to have the plan. It's like losing weight. I want to lose 10 pounds. Well, it's daunting when you think of the 10 pounds all in one go. But if you think, okay, my goal is I'm going to lose the 10 pounds, let's work backwards from that. Can I lose a pound a week? Can I do it in this time frame? Can I, and it's just working backwards. So it's like just get your head around it. It's something you have to do. Build it in like you would business development. Don't watch Netflix for an hour that night. Instead, do an hour of just thinking about, okay, what if in 3 years, I don't want to be doing this anymore. And then it just makes it so much more manageable to have a plan or to even start to think about it. Think about those options. Do I want to merge with another firm? Do I just want to wind down and call it a day? Do I want to have a successor? Do I have a successor? Or do I want to sell it? And, like you could just categorize it and then pick one and start to just fraction it out.
Well, that old saying, what gets measured gets managed, right? But we're not measuring this. Audience question that came in. Thank you for submitting it. Around what stage of life should a lawyer plan succession and eventually exit practice? So I guess I'm not sure what they mean by stage, but maybe age or years A, or I don't know, maybe stage. How would you guys approach that question? Heather, you want to take a kick at that?
Yeah, I mean, everybody is different. And I'm not ducking the question. There's my doctor who's, who's 71 and going to practice until 5 years after she's dead. Well, I don't think that's going to happen. But she's practicing at 71.
Why would lawyers retire? We've got a great job. Most of us love what we're doing. Like the mindset is, what am I going to do if I retire?
Well,
right?
But this is it. It's the stuff that comes after that can create the fear or the concern. I mean, you can't, well, you might be able to, Russell, spend every day on the golf course. But because I know you like that on Fridays, if I remember correctly. But everybody's going to be different in what they want to do afterward. But the thing is, you need to, as Michelle mentioned, you need to plan for this, but you also need to action it, and you need to tell people about it. You cannot do succession planning in your head. It's got to come out of your mouth. It's got to come in the actions. It's got to bring people along so that nobody is surprised when you decide that you're going to step back. Nobody wants a surprise. And that's the key part of succession planning as far as I'm concerned.
So stage, 15, 20 years out, 20 years into practice, if you had to put a number on it, is there a sweet spot that you're seeing?
That's a good question. I would give like a good 5-year runway to really get the wheels in motion. I'm assuming this person is probably in a smaller firm just by the demographic from the poll. In the larger firm, you just do have to be cognizant. What we're seeing a lot of now is the mandatory retirement. And what's ironic is it's 65, which is the new 35. So it's when people are don't have family obligations like they used to because their kids are either grown up out of the house, mortgages are either paid down or significantly reduced, and your expertise is high. You were at the pinnacle of your career and you have about 15 years left, and suddenly they're saying you're out. So we're helping a lot of succession planning with those people. What's my next step? But if this person is talking about a smaller firm, like it's really 5 years to like identifying a firm is hard, identifying a successor. So it's just starting to, put out the feelers, wrap your head around, see who's doing what, see what values align, what practices align, going to networking events, just in case, because if you're the only person and it's falling on you and that's your only source of income, it can be very scary if you don't have a plan, whether it's just straight retiring or if something actually happens, you need to have some sort of next step. So I'd say
Maybe I'm being naive. Who's telling people to retire at 65?
well, the mandatory retirement is 65 to 70 in the large firms. That's the age.
Really?
If they've got a program in place, if that's part of the partnership agreement, and that does
So
not
the partners are kicking them out.
Oh, I know. I can think of 5 senior partners right now in Vancouver who had to start their own thing, and they're killing it
Yeah.
now. But
Well, their
it's
lifestyle is going to change, right? Their income's going to drop significantly.
But they're going to have more time.
Pardon me?
But they're going to have more time. You either pay
They're not going to know what to do with
more
themselves.
time
I'm
or
telling-
more money. Right. And they're just at the peak of their career. These are the guys you want on, not the
Right.
person where they're trying to pay for kids' schools and have to leave the office at 4:30. And it's just interesting. It's just an archaic policy that they're trying to switch over. It's almost like in violation of the Human Rights Code, but
I've got our poll results, and I think I'm going to start ringing the fire alarm here. Where are you in your succession planning? I don't have one, 44%. Well, I have one, that's good, 30%. I'm only thinking about it due to this program, 25%. I have one and everyone knows about it, 0%. That's scary. But, we're 70%. People haven't even turned their minds. Our audience here today haven't thought about this. So
think about it. You'll
actions.
thank yourself later.
Yeah, you will. That's
You
the
really
first step,
will.
is thinking about it, just wrapping your head around it.
Will.
The rest will fall into place.
Well, like I said, this is a great bookend to today's program because we don't think about this until it's too late or we're injured or incapable of making these decisions for whatever reason. Action steps. Now that we know that there's certainly a demand for this, right? This is a blind spot. We're identifying this for everybody today. Our audience is agreeing with us. 70% of our audience is saying this is a huge blind spot. They haven't turned their minds to them. So action steps. Let's start with Michaela. What should we be doing when we log off and go get our cup of coffee or glass of wine or whatever people are doing tonight?
Is just thinking, where do I see this going? Am I just going to wrap it up and walk away? Or do I want to go from lawyer to legacy? Do I want this to continue whether or not I'm at the helm? And then taking it from there. So if you do, then you've got to identify a potential successor, a potential law firm to merge with, a potential purchaser. If you don't, then it's the other things. It's more regulatory. It's I'm going to wind down. I've got to let my clients know. I've got to make sure that somebody's there for me to transition them to. So just methodical. The other thing is, if you don't want to deal with any of this because you just want a lawyer, that's where we come in. Life After Law is starting a whole succession planning sort of offshoot, because it used to be Life After Law. Like, what do I do? I'm in private practice. I'm in my 5th year. I'm disgruntled. Maybe I should go into in-house. Now I'm 65. I'm at the peak of my career. I can't stay at this firm any longer because of a policy or somebody just having their own firm saying, I don't want to do this. I want to be on the golf course every Thursday and Friday. So it's sort of, how do I pivot now? I've done the same thing for 30 years. So I think there's 2 sort of things. It's, do I do it myself? And if I do, okay, can I look for a successor? Can I look for somebody to purchase? Can I look for a merger? Or do I want to outsource this? Who am I going to bring in to help me get through this so I can just keep lawyering, but I'm not shooting myself in the foot?
I'm writing this down. I was at we have the smaller law associations have annual AGMs with a dinner and awards presentation. They're really quite nice. And the second time I've seen this, a lawyer received the certificate for 50 years at the bar, still practicing. So I'm going to say these numbers, 15, 25, 50 years out, there's lawyers out there doing it. We're going to wind this program up in 5-10 minutes. What should I be writing down as an action step tonight? And what should I be doing in the next 30 days? Maybe 2-3 takeaways of things to put down on a piece of paper, put it in your calendar and take some action. So, Heather, you want to start with that and then we'll flip that back over to Michaela?
Sure.
And any additional steps you're recommending?
Well, yeah, Michelle has said about, thinking about it. And yeah, you absolutely have to, because if you don't think about it, it's never going to happen. So you've actually got to think about it and then you've got to do something. And what I always suggest is that if you write it down, it becomes a little more real. As I said, you can't do succession planning in your head. You need to get it out and you need to either get it on paper or talk to somebody about it. Talk to someone who has been through this. There are people who have been on this road ahead of you. Find people who you respect and find out how they did it. And you can take little bits of what they did and apply it to what you do. I can tell you right now that I am doing a lot of work in this area. I am also going through my own succession. And I have determined, I started this 5 years ago myself. What do I want at a certain point in my life? And I want to do not as much consulting work, but more advisory work. A lawyer can do the same sort of thing. I'm going to shift into advisory. I want to spend more time doing pro bono work. I know what I'm going to do because I've plotted it out. And because I've plotted it out and I've got a map, it makes me feel a little more secure, because then I can apply a budget to that, a timeline to that, and everybody who knows me knows what I'm going to do. So there's not going to be any surprises, including, a surprise from a client.
Yeah, and the legal profession has a great tradition of mentorship, right from articles through. So if you know somebody who's retired, talk to them about it, find out what went right, what went wrong. I really like your idea, Heather, not just writing it down, but telling somebody about it. I think statistically, when you talk about goals or your vision, you verbalize it and discuss it or create a vision board, it's much more effective. Michelle, I apologize for mispronouncing your name.
No,
but
I get it all the time. Look how it's spelled. I don't even know how to pronounce it.
So, action steps. What are you recommending for tonight and next 30 days? What should some good baby steps we should be taking?
I love what Heather said. Look at somebody else who you look up to or has a similar practice, whether you know them or not. I feel like people are so inclined to help. You pick up the phone, you shoot an email saying, just want to pick your brain. I've noticed that you've done this. But like action steps, really deciding like in 5 to 10 years, where do I see myself? If God forbid something happened and I couldn't practice again and still had to pay my bills, what would I do? I think when you've identified what it is, what is it where attention goes, intention flows, or like you always have to have that thing first to be able to put the attention to it and make it manifest it into reality. So I think it's really important. Tonight I would sit down, where do I see myself in 5-10 years, and then you can say, how do I get there? You can't just say I want to go to Buffalo and hop in the car. You get out the map, or you get out Google Maps. You first establish the destination, then get in the car and go. But if you're just going to go aimlessly, you're never going to get to where you want to be. So you just write it out, 2 possibilities, and then start to action it. Okay, well, I really think I'm going to, again, it comes down to winding down or whether I want a merger, and then see, like what Heather said, who's done that, who has successfully sold their practice, and don't reinvent the wheel. Tell them, say, what did you do? I don't know where to start. And right there, you'll get, oh, talk to this person or this person. Oh, I just spoke to my friend who I graduated law school with 30 years ago. They're looking for the same thing. And before you know it, the wheels will turn. You'll be ignited again for the next stage, because there is a life after law. There is something after, if you've got those things in place. It doesn't have to be, again, lawyer to legacy. Like you could ride this out, but get that action plan in place, start those small baby steps, and the rest sort of flows from there.
I've got my notes. I've been making notes. This has been fantastic. I've actually had a senior lawyer reach out to me saying, it's time for me to merge my firm. This is fantastic just from this event. So that was
That's amazing.
fantastic.
Heather and I'm happy to discuss anytime they can reach out. That's what we do.
I was going to suggest call one of you two, right? You guys, this is your.
Happy to help.
We've done it.
Yeah.
This is what we're in the business of. We're happy to guide anyone through. So
I've read your work. I think you guys are providing great value to the profession, and I deeply appreciate you bringing this to our attention. This is a huge blind spot that 80% of this audience is obviously hasn't thought of it or taken any action on. We're going to wrap up quickly, though. I'll give final comments first to Heather.
I really don't have anything further to say that I haven't said already, Russell. I would just be repeating myself. But if you'll indulge me, I would like to thank the good folks who organized this event today, by name Daphne Brooks and Nicole Dortono, and the team of technical wizards. I know you're there, and the admin support, as well as to Michelle, whose picture we see there, and of course to you, Russell. Thank you very much, everyone, for your time and your skills and your talent and your care. You've made this a pleasure.
Thank you so much, Heather. Michelle?
how can I go after that? I'm just going to piggyback on that. Thank you. No, thank you so much. It's been such a pleasure. I feel honored to be amongst this sophisticated panel, and I just hope that, we could impart some wisdom. But again, like we just said, we're here if you want to call, email, LinkedIn, if there's any questions that you have that's come out of today, happy to answer it further.
Yeah, and I want to thank our audience for joining us on Zoom and on YouTube. We've had a great turnout today. If you want to learn more about this subject, we're going to have more in the show notes. And, Heather is right. There is a team that puts this together. They've been working for 3-4 months, planning this out, ordering swag, doing sound checks, getting programs accredited, getting the message out. So Daphne, take a bow. Michelle D, she's behind the scenes doing our tech stuff. Sarah A, great job on the marketing, and Michelle Mulchan, our co-host. Fantastic. And all the presenters today donated their time, their expertise. If you like the presenter or if you want to learn more, reach out to any one of our presenters. I'm sure they'd help you find out more and give you some more guidance. Michelle, any final thoughts?
No, it was wonderful. I have been watching your presentation in the back, and I've got some ideas for you, Russ. Just wait till our next management meeting on Monday.
If I show up, apparently I'm going to be on the golf course somewhere recording these two over here. So
I'm booking you for Monday. I heard it.
Oh yeah, and we've got the CV training coming up in a couple of weeks. There is a handful of spots left. Daphne's going to send it. The code discount will be open for the balance of the week. Daphne, what else do we need to talk about?
That about wraps it up. I just want to thank you both, Heather and Michelle. Thank you so much. I appreciate the shout out. I'm smiling watching behind the scenes, so thank you. And so for today, the hours in total, there was 1 EDI professionalism hour, 3.5 professionalism hours, and 1.5 substantive hours. So just a note to anyone, any of the family lawyers watching in our audience. But yeah, that about wraps it up.
Well, fantastic day, Daphne. Fantastic presentation, ladies. Michelle, you rock it always. And once again, thanks to our audience for showing up today and playing full out and participating in our polls and sending in your questions. You really made it an excellent experience.
Thank you very much, Russell, and thank you, everyone.
Thank you.
Have a good evening. Thanks, guys.
Good evening.
Bye.